Hello, hello, hello. Yes. Camera. Camera. Dear students, good morning to all of you. So today we will proceed with test number 2 discussion. I hope you all have. Dear students, good morning to all of you. So today we will proceed with test number 2 discussion. Okay, so we'll continue the test number 2 discussion. I think most of you have given the test. Okay, we'll just continue. Well, the first question in test number 2. Mukesh, how did you find this test? Test number 2. Okay. So let us quickly try to solve the questions, and in case if you have any queries, you can ask the queries. So look into the question number 1. Consider the following statement. Statement 1. A candidate contesting an election to the Rajya Sabha from a particular state should be an elector in that particular state. Now, before I proceed with this particular statement, you'll have to understand that there are certain qualifications that is given. If you look into Article 84 of the Constitution, Article 84 of the Constitution gives some qualifications for someone who wanted to contest election to the Parliament, be it Lok Sabha or Rajya Sabha. If you look into those qualifications, the qualification says that one should be a citizen of India, should be not less than 25 years of age. In case of Lok Sabha, should be not less than 30 years of age. They should take an oath in front of an authorized authority, that is none other than, in this case, in front of the officer appointed by the Election Commission of India. And apart from that, it also says any other qualification as may be determined by an Act of Parliament. Do you know which law is giving some qualification apart from what is given in the Constitution? Very good. The Representation of People Act. So, the Representation of People Act 1951 provides. So now this question is exactly, you should know the provisions of the Representation of People Act. A candidate contesting an election to Rajya Sabha from a particular state should be an elector in that particular state. Is it required that he should be an elector in that particular state? Now this provision was true till 2003. Till 2003, anybody who wanted to contest election from a particular state, he has to be an elector from that particular state. But in 2003, the Representation of People Act was amended. So now this requirement is not there. Say for example, when Mr. Manmohan Singh was elected to the Rajya Sabha, he was elected from which state? Do you know that? He was elected from Assam, although he is not a domicile or he is not resident in that particular state. But this provision was true till 2003, but subsequently now it has been changed. There is no such thing. So candidate contesting an election to Rajya Sabha from a particular state should be an elector from that particular state, not required. Come to statement number 2. A member of scheduled caste or a scheduled tribe cannot contest seats to the Lok Sabha not reserved for them. Do you know that there is a seat reserved for the scheduled caste and scheduled tribe? And what is the basis on which the seat is reserved? I'll come to the statement, but we'll see the other information also. What is the basis on which the seat is reserved? On the basis of population. On the basis of population, the seat has been reserved. And who will allocate the seats? Who will reserve the seats? Who will decide how many seats are to be allocated? That Delimitation Commission. And what is the census that is used for this particular purpose? 2001 census. 2001 census is used for this particular census. That is the latest one. So based on 2001 census, the Delimitation Commission is doing this. So it's a very clear thing that you'll have to keep in your mind, that while the seats which are reserved for the scheduled caste and scheduled tribe, only the scheduled caste and scheduled tribe can contest the election. But the scheduled caste and scheduled tribe people, they can contest in the general constituencies also. Okay, that should be very clear. Say a member of a scheduled caste or a scheduled tribe cannot contest a seat in Lok Sabha not reserved for them. That is definitely wrong. Come to statement number 3. In the Rajya Sabha, seats are reserved for the scheduled caste and scheduled tribe as per the 4th schedule of the Indian Constitution. First of all, this is wrong for 2 reasons. Now you see that in the Rajya Sabha, first of all, you see that there is no reservation of seats. Reservation of seats is where? Lok Sabha, and in the state level, Legislative Assembly. There is no reservation of seats. So definitely that is nothing which is given in the Indian Constitution, in the 4th schedule of the Constitution. This is also wrong. So how many of the statements given above are correct? What is the answer? None. Very good. Answer is option D. Mukesh got this question right? Which of the following statements are correct? So none of the statements are correct. Any confusion? But it is your responsibility. Once you do all these things, make sure that you are choosing the options also correct. So how many options are correct? None of the options are correct. So the answer is none. Or how many options are not correct? Okay, so this it should be C, can be C also. Not correct. All 3. Okay, so this option may not be this. I think there is some problem with the question. So it can be option C or option D. I give answer to both the things. Okay. So whoever has chosen option C or option D, both are right. Okay, good. We come to the next question. Yes. Now, whenever the question is asking how many, which of the means, if the suppose let us assume the question is starting which of the following statements, only 3 means only statement number 3. How many means it is only the absolute numbers, not the statement. Okay. The number of seats of Lok Sabha and in case of Legislative Assembly, they are mentioned in the Representation of People Act 1950. The delimitation orders will be consolidated and it will be represented, and it is mentioned in the schedule of the Representation of People Act 1950. In case of Panchayati Raj, it varies from law to law, state to state, based on the law that is made by the concerned state legislature. Okay, so there is no common law for that. But in case of Lok Sabha and Legislative Assembly, it is in the Representation of People Act 1950. Alright, come to next question, question number 2. So, considering your time also, we'll try to keep the discussion little brief, okay, so that your time is not getting wasted, and we'll try to maximize what we'll learn from the class. Come to question number 2. Consider the following statements in the context of the session of the parliament. Now, do you know under which article all these things are mentioned? Can anyone guess me the article? Article 85 of the Constitution, if you go, it deals with the sessions of the parliament, and it is the president who has the power to determine all those things under Article 85 of the Constitution. Come to statement number 1. The President of India cannot prorogue the House while in session. Can he prorogue the House while he in session? The President of India cannot prorogue is wrong, because he can prorogue. It is the power of the President to prorogue. Prorogue means termination of the session. He has a power to summon the session, he has a power to terminate the session also under Article 85 of the Constitution. That he can do at any time, but on the aid and advice of the Council of Ministers. So when you say that he cannot do that, then that statement is wrong. Prorogation means termination. Does anyone know what is the meaning of the word summoning? Summoning means calling upon the members to start the session. Prorogation means termination of the session. Prorogation of the session does not affect the bills pending before the Lok Sabha. Will the prorogation affect the bills which are pending in the Lok Sabha? Suppose if any bill is pending, it has gone through some stages. Will it going to affect prorogation? The termination of the session? Termination of the session will have no impact on the bills. What will have impact on the bills? Only when the dissolution of the house happens. So prorogation will not have any impact. So prorogation of the session does not have effect on the bills pending before the Lok Sabha. So this is true. Come to statement number 3. The Rajya Sabha, being a permanent house, is not subject to dissolution. Only the Lok Sabha is subject to dissolution. Is it true? Because we know that under the constitution, the Rajya Sabha term is not mentioned. And it's a permanent house. Now why do you think that the Rajya Sabha is a permanent house? No, I'm not asking the reasons. Why and how do you say it is a permanent house? Because the election to the Rajya Sabha members does not happen at the same time. Whereas the election to the Lok Sabha members happen at what point of time? At the same point in time. So what happens is that they all retire at the same time. But that is not the case with regard to the Rajya Sabha. So Rajya Sabha always continues to be a permanent house. This is true. Come to statement number 4. In general, the power of adjournment lies with the presiding officer of the house. Is that true? In general, the power of adjournment lies with the presiding officer. Can someone tell me what does it mean by the adjournment? Now you should be very clear about all these things. First is summon. So you should understanding the meaning of word summon. You should understand the meaning of word termination or prorogation. Termination or prorogation. And then you should understand the word apart from the termination, prorogation, dissolution. And then you should also be understanding the word adjournment. So what is adjournment? Temporary suspension of the business in the house during a session. An adjournment can be anything. It can be an adjournment for a lunch break. It can be an adjournment for 1 or 2 days. It can be adjournment for a week. But the session is still intact. And whatever is the temporary break within a session, that is what is called as adjournment. And who is going to adjourn the house? The presiding officer. In case of Lok Sabha, the speaker. In case of Rajya Sabha, it is the chairman. The presiding officer will do that. Okay. So in general, the power of adjournment lies with the presiding officer of the house. So this is also true. So how many of the statements? How many? Whenever the word how many is, then you'll have to see the total number of statements. What is the answer here? Only 3. That is option C is the right answer. Very good. Come to the next question. Both are different things. I'll explain what is adjournment motion. Adjournment and adjournment motion, they are two different words. They have two different meanings. Come to the next question. Question number 3. Consider the following statements about the leader of opposition. So here it is asking about the leader of opposition. Now the first statement is saying the office of the leader of opposition is not mentioned in the Constitution of India. Is it mentioned in the Constitution, the leader of opposition? Does the leader of opposition have got any statutory recognition? Is it recognized by any law? There is a leader of opposition act. There is a law that is passed by the parliament that recognizes, but the constitution does not recognize it. In fact, there is an act which was passed by the parliament in 1977. You can note down that leader of opposition act 1977. So there is a law that recognizes the leader of opposition, but it is not recognized in the constitution. So when that law was passed by the parliament, 1977, leader of opposition act 1977. So if a question comes, does a leader of opposition has got a statutory recognition? Is it true? They have a legal recognition, but it is not recognized in the constitution. So the opposition, the leader of opposition is not mentioned in the constitution. So this is true. They are entitled to the salary, allowances and other facilities equal to that of a cabinet minister. Now what this law is saying, that is the leader of opposition act 1977, it is saying that anyone who is given the status of leader of opposition, both in the Lok Sabha as well as in the Rajya Sabha, they'll have the same salary, same allowances as that of whom? As that of the cabinet minister in our country. In the last class I already explained the cabinet minister. Who is a cabinet minister? Does anyone know different classification of ministers in our country? What are the different classification of ministers? At the top we have the cabinet minister, and then Next to cabinet ministers, who are the next? Deputy minister of state, and then you have the deputy minister. Now, is this classification mentioned in the constitution? This classification is not mentioned in the constitution. It is only for the administrative convenience this has been created. There is no mention of such thing in the constitution. So this particular statement is also right. They are entitled to salary, allowances and other facilities equivalent to that of the cabinet minister. Which of the statements given above are correct? So the answer is option C. Option C is the right answer. Yes, Mukesh, quickly. Council of Ministers include all these categories. So Council of Ministers is not a separate category. We generally call them Council of Ministers. Inside the Council of Ministers, we have somebody who's with the cabinet rank, somebody Minister of State, somebody Deputy Minister. They all come under Council of Ministers. Okay. Leader of Opposition? That I am not sure. You can just verify that. I am not sure about it. You see this Leader of Opposition. This Leader of Opposition, but to be recognized as a Leader of Opposition under this Act, they should have a minimum of 1/10 of the members in the Lok Sabha. Okay, that's also very important. And the same is there in the Rajya Sabha as well. Alright, so come to the next question. Question number 4. Consider the following statements in the context of the general budget. So do you know that the word budget is not mentioned in the constitution? What is the word that is mentioned in the constitution? Annual financial statement. And whose responsibility is to lay down this annual financial statement? Finance Minister, please raise your hand. Okay, Finance Minister, Economic Advisor. Any option from your side? Chief Economic Advisor. Now, as per the Constitution of India, it is a responsibility of the President of India. Anything apart from that is wrong. So who has to lay down the annual financial statement? In the houses of the parliament, it is the President. That is what the Constitution says. But try to understand that the President is the head of the Union Executive. So the President can do it. On his behalf, his subordinates can also do it. So on behalf of the President, who lays down the annual financial statement? The Finance Minister, who is a subordinate of the President. Okay. But as if the question comes as per the Constitution of India, the Finance Minister will lay down the thing. As per the Constitution, who has to lay down the annual financial? The President of India. That is what is mentioned in Article 102. Okay, but the term budget is not mentioned in the Constitution. So the term budget is explicitly mentioned in the Constitution. This particular statement is wrong. Now, what happened in the year 2017? 2017, I think Mr. Arun Jaitley was the Finance Minister of India. Late Arun Jaitley, Mr. Arun Jaitley. So he is no more. So when he was a Finance Minister of India, he brought in a reform. And what he has done is, he has merged the railway budget and the general budget. So till 2017, there were two different budgets in our country. A separate budget for railway ministry with related to the railway expenditure. And then a separate budget for the other areas apart from the railway. But today we have only one budget. And when that was merged? In 2017. Okay, this is a very factual information. Try to remember. There are pros and cons, but that is beyond the scope of the preliminary examination. So till 2017, the government of India had two budgets, namely the railway budget and the general budget. That statement is true. Come to statement number 3. The expenditure charged upon the consolidated fund of India requires the approval of the parliament in the form of vote on demand for grants. So there are many things that you have to understand here. Okay. So first tell me, what are the other types of funds that you know in the Constitution apart from the consolidated fund of India? Very good. There are three types of funds which is there in the Constitution. One is the consolidated fund, and then you have the contingency fund, and then the public accounts of India, which is a major fund for the government. Each and every single penny for the expenditure of the government is taken out from where? From the consolidated fund of India. And what the Constitution says, that even to take out a single rupee from the consolidated fund of India, it requires approval of whom? It requires the approval of the parliament. Is it possible to take out money without the approval of the parliament? And how does the parliament give this approval? We know that the parliament has to give the approval in the form of an appropriation bill. During the budgetary process, can you tell me the different stages of the budgetary process? First is the introduction of the budget, general discussion, and then refer to the various committees, DRSEs, and then there is a stage which is called as demand, vote on demand for grant. And then after the vote on demand for grant stage, there is a stage which is called as an appropriation bill. And this appropriation bill is a stage where the parliament is giving the approval for the government to take out money. So without this appropriation bill, not even a single penny can be taken out. Okay, so try to make a note of all these things. Now, the most important thing is the expenditure charged upon the Consolidated Fund of India requires the approval in the form of vote on demand for grant. So this is the fourth stage that I discussed, vote on demand for grant stage. Now, do you know that in the budget, suppose let us assume this is budget. So what is budget in general? Budget is a statement of estimated receipts and estimated expenditure. So budget contains majorly these two things. It may estimated receipts. Receipts means what? Receipts means income for the government, and expenditure is the expenditure part. And if you look into Article 112 of the Constitution, it says that the expenditure has to be further divided into two types of expenditure. Expenditure made upon the Consolidated Fund, expenditure charged upon the Consolidated Fund. Now, where do we know that what these charge expenditures are? Is there something in the Constitution? Does the Constitution mention what is a charge expenditure? Or at least some examples of charge expenditure? Where is that information? What you are saying is true. That the salary of the President, his office expenditure, salary of the Comptroller and Auditor General, the judges of Supreme Court, pensions of judges of High Court. So please go and look into Article 112 of the Constitution. Very, very important. Many times question has just been asked as to, they have given a list of expenditure and we have to identify among them what are charge expenditure. Apart from whatever is a charge expenditure, the other expenditures are made expenditure. They are mutually exclusive. So charge expenditures will be in this column, and then the other expenditures are the made expenditures. Now what exactly is the difference between charge expenditure and the made expenditure? Well, the made expenditure is discussed and put to vote in this particular stage, that is vote on demand for grant stage. But whereas charge expenditure can be discussed but cannot be put to vote. It has to be passed without even voting. Okay, so this is a very important expenditure. That's why it has to be passed without even putting to vote, but it can be discussed in the parliament. Okay, and now a related question is, can the cut motion be introduced at this particular stage? Can the cut motions be introduced on the charge expenditures? On the made expenditure? Okay, so this is also you should understand, because it is put to vote, here they can introduce a cut motion on the made expenditure but not on the charge expenditure. Now come to this particular statement. The expenditure charged upon the Consolidated Fund of India requires approval of the Parliament in the form of vote on demand for grant. Is it true? This particular statement is wrong. Not on the charge expenditure but on the made expenditure. So how many of the statements given above are correct? Only one. Only this particular statement is correct. Only one. Okay. Don't look for the number of the statement number. How many of the statement means absolutely how many statements. So how many of you got this right? Good. Come to the next question. Online students, please following. And if you have any queries, you can put it in the comment box. Come to the next question. Vinay, one suggestion, one request from my side. Do not ask questions which is irrelevant to the question, because it is going to unnecessarily affect. You may have some doubt, and if you have the doubt, you ask me after the class is over, after the break. If any question related to the question is there, you can ask the doubt. Random questions is going to disturb. Online students are also there, and they cannot wait. It is going to disturb them. They may not be aware what is happening. So any relevant question to this doubt to this particular question, you can ask me. Otherwise, during the break, you can come and ask me whatever is your doubt. Random questions are not entertained. Okay, come to the next question. Consider the following statements. Statement 1. The Speaker of Lok Sabha is elected by an effective majority among effective majority of the members of the House. Now tell me, is it true or is it wrong? What is the majority by which the Speaker is elected? Simple majority, special majority, effective majority, which majority? So many of you think it is wrong. So as per the Constitution of India, the Speaker is elected by simple majority. He is elected by simple majority, but he can be removed by effective majority. So do not make a mistake, okay? So it is only simple majority, not effective majority. I hope you understand as to what is a simple majority. Elected by simple majority, removed by effective majority. Come to statement number 2. The speaker has the right to vote in the houses only to break the tie. Is it true? Or in other words, this question is trying to understand your knowledge, try to assess your knowledge, that do the speaker have the right to vote in the first instance? Can you vote in the first instance? The speaker cannot do that because the speaker is bound to work as a neutral person when he is a presiding officer. Although the speaker is really a neutral person, or in other words, this you cannot say, or in other words, let me reframe the question in this way. Does a speaker has to resign from his party in our country after he is elected as a speaker? So he has to resign, or he can continue to be a member of that party. Suppose, let us assume today Mr. Om Birla, who is a speaker, who is elected as a speaker, is he continuing to be a member of BJP party? Yes or no? Can he continue to be a member of BJP party? He can continue. There is no restriction in the constitution. In UK, there is a parliamentary convention. That it is a conventional practice. In UK, that conventional practice exists, but in India, there is no such conventional practice, nor there is a constitutional requirement. All right. So this is basically what you'll have to understand. So now come to this particular statement. The speaker has the right to vote in the houses only to break the tie. So this provision is there in the constitution just to make sure that the speaker does not act in a partial manner. In order to make him impartial, whenever there is a tie, that means when there is equality of votes for and against, to break the tie, the speaker can exercise his vote. And that is also technically what is called as casting of vote. Have you heard this word, casting of vote? That means he is voting to break the tie. So this is true. Come to the next statement. As per the Constitution of India, only a member of Lok Sabha can get elected to the House of, only a member of Lok Sabha can get elected to the House as a speaker. Is it true? Can a member of Rajya Sabha get elected? Can anyone who is not a member of Lok Sabha, can he get elected as a speaker? This is a constitutional requirement. So keep this in your mind. The only constitutional requirement is that anybody who is willing to contest election to become speaker should be what? Should be a member of that particular house. Without being a member of that particular house, he or she cannot get elected. Okay. So this particular statement is what? As per the Constitution of India, only a member of Lok Sabha can get elected to the house as a speaker. This is true. Okay. So see what is the right answer here. Which of the statements given above are correct? It's option 2 and 3. Very good. 2 and 3 is the right answer. Any doubt? Yes, it is mentioned here. It's a member of Lok Sabha, it is mentioned here. Okay. So come to the next question. Let us move to question number 6. See, in this way, we will solve every question. We will have a conceptual understanding on all the areas. Okay. So if you have any doubts, you can make a note of it. Whatever is relevant to the question, you can ask me. Other doubts are also entertained, but not in between these questions. Okay, during the break or after the class, you can ask the questions. Come to question number 6. According to the Constitution of India, it is the duty of the President to cause to lay down before the Parliament which of the following. That means constitutionally, there are certain mandate to the President that he has to place certain reports in the Parliament. So among these things, what are the reports that the President will place in front of the Parliament? That's the question. Statement 1, the recommendation of the Union Finance Commission. Which article in the Constitution is related to the Union Finance Commission? Article 280, very good. Article 280. Does the Constitution specify the composition of the Finance Commission? Yes or no? The last class we have discussed this. It says there shall be a chairperson plus 4 members. The composition is given in the Constitution. Does it specify the qualification of the members in the Constitution? The qualification is not mentioned. The Constitution only says the Parliament can make a law and by that law they can determine the qualification. Does the Constitution provides the functions of the Finance Commission? What the Finance Commission is supposed to do? The terms of reference is not mentioned, but certain functions of the Finance Commissions are mentioned in the Constitution itself. There are 4 functions. You can just go and look into it. It is mentioned. And apart from that, in the functions, if you see, one more point is given. Any other functions as may be determined by the President of India. And by that power, the President determines the terms of reference. Okay, the terms of reference is not mentioned. Alright, so these are all the additional information. And if you read Article 280 of the Constitution, you will also further understand that the President has to submit the report of the Union Finance Commission in the Parliament. So is it the responsibility of the President? Of course, it is the responsibility of the president. The president has to do that. So this is true. A report of the, I will come to statement number 2, but before that come to statement number 3. The report of the Comptroller and Auditor General, the report of the CAG, the Comptroller and Auditor General. Now, what is the article that establishes the CAG? Article 148 of the Constitution. Do you know what is the function of this CAG under Article 148? What the CAG has to do? The CAG has to audit the accounts of the government. When I say accounts of the government, both the revenue accounts as well as the expenditure accounts. So every year the accounts has to be consolidated, and finally the CAG will audit these accounts. And you know what the CAG does after he audits the account? To whom he will submit the report? The CAG has to submit the report to the president. And what the president will in turn do? The president will submit the report in turn to the parliament. And in the parliament, there is a committee which is called as Public Accounts Committee. And that Public Accounts Committee, what it is going to do? It is going to scrutinize the report of the CAG. The Public Accounts Committee is going to scrutinize the report of the CAG with regard to the revenue and the expenditure part. There is also one more committee in the parliament which is also scrutinize the report of the CAG. What is that other committee? Not the Estimates Committee. The Estimates Committee has no role with regard to the CAG. There is one more committee. How many of you know there are 3 financial committees in the parliament? Can anyone recollect the 3 financial committees? One is the Public Accounts Committee. Second is the Estimates Committee. Third, there is a committee which is called as the Committee on Public Sector Undertaking. This Committee on Public Sector Undertaking will also scrutinize the report of the CAG, but with regard to the audit that is done by the CAG on the public sector undertaking. So whatever is the government expenditure, that will go to the Public Accounts Committee. Whatever is the expenditure and the revenue of the public sector undertaking, that will be scrutinized by Committee on Public Sector Undertaking. Alright, so now coming back to the question. The report of the Comptroller and Auditor General, is it submitted in the parliament? Of course it is submitted in the parliament. The president has to do that. And come to statement number 4, the report of National Commission for Scheduled Caste and National Commission for Scheduled Caste. It is same for National Commission for Scheduled Tribe also. It is same for today National Commission for Backward Classes also. In all the 3 cases, the report will be submitted by the commission to the president. The president will submit the report to the parliament. So all these things are true. Can someone tell me the article for National Commission for Scheduled Caste, Scheduled Tribe, Backward Classes, if you remember? Online students, you can also put it in the comment box. Article 338 in case of National Commission for Scheduled Caste, 338A in case of Scheduled Tribe, and 338B in case of Backward Classes. And in all the cases, the president is going to submit the report. These are all true, definitely. Article 338A. So now come to statement number 2, the report of the Public Accounts Committee. Now once the Public Accounts Committee scrutinizes something, whatever is the report of the Public Accounts Committee, it will go only to the parliament, not to the president. The Public Accounts Committee is a subset of the larger parliament. And whatever is the report of the Public Accounts Committee, they do not submit it to the president. It is scrutinized by whom? It is scrutinized by the parliament as a large body. So definitely this is not true. So what is the answer in this particular case? Choose the correct answer from the codes given below. What is the answer? C is the right answer. Very good. So try to make a note of whatever we discuss. It will be really useful for you. Come to the next question. Question number 7. Question number 7. So consider the following statements. Shall I move to the next question? Is it all right? Okay. So come to the first statement. In India, the same person cannot be appointed as governor for 2 or more states at the same time. Is that true or is it false? False. Now, in fact, do you know that it was true as per the original constitution? In the original constitution, it was true, but today it is not true. Your answer is right when you say this particular statement. When you say that cannot, means he can be appointed. He can be appointed. But do you know when this change has happened in the constitution? Very good. 7th Constitutional Amendment Act in 1956. What was the significance of the 7th Constitutional Amendment Act? 1956. If you can look into the history. This is the time when the reorganization has happened. Have you heard about the State Reorganization Act 1956? During the State Reorganization Act, there were many states that was created. And suddenly the government was not having the governors to appoint to all these states. So a corresponding change was made in the constitution that the same person can be appointed as a governor for 2 or more states. Now see, if you remember and if you can recollect and if you can connect all those things, you don't have to remember them. So automatically it will be there in your mind and you can easily answer them. So definitely when you say in India, the same person cannot be appointed, this is wrong. Initially it was true, but not today. Changed by the 7th Constitutional Amendment Act in 1956. Okay. Come to statement number 2. The judges of the High Court of the states in India are appointed by the governor of the state, just as the judges of the Supreme Court are appointed by the president. Is that true? Who appoints the judges of both the Supreme Court and the High Court? It is the president who appoints. In both the cases, he is the appointing authority. Who is the removal authority in both the cases? Is it the president or the parliament? How many of you think it is the parliament and how many of you think it is president? Please raise your hand whoever thinks president is the removal authority. Whoever thinks it's a parliament. Okay, now try to understand this as a thumb rule. Now, if the president is the appointing authority, no authority below the authority of the president can remove them. That's a general rule in the constitution. The president is appointing, no subordinate authority can remove them. Okay. If the president is appointing, only the president or some other authority above president can remove them. So in this case, who will be the removal authority? The president. The president itself can remove the judges of the Supreme Court and High Court, but the president cannot do it on his own, but based on the motion that is passed by the parliament. The parliament has to pass a motion for their removal and then subsequently only the president can remove them. Okay. If a question comes who is the removal authority, it is the president, but anyways, the appointing authority is not the governor in case of the judges of the High Court. Come to statement number 3. No procedure has been laid down in the Constitution of India for the removal of the governor from his or her post. Is it true? There is no specific process that is laid down. The only thing that is given in the Constitution is that the governor can be removed or governor holds office during the pleasure of the president. What is the meaning of the word pleasure of the president? There is no security of tenure. That means what? That means whenever the president is not happy, the president can remove him. And that's not a discretionary power of the president, but the president does that based on the aid and advice of whom? Council of Ministers. But the statement is factually right. Okay, so this particular statement is true. In the case of an union territory having legislative setup, the chief minister is appointed by the lieutenant governor on the basis of the majority support. Is it true or false? How many of you think it is incorrect? In case of the union territory having legislative setup, what are the union territories that have got legislative setup today? National Capital Territory of Delhi, very good. Puducherry, Jammu and Kashmir might have it. There's a provision as per the law, they might have it. So these are the 3 union territories. The chief minister is appointed by the lieutenant governor. The chief minister is not to be appointed by the lieutenant governor, but by the president of India. The president has to appoint them. So this is also wrong. Okay, so which of the statements given above are incorrect? So let us try to understand the incorrect statement. So if you see how many of the statements, not which, how many of the statements. So how many statements are incorrect? Only 3. That is 3 statements are incorrect. Okay. That is why for the judges of the Supreme Court and High Court, the word pleasure of the president is not mentioned. It is not that the president can remove him at his whims and fancies. No, not possible. In case of governor, he can do that, but not in case of the judges. He can directly, no, nothing, not even a single information. For the judges, there's a lot of procedure it has to happen. That is why it is not called as. In fact, how many judges of the Supreme Court and High Court has been removed till this point of time? Not even a single judge of a High Court has been removed or a judge of a Supreme Court has been removed till this point of time. Okay, so that you'll have to understand. So that much amount of security has been given to them. That is different thing, but they have not been removed. Come to the next question. Question number 8. Which of the following statement is correct about the joint sitting of the parliament? So how many of you heard about this joint sitting? Can someone tell me which article is relevant to joint sitting? Article? Under what circumstances there is a need for this joint sitting? There is a term which is called as deadlock. Whenever there arises a deadlock, then the president can convene a joint sitting. Is it a discretionary power of the president to convene this joint sitting? Can he do it on his own? He does that based on the aid and advice of the Council of Ministers. So the crucial word here is what is called as deadlock. What is important is you have to understand the word deadlock. So can someone tell me what are the circumstances under which the deadlock can arise? Deadlock means whenever, let us assume, a bill is introduced, and if there is any disagreement between both the houses, that is basically what we call as deadlock. So can you tell me what are the circumstances you think there can be deadlock? Let us assume a bill is introduced in the Lok Sabha and it has been passed to Rajya Sabha. The Rajya Sabha does not take any action for a period of 6 months. How many months? 6 months they do not act on that particular bill. Then there is a deadlock. A bill has been passed from Lok Sabha to Rajya Sabha, where Rajya Sabha rejects that bill. Then there is a deadlock. One house is proposing, other house is rejecting it. Lok Sabha is passing the bill. Rajya Sabha is making some amendments and send it back to the Lok Sabha, where Lok Sabha is not agreeing to that particular amendments. In that case also there is a deadlock. So these are the three areas as per the constitution that deadlock can arise. And the deadlock can arise only in case of an ordinary bill. A deadlock can arise in case of financial bill type 2. A deadlock can arise in case of, not in case of money bill. It cannot happen in case of money bill. It cannot happen in case of a constitutional amendment bill. But in case of an ordinary bill, in case of financial bill type 1, it can, financial bill type 2, it can happen. Okay. So whenever there is a deadlock, who can convene a joint sitting? The word convene means who can summon the joint sitting, who can convene the joint sitting? Only the president under the constitution, under article 108. And that too, only the president can convene the joint sitting. Convening means calling upon for the joint sitting. And there is a word which is called as presiding the joint sitting. Who will preside over the joint sitting? That is done by the speaker, Lok Sabha. Okay. So try to differentiate between these two words. Alright. Now come to this thing. So whenever there is a deadlock, a joint sitting can be convened. And once a joint sitting is convened, who can preside over the joint sitting? The speaker will preside. And in the absence of the speaker, who will preside? Deputy speaker. In the absence of both the speaker and the deputy speaker, it is done by the deputy chairman of the Rajya Sabha. The chairman Rajya Sabha cannot do this. It is done by the deputy chairman. Okay, so this is basically you have to understand. Okay, the idea of this joint sitting is to resolve the deadlock because both houses are having disagreement. So in front of members of both the houses, this proposal is put to vote. So as per the Constitution of India, what is the majority that is required in case of a joint sitting? What is the majority that is required? Very, very important. Has been asked in the prelims many times. Again, they can ask you. What is the majority that is required? Simple majority, special majority, effective majority, absolute majority. It is simple majority. Try to keep that in your mind. Okay, it's a simple majority. Alright, now come to the questions. Let us try to now see the thing. So try to remember all those things. So whenever you take a topic, you should know everything from that particular topic. So come to the question statement. The provisions of joint sitting apply to ordinary bill and constitutional amendment bills and not to money bills. So is it true? The provision of joint sitting apply to ordinary bills and constitutional amendment bill but not to many bill. It does not apply to a constitutional amendment bill. That is wrong. A joint sitting is governed by the rules of procedure of Lok Sabha and Rajya Sabha. Is it true? The joint sitting is governed by the rules of procedure of Lok Sabha and Rajya Sabha. I'll just come back to that particular statement if you have any doubt. The quorum to constitute a joint sitting is 1/10 of the total members of the Lok Sabha. There is no quorum that is specified in case of this. So this is also wrong. You cannot be the answer. The speaker and the deputy speaker are absent from a joint sitting. The deputy chairman of Rajya Sabha will preside. Is it true? So this statement definitely true, you know. Now this statement is not true because of the fact there is no rules for the joint sitting. It is specified in the constitution. The rules can be made by the president. As per the constitution, who will make the rules for the joint sitting? The president has the power to do that. It is not followed as in the Lok Sabha, Rajya Sabha. Okay, so this particular statement is also wrong. So what is the right answer here? Option D is the right answer. So any question from joint sitting, nobody should get it right. Okay, so please try to understand all these things. Come to the next question. Consider the following statements. Any doubt from the last question? Clear? Okay, write down. Come to the next question. President. The president can make the rules. Come to question number 9. Chairman appoints from among the members a panel of vice chairpersons in Rajya Sabha. Is that true? Have you ever heard of this concept which is called as the channel of vice chairperson? And who are this panel of vice chairperson? How many members are there in the Rajya Sabha? How many members are members, total members? 245 members. In the Rajya Sabha overall, if you see total membership presently is 245. Now out of this 245 members, they should have a presiding officer. Who is the presiding officer? Is the presiding officer elected from among the members of the house? Who is the presiding officer? The vice president, and the vice president becomes a presiding officer in ex officio capacity. He is not a member of that house. Whoever is the vice president automatically becomes a presiding officer. Now the point is, what if the presiding officer is absent on a given day? It may not be possible that the vice president every day when there is a session he can come and he can preside over the house. He may be feeling sick. He may have to do some other personal work, so he may have to take leave also. So during the absence of the presiding officer, that is in this case the vice president, the chairman Rajya Sabha, who will preside over the house? So in order to do with this particular problem, there is a provision that the chairman can appoint a panel of vice chairperson. So a panel of vice chairperson can be appointed, and the idea of having this panel of vice chairperson is that anyone among the panel of vice chairperson, they can preside over the house. So who is going to appoint this panel of vice chairperson? That vice president, that is the chairman himself. So the number is not mentioned in the constitution, but he can appoint. And the concept is, whenever his chairman is absent, only during the absent, that is very important. Whenever he is absent, and there is another term which is called as vacancy. There is a difference between these two words. If you do not understand, then you will make a mistake. Absence is something different, vacancy is something different. So can someone tell me what is the difference between absence and vacancy? Absence means somebody is there, but he is absent from the office. Vacancy means nobody is there. So in case of absence, anyone among the panel of vice chairperson, what they can do, they can preside over the Rajya Sabha. So this is what is the purpose. So in that case, what happens in case of vacancy? Suppose let us assume the vice president suddenly dies, and then there is a vacancy to the office. So when there is a vacancy, the president will appoint someone temporarily till the time the new vice president is elected. The panel of vice chairpersons cannot do that. So they can do only in case of what? Only in case of absence. Okay, with that, come to the statement. Please do not talk. Excuse me. Please do not talk. Okay, don't disturb me in the class. The chairman appoints from among the members a panel of vice chairpersons in the Lok Sabha. Is that true? This particular statement is perfectly true. Come to statement number 2. Any one of the members of the panel of vice chairperson can preside over the house in the case of absence or vacancy of chairman to perform his or her duties. Is it true? It happens only in case of when? Only in case of absence, not in case of vacancy. So this is wrong. So now this particular statement itself is wrong. So what is the answer here? Which of the statements are correct? It is one only. Why? Now in case of absence they can preside. In case of vacancy it is not possible. President will appoint one person as the presiding officer. In case of absence, anyone among these members can preside. Why, if you ask me, this is the provision in the constitution. This is how the constitution has been decided by the Constituent Assembly. During absence, suppose let us assume the vice president is not able to preside over the house on a particular day. That means there is someone who is the chairman, but on a given day he is absent. When he is absent, some of the members, suppose let us assume 10 members are there. Any one person will preside instead of the vice president. Alright? But suppose let us assume the vice president has died and there is a vacancy. In that case, if the house is to be presided, the president will appoint someone temporarily as a presiding officer. No, outside the panel also. There is no restriction. But absence only from any of these members they can preside. The president can appoint any member. From this also, outside this also, there is no restriction. But absence only these members. Okay, come to the next question. We are into which question? Question number 10. Next question. Come to the next question. So consider the following statements regarding exit polls. Anybody from the state of Rajasthan? Recently, I think the elections held in Rajasthan. And anybody from the state of Rajasthan? And there's a lot of news related to exit poll. What do you mean by this exit poll? Who does this exit poll? Will the government do this exit poll? Definitely it is not done by the government. Usually done by the media agencies and other private organizations, civil societies, NGOs, normally the media organizations. They do this exit poll. So what is the purpose of this exit poll? If you see, the purpose of this exit poll is an opinion which is taken by these agencies. So whoever has cast their vote, when they come out of the polling booth, they want to take the opinion. And through the opinion, they will try to assess as to who will be the winner of the election. What will be the outcome of this election? That's basically, they try to predict the outcome of the election even before the Election Commission of India declares the result. That's basically what is called as the exit poll. But today, the law in our country has put some restrictions on this exit poll. And do you know which law has put some restrictions? So the idea is it should be a free and fair election. Because why this restriction is there? The elections is not happening on the same day throughout the country. Even within the state, the election may not happen in the same day, because you know that the election happens in multiple phases. Right? The election happens in multiple phases, right? So if the people, some opinion, suppose let us assume in a particular area, let us assume some opinion, this exit poll is happening. And if this result is published, and then it could influence the other voters also who are going to vote in the different phases of the election. And then it can affect the free and fair election. So in order to prevent that, there is today a restriction as per the Representation of People Act. And under which Act? Representation of People Act 1951. So this much is more than sufficient. To be very specific, it is under section 126. But the section is not important. But try to remember, under the Representation of People Act, the Election Commission of India can regulate this exit poll also. They can conduct exit poll, but they cannot declare the results. So till what point of time they cannot declare the results? Till the time the election result is announced by the Election Commission of India, or at least till the conclusion of the elections in all the phases. So till the time the conclusion of election is there, they cannot declare the exit poll results. They can conduct it. No, how they can publish the result before the election is being started? Exit poll is only after the election they can take the opinion. And they should not publish the result till the election is completed in all the phases. Okay, so this is the restriction that they can impose. What you are confusing is with the silence period. Silence period before 48 hours before the election begins is that they should not engage in any form of campaigning. That's a different thing. Exit poll is something different. Okay, so now come to the information answer today. So these are all some things as an aspirant you should have closely watch. Whatever is in the current affairs which is related to a subject, there's a possibility that they can ask you. Look into the statement number 1. Exit poll is an opinion survey regarding how the electors have performed with regard to the identification of political party or a candidate in an election. Is it true? It's an opinion that they take, how the electors have performed. How the electors means, who are electors? Those who voted. So how they have performed, to whom they have voted. So they try to know that. Okay. So this is basically on a voluntary basis. If they want to give the information, they can give it. So this is definitely true. Come to statement number 2. No person shall conduct any exit poll or publish its result during the election time as notified by the Election Commission. Is that true? This is true. Okay. So till the time the result is published, till the time the election is concluded in all the phases, they cannot do that. Okay. So this is also true. Which of the statements given above are correct? Both 1 and 2. Very good. Option C is the right answer. Representation of People Act is legally enforceable. So if they violate the Representation of People Act, action can be taken against by the Election Commission. Come to question number 11. Any doubt in this area? Alright, so come to question number 11. 9, what is the doubt in question number 9? Read it quickly. Done? Come to question number 11. So look, have a look into the question number 11. Come to question number 11. Okay, so this is again a very, very important area. Every year there is a question, either from the theme Constitutional Amendment Bill, either from the theme Money Bill, or a comparison between the Finance Bill and the Money Bills. Okay, very, very important area. So with reference to the Finance Bill and the Money Bill in the Indian Parliament, consider the following statements. Statement 1. When the Lok Sabha transmits financial bills to the Rajya Sabha, it can amend or reject it. Okay, so first of all, you'll have to understand when it comes to the finance bill. So how many of you are aware of the different types of bills? First of all, I would say there are different types of bills. I would say if you classify the different types of bills, I'll put it right from the ordinary bill. So this is very, very important. You should know the procedure for all these types of bills, how these bills get enacted in the parliament. You have ordinary bill, and then you have money bill, and then you have got financial bill. Okay, alright, so you can classify this further into 1 and 2, and then you have got constitutional amendment bill. Okay, of all these different types of bills, try to have an understanding of all these types of bills: ordinary bill, money bill, financial bill type 1, type 2, constitutional amendment bills. Now there are certain types of bills, try to have an understanding. There are certain types of bills among these things where the Lok Sabha and Rajya Sabha has got equal powers. But there are certain types of bills where there is no equal powers. So where there is equal power to both Lok Sabha and Rajya Sabha, in case of ordinary bill equal power, in case of constitutional amendment bill equal power, in case of money bill there is no equal power, in case of financial bill 1 also there is no equal power to some extent, but there is equal power in certain extent. In case of financial bill type 2, they have got equal powers. Very, very important. You have to understand all those things. Now with this, come to statement 1. When the Lok Sabha transmits the finance bill to the Rajya Sabha, it can amend or it can reject the bill. Can they reject or amend the bill in case of a financial bill? Now try to open your ears and try to understand this. If you read your book, you may not understand it. So try to listen to this carefully. Now in case of financial bill type 1, what you will have to understand is, in case of financial bill type 1, it is similar to that of the money bill in certain respects. What is the similarity? What is the procedure governing the money bill in the constitution? Where the money bill can be introduced? Can it be introduced in both the houses? The money bill can be introduced where? Only in the Lok Sabha. And the money bill can be introduced only in the Lok Sabha. Not only it can be introduced only in the Lok Sabha, it can be introduced only with the prior recommendation of the President. These two things you'll have to keep in your mind. So in case of a money bill, it can be introduced in the Lok Sabha and it can be introduced only with the prior recommendation of the President. Okay, that's what is exactly important. Now similarly, in case of a financial bill type 1, these two conditions will apply. It can be introduced only in the Lok Sabha, it can be introduced only with the prior recommendation of the President. But in all other respects, the financial bill type 1 is similar to that of an ordinary bill. In all other respects, it is similar to that of an ordinary bill. So in case of an ordinary bill, just try to understand, when a bill is passed from Lok Sabha to Rajya Sabha, can the Rajya Sabha reject the bill? In case of an ordinary bill. So similarly, in case of a financial bill type 1, once the bill is introduced in the Lok Sabha with a prior recommendation, after it is passed from Lok Sabha to Rajya Sabha, can the Rajya Sabha reject the bill? It can reject the bill. Okay. So it is similar to that of the ordinary bill in all other respects. Only the introduction is similar to that of a money bill. Now come to financial bill type 2. A financial bill type 2 is similar to that of the ordinary bill in most of the respects. It can be introduced in either houses, and once it is passed from Lok Sabha to Rajya Sabha, it can be rejected or it can be amended. Okay. So now come to the question with this. When the Lok Sabha transmits a financial bill to the Rajya Sabha, it can amend or reject the bill. Is it true or it is wrong? This particular statement, based on the explanation. Once the bill is passed from Lok Sabha to Rajya Sabha, and if the bill is a financial bill, can the Rajya Sabha reject it? Can the Rajya Sabha amend it? So both the things can be done. Both in case of financial bill type 1 and type 2. So okay, so this is very much true. Come to statement number 2. When the Lok Sabha transmits a money bill to Rajya Sabha, it cannot amend or reject the bill. It can only make recommendations. Is it true? This is in regard to the money bill. Now try to have an understanding with regard to money bill. Few things. First of all, I said money bill where it can be introduced. And it requires prior recommendation of whom? President. Once it is passed from Lok Sabha to Rajya Sabha, what is the power of the Rajya Sabha? The Rajya Sabha cannot reject the bill. The Rajya Sabha cannot amend the bill, but it can make recommendations. And that too within 14 days. Or it can just sit on top of that particular bill. When I say sit on top of that particular bill, they are not sitting on that particular bill, but they are not taking any action. And how long they can delay without taking any action? 14 days. So the maximum power is that they can delay the bill by 14 days. When the Lok Sabha transmits the money bill to the Rajya Sabha, it cannot amend or reject the bill, it can only make recommendation. Is it true? This is true. Statement 1 is true. Come to statement number 3. In case of any disagreement between the Lok Sabha and Rajya Sabha, there is no joint sitting in case of a money bill. There is no possibility of joint sitting because there is no deadlock in the first place. There cannot deadlock because the Rajya Sabha has not equal powers with regard to Lok Sabha. But a joint sitting becomes necessary in case of a finance bill if the bill is to proceed to the next stage. Is it true? If they have to proceed to the next stage, a joint sitting is necessary. And a joint sitting can be convened by the President, both in case of financial bill type 1 and type 2. But in which cases a joint sitting is not possible under the Constitution? Constitutional Amendment Bill and Money Bill. Just put this into your mind. There is no possibility for joint sitting in case of the Money Bill and the Constitutional Amendment Bill. Now, why it is not possible in case of a Constitutional Amendment Bill? In case of Constitutional Amendment Bill, the Constitution is saying it has to be separately passed by both the houses of the Parliament by special majority. And whereas in case of a money bill, it is not possible because the Rajya Sabha has no equal powers. So there is no joint sitting. So try each and everything that I am discussing can be asked as a question. So try to put it in your mind. In case of a constitutional amendment bill, the bill has to be passed with special majority separately in both the houses. So when I say separately, that itself is implicit that there is no possibility of joint sitting. It has to be passed separately in both the houses of the Parliament with special majority. I'll explain that. I'll explain that. Okay, so what is the answer in this case right now? So this is true. So this is also true. This is also true. What is the answer? All the three. Option C is the right answer. How many of you got this question right? Okay, got it right? Got it right, Vinay? Okay, we are not part of this series. Okay. What is the answer? Okay, there should be some mistake, I think, but the statements are right. Okay, so come to the next thing. Come to the next thing. Consider the following statements in the context of the Constitutional Amendment Bill. So consider the following statements in the context of Constitutional Amendment Bill. So where a Constitutional Amendment Bill can be introduced? Can it be introduced in either houses? Can it be introduced by a member of Parliament? Or it can be any member of Parliament, or it can be introduced only by a minister? Any member of Parliament. It can be a minister or it can be a private member. Doesn't matter. It can be introduced. Does it require a prior recommendation of the President? There is no need for any prior recommendation, and it can be introduced in both the houses. It can be introduced by any member of Parliament. In whichever house it is passed, it has to be passed with special majority. Then it goes to the next house. There also it is passed with the special majority. Then it goes to the President for his assent. When the bill is submitted for the President for his assent, what is the requirement? He has to give the assent. That is mandatory. The President has to give the assent. And is it this provision is from the very beginning? Is it there in the original Constitution? It was changed in the 24th Constitutional Amendment Act. 24th Constitutional Amendment Act 1971 has made it mandatory. Now try to read and try to attend the class, revise the class after the class is over. I'll make sure that 90% of your questions in polity will get it right. Suppose let us assume there are 20 questions, I can make sure that you will get 18 questions right. I can guarantee you that. 100% I cannot guarantee, and nobody can guarantee because we do not know what surprise UPSC is bringing. But as you attend my 2 discussions, there is a live discussion for the previous thing also. Solve that paper, attend the live discussion. Solve this paper, attend the live discussion. And then there is one full test on polity. I'll make sure that your entire polity is covered. But again, I cannot teach everything in polity. This is just a revision class. So if you have already done your job, then it will be easy for you. Okay, so now with this come to the question. It can be introduced in either house of the Parliament. Is it true? True. It can be introduced by a minister only. Is it true? No, definitely this is wrong. Come to statement number 3. If it is duly passed by both the houses of the Parliament, the President must give the assent. Is it true? Under which constitutional amendment this was made? Try to remember this. They can ask this factual thing also because UPSC sometimes asks some of the important constitutional amendments as well. Okay, so wherever I am putting the constitutional amendment, try to remember them as well. I hope online students, you are following it up. Alright, in case of any questions, you can just put it in the comment box. Which of the statements given above are correct? What is the answer here? The answer is option B, that is 1 and 3 only. Alright? Yes. What Mukesh? Which one? Government bill, what does it mean by a government bill? There is no mention of such thing in the constitution. When you say when a bill is introduced by a minister, then it is called as a government bill. But here we have said who can introduce a bill? It can be introduced by a minister or by a private member. It depends upon who is introducing it. That's what I am trying to say. So it cannot be called, when the government is introducing, it's a government bill. If a private member is introducing, it can solve that a private member has introduced a constitutional amendment bill. So depending upon who is introducing it, you call that a private member bill, or it is introduced by the government, a minister, a government bill. But it is related to what? It is related to amendment of the constitution. But try to understand, a private member can introduce, but it will go no forward, because you need a lot of majority, which normally the government has. Okay, so normally it is done by the ministers. Those things are not very important. Procedural things that you are talking about, they may not even come in the examination. Come to the next statement. See, UPSC focus on what is there in the constitution. UPSC doesn't look for some experts who knows everything. UPSC knows those things which you are aware of the basics in the constitution. Later when you perform certain jobs, you can develop expertise, but UPSC cannot expect expertise from a student who is appearing for the examination each and every area, which will take a lot of time. Come to question number 13. Consider the following statements about the pro tem speaker. How many have heard about the pro tem speaker? I am sure that you all would have heard about the pro tem speaker. Now what exactly is this pro tem speaker? For which you have to understand how the election happens. Now, do you know which Lok Sabha is continuing right now? 17th Lok Sabha. Soon the 18th Lok Sabha is going to come. Now do you know that before the 18th Lok Sabha elections, the 17th Lok Sabha will be dissolved. It has to be dissolved. Who will dissolve the Lok Sabha? The president will dissolve. Very good. After the president dissolves the Lok Sabha, the elections will happen. And in the elections, the Election Commission of India will declare the result. And then somebody will form the government. Whoever is having the majority, they will approach the president, and the president will appoint someone as a prime minister who is having the majority. And then the prime minister who is appointed as a prime minister will recommend the names of the other ministers. The president will appoint the other ministers also. The government is formed. Now after the government is formed, then this government will advise the president to summon the session of the new parliament, because who has the power to summon the session? The president has got the power to summon the session. So this new council of ministers will advise the president, and then the president will summon the session. That is when the first Lok Sabha, the Lok Sabha's first session will come into existence. Which Lok Sabha? The 18th Lok Sabha, say for example. And when the first session comes, you need to have someone as a presiding officer. The president can summon, but the president cannot preside. Who will preside over that session? Some presiding officer has to be there, and for the purpose, till the time the speaker is elected in that particular house, someone will be appointed by the president as the pro tem speaker. Do you understand who is this pro tem speaker and what is his responsibility? He has to preside over the session whenever it is summoned in the new Lok Sabha, till the time the speaker is elected. And he is what is called as the pro tem speaker. But what he'll have to keep in your mind is this pro tem speaker is not elected. He is what? He is appointed. He is appointed by whom? By the President of India. And there is no mention of this pro tem speaker in the constitution. This is just a conventional practice in our country. This is what? This is a conventional practice. As per the prevailing convention today, who is usually appointed as a pro tem speaker? The senior most member in the Lok Sabha from the ruling party. He is appointed as a pro tem speaker. Now there is one more provision in the constitution. Whenever the president summons a first sitting, he is appointing a pro tem speaker, and the president will administer him the oath. Because to be a member of parliament, once you have to enter into the parliament and to perform the duties as a member of parliament, an oath has to be administered. And who is going to administer the oath to the pro tem speaker? The president. And that is true for other members of the parliament in the Lok Sabha also. For other members also, once the session is summoned and they have to come and take part in the proceedings, they should also be administered the oath. So who will administer the oath to the other members? The pro tem speaker will administer the oath to the other MPs. Alright, now the pro tem speaker is appointed, his oath is administered, and then the session is summoned, and then the other members come to the session. For the other members, the pro tem speaker is administering the oath. Then what the president will do is, the president will decide a day on which the election of the speaker is to happen. So who will determine the date for the election of the speaker? The president will determine the date. Try to remember, each and every point can be asked in the prelims examination. The president will determine the date on which the election is to happen for the speaker. And on the date which is decided by the president, try to understand, the elections will be conducted. The election will be conducted for the speaker, and who will preside over this election? The pro tem speaker will preside over the election. So whoever is elected with simple majority. What is the majority that is required to elect the speaker? Simple majority. Anyone being a member of Lok Sabha can contest, and who will preside? Pro tem speaker. And once the speaker is elected, then automatically the office of the speaker pro tem ceases to exist. Then there is no role for the speaker pro tem. So this is exactly what you'll have to understand with regard to the speaker pro tem. Now come to the question. He is elected by the Lok Sabha from amongst its members. Is it true? So partially it is true, but he is not elected. But what? He is appointed by the president. He is not elected, so this particular statement is wrong. He or she fixes the date of election of the speaker. Who fixes the date? The president fixes the date, not he. The president himself administers the oath to him or her. Is that true? That is true. So which of the statements given above are incorrect? What is the answer? Only two. Okay, so option B is the right answer. Yes, Mukesh, quickly. Same? Repeat it, please. Same thing. Instead of the president, you replace it with the governor. That is the only difference. Otherwise, everything is the same. The same process happens in the state legislature as well. Come to the next question. Please be little louder, Mukesh. Oh. Till the time the pro tem speaker is appointed, the previous speaker would continue to hold the office. Whenever the speaker pro tem will appointed, then the previous speaker ceases to exist. Okay. Come to the next question, question number 14. Consider the following statements. As per the Constitution of India, money can be withdrawn from the Consolidated Fund of India only after an appropriation act. Just now I explained this. Is it true or is it false? As per the Constitution of India, money can be withdrawn from the Consolidated Fund of India only after the Appropriation Act. Even to take out a single rupee from the Consolidated Fund, you require approval in the form of what? In the form of an Appropriation Act. And when does this Appropriation Act happens? During the budget process. Which stage? After the vote on demand for grant stage, the fifth stage. And there's one more stage after this, which is the passing of the finance bill. Okay, so this particular statement is definitely true. Come to statement number 2. The payments from the public accounts of India can be made without parliament appropriation. Is that true? Okay, so one thing that you have seen is, there are 3 types of funds you have seen. One is the consolidated fund. What is the other fund? Another is the contingency, and then it is the public accounts. So these are the 3 types of funds that you should be aware of. Of this, try to understand, very, very important thing, of this try to understand, to take out even single rupee from the Consolidated Fund of India, it requires what? It requires the approval of the Parliament. Without the approval of the Parliament, not even single rupee can be taken out. So for every single rupee, the Parliament has to give the approval, and the Parliament gives the approval in the form of an Appropriation Act, which happens during the budgetary process. But to take out money from the contingency fund, the approval of the Parliament is not required. Whose approval is required? The President approval is required. The President is the authority who will give the approval. On behalf of the President, today this approval is given to the Secretary, Ministry of Finance. Secretary, Ministry of Finance. And for the public accounts also, the approval of the Parliament is not required. For the public accounts also, the concerned government officer can give the approval. It's also under the hands of the executives. There is no need for approval of the Parliament. So now with all these information come to the question, come to statement number 2. the payments from the public accounts of India can be made without parliamentary appropriation. Is it true? This is definitely true, because only for the consolidated fund it requires the appropriation. The contingency fund is held by the finance secretary on behalf of the President of India. Is it true? So ultimately the control is there to the President. But what is the position of the President in our country? He is the head of what? He is head of the Union Executive. So he can delegate this power to the subordinates. And Union Finance Minister's secretary is what? He is a subordinate. So he has delegated this power to the Finance Secretary for the purpose of administrative convenience. Because every time you take the permission from the President, it will take some time. So what is contingency fund? Contingency means it's an emergency purpose. So to make it faster, this power has been delegated by the President to the Finance Secretary. But he does not hold this power, but on behalf of the President, he is exercising this power. So this is also true. So how many of the statements given above are correct? What is the answer? Answer is option C. Very good. So how many of you got this right? Okay, so in this class, how many of you are part of the test series? Can you just raise your hand? So how many of you are part of the test series? All right. So the discussion could be fruitful if you take the test and then if you commence it. It would be much better for you to grasp and to consolidate your understanding. And if you read, if you take the test, then it could be much more beneficial. Okay, come to question number 15. With reference to Parliament of India, which of the following parliamentary committee scrutinizes and reports the House whether the power to make regulations, rules, sub-rules, bylaws, etc. conferred by the Constitution or delegated by the Parliament or being properly exercised by the executive within the scope of such delegation. So can anyone tell me the answer for this question? Subordinate legislation. Alright, so first let me explain these committees. There is something which is called as Committee on Government Assurances. Now what is this Committee on Government Assurances? Suppose let us assume there is some question that is raised against the Prime Minister or against any of the other ministers in the Parliament. And they are giving an assurance, okay, let us assume that the Chinese incursion which is happening in the border, so the opposition is trying to talk about it. Or let us assume Manipur issue, you might be aware of the ethnic conflict that happened in Manipur. So at that point of time, the opposition might ask a number of questions to the ministers, responsible ministers, the government. So the government ministers will say something in the houses. They will give some assurances, okay, within this time we will take measures. We will file FIR and we will take action against all those people. So they will make some assurances in the Parliament. But who is going to follow up on these assurances? There is a committee in the Parliament which is called as the Committee on Government Assurances. They will make a note of all the assurances that is given by the ministers. And after a certain time, they will raise questions. Okay, this is an assurance that you have given. Have you done this? So in this way, can they ensure the accountability of the government? So this is a way that they can ensure the accountability. That is Committee on Government Assurances. So anyways, this is definitely not the answer for this. A Rules Committee. Who is supposed to make rules as to how the various things happen in the Lok Sabha? Who has the power to make rules? Can anyone tell me who has the power to make rules? Say for example, to carry out anything in an organized manner, you need to have the rules. In fact, the Constitution is a rule book. But the Constitution is not so elaborate that it has mentioned the rules in the Lok Sabha. The Constitution is not so elaborate that it has mentioned the rules in the Rajya Sabha. Rather, the Constitution has given the power to the presiding officers to make the rules. Whoever is a presiding officer, they have been given authority. And who is giving that authority to them? The Constitution is giving that authority. But the presiding officer cannot make the rules on their own. They need the help of others. So they have a rules committee within the Parliament. In the Lok Sabha, there is a rules committee. In the Rajya Sabha, there is a rules committee. And these committee members will advise the presiding officer in making the rules. Okay. So what is the function of the rules committee? They will advise the presiding officer with regard to how the rules can be made. If the existing rules can be amended, they can suggest and it can be done by the presiding officer. That is the function of the rules committee. What is business advisory committee? Suppose let us assume there are 10 business in the Parliament. There is a constitutional amendment bill, there is an ordinary bill, there is a motion that is introduced. Now which is the order in which it is to be taken up? Which should be given the priority? So how the business has to be organized in the house? So that has to be decided by the presiding officer. And for the presiding officer, who will advise? The business advisory committee will advise. Okay. So if you rule out all those things, what is left out? What is left out? Committee on Subordinate Legislation. So when I say Committee on Subordinate Legislation, now what is the purpose of the parliamentarians? What is the major function of the parliamentarians? Making the law. There are a number of functions, but one of their primary function is making laws. But do you think that the parliamentarians are legal experts to make the laws? They may be amateur, they may not have any knowledge, legal knowledge also, but yes, that is how democracy is. Democracy elect the representatives and the representatives have that power to make the laws. Now, whenever these elected representatives make the law, whenever the law is made in the parliament, have you ever heard of this, that the parliament makes a law in what is called as a skeleton form? The parliament makes law in which form? The parliament makes a law in skeleton form. That means not all the minute details will be there in that law. Only the skeleton, only the structure will be there. Only the skeleton will be there. Who will fill the bones, sorry, who will fill the flesh, who will fill the blood, so that if you take a human body, we have a skeleton, and then we have the muscles, we have the we have the blood and all those things. So who will fill all those things? The permanent executive. Say for example, let us take the example of the traffic rules in our country. So how many of you ever paid some kind of fine for violation of traffic rules? Be it not wearing the seat belt, not wearing the helmet. So everyone might have some experience. But do you think that all these things are made by the parliament? No. The parliament only makes a law in what is called as a skeleton form. Skeleton form means in raw form. The law will be made. So it is the traffic department, the police officers, whoever is in charge, they'll make the rules under that. They'll say, okay, this much is fine for the violation. And that law is what is called as what? They are called as rules, bylaws and all those things. But somebody has to monitor that, whether they are making it properly. And who will monitor that in the parliament? It will be done by the Committee on Subordinate Legislation. So what is the answer? The answer is option B. Is that clear? So here the answer is option B is the right answer. Come to the next question. Question number 16. Which of the following statements, consider the following statements regarding the governor. The governor must take oath or affirmation before entering the office. Is it true? In that case, who will administer the oath for the governor? The oath for the governor has to be administered by? Okay, so the concerned Chief Justice will administer the oath. Okay, so that is definitely true. And come to statement number 3, the oath of the office of the governor is administered by the Chief Justice of the concerned High Court. This is also true. Come to statement number 2, the third schedule of the Constitution contains a format of oath or affirmation. Is that true? The third schedule? Okay, in the third schedule, whose oath are mentioned in the third schedule? Very, very easy. You should remember this also. So try to remember ministers. So make a note of it, that what is there in the third schedule. Ministers, both union and state. So 1, 2, members of parliament, members of state legislature, so this is 3, this is 4. Anybody who wanted to contest election to parliament, anybody who wanted to contest election to the Lok Sabha, who wanted to contest election. Contest election to parliament, to state legislature, that is also there. So 5, 6, judges of Supreme Court, judges of High Court, Comptroller and Auditor General. So these are the 9 oaths that is mentioned. So try to remember this so that you do not make any mistake. Is the governor mentioned here? It is not mentioned here, so this particular thing is wrong. So the third schedule of the Constitution contains a format of oath, so that is not the case. So what is the answer here? Which of the statement is correct? The answer is option B, 1 and 3 only. Okay, so come to the next question. Governor oath has to be taken, but it is not as per what is mentioned in the third schedule. It is not mentioned in the third schedule. That is the question. Come to the next question. Question number 17. Have a look into the question. With reference to the Deputy Speaker of Lok Sabha, consider the following statements. Statement 1. As per the rules of procedure, the conduct of business in the Lok Sabha, the election of Deputy Speaker shall be held on such date as the Speaker may fix. Is it true? I already explained this. Who will fix the date? The president will fix the date, not the deputy speaker. So this particular statement is wrong. But what is the question here? What we are talking about? As per the rules of the procedure, the conduct of business of Lok Sabha in the election of the deputy speaker. Okay, so it is for the deputy speaker. For the deputy speaker, it will be done by the speaker. Sorry, I was imagining that it is for the speaker. For the deputy speaker, it is done by the speaker, and for the speaker, it is done by the president. Okay, so this particular statement is true. Okay, this is right. Come to question number 2. There is a mandatory provision that the election of the candidates of the deputy speaker of Lok Sabha shall be either the principal opposition party or the ruling party. So here the key word is there is a mandatory provision. Okay, the constitution does not say as to who can contest election to the speaker, who can contest election to the deputy speaker. To get elected as a speaker, you need to have simple majority. To get elected as a deputy speaker also, you need to get simple majority. But today there is a parliamentary conventional practice. And what is a conventional practice? The conventional practice is that anyways the ruling party has the majority, so they elect the speaker. From the 11th Lok Sabha, this conventional practice has started. The conventional practice is that they will give the position to the opposition party. Okay, that's only a conventional practice. That means the government will not contest the election to the deputy speaker, they are giving it to the opposition party. Provided that the opposition party has a minimum majority. The minimum majority is not less than 1/10 of the total membership of the house. Okay, so this is not a mandatory provision. Come to statement 3. The deputy speaker has same power as that of the speaker when presiding over the sitting of the house, and no appeal lies against his ruling. Whenever the deputy speaker is presiding over the house, the deputy speaker will have the same powers as that of whom? As that of the speaker. And whatever his decision is final within the house. Even the speaker after coming back, he cannot change it. Okay, so this is definitely true. Statement number 3, the well-established parliamentary practice regarding the appointment of deputy speaker is that the motion is moved by the speaker and duly seconded by the prime minister. Is that true? The well-established parliamentary practice regarding the appointment of deputy speaker is that the motion is moved by the speaker and duly seconded by the prime minister. There is no such rules as of now. This is just a distractor. Okay, so there is no need for this has to happen. So this is definitely wrong. So what is the answer here? The answer is option A, that is 1 and 3 only. Okay, come to the next question. Okay. So in this case, they can give it to the secretary Lok Sabha. So this rule has already been made by the president. Okay. So in case the deputy speaker is not there, then this may happen. And in case of deputy speaker is there, no speaker is there, then also the deputy speaker can do this. Come to the next question, question number 18. So consider the following statements regarding the chief ministers with regard to the council of ministers. He allocates various portfolio to the minister. So who allocates the portfolio to the ministers? Portfolio. First of all, you'll have to understand as to what this portfolio is. Portfolio means departments and ministries. This segregation. That's basically what is portfolio. When this portfolio system came into existence in our country? In the last class we discussed this. Who is the father of the portfolio system? Lord Canning. Lord Canning introduced this in 1859. After the Government of India Act, he introduced this, but it was given a statutory recognition. A legal backing was given when? To the portfolio system in our country, in British India. When was the legal backing was given? The legal backing was given in 1861, Indian Councils Act 1861. Very, very important. Make a note of it. Okay. So he allocates the various portfolio among the ministers. Definitely true. So who will allocate the various portfolio? The chief minister in this case. The chief minister will allocate the portfolio. And his death can dissolve the council of ministers. Is it true? Suppose let us assume today a chief minister is there in a particular state, suddenly the chief minister dies. Can the other ministers continue to be in office? Can the other ministers? As long as the new chief minister recommends a governor, these ministers can continue. If a new chief minister is elected and if the new chief minister is not okay with the present ministers, it has to be dissolved automatically. Okay, so this is definitely true. His death will dissolve the council of ministers, because who appoints the chief minister and the other ministers? Who appoints? Governor appoints, but the governor cannot act on his own. The governor appoints on the aid and advice of the chief minister. He appoints other minister based on the chief minister, but this chief minister dies. So the new chief minister can recommend new people to the governor. So in this case, I cannot continue once the chief minister dies. That is why the position of the chief minister and the prime minister becomes so important. Okay, so there's one story also behind this. How many of you are aware of Prime Minister Mr. Manmohan Singh? Most of you might be aware of Prime Minister Mr. Manmohan Singh, and he was considered to be a very silent Prime Minister and not a very authoritative Prime Minister. So this Prime Minister was wanted to have a deal with USA, civil nuclear agreement. So which has not been completed even today, but the process already started. So Prime Minister wanted to have this civil nuclear agreement because he thought that that will bring energy security to India. But then there are many members within the Congress did not accept to that. Many ministers within Congress openly opposed that. And then the Prime Minister didn't know what to do. And then Prime Minister announced one thing: if the ministers are not agreeing to what I am going to do, then I will resign. So he announced that he is going to resign, because if he resigns, then the other ministers cannot continue in office. Although the Congress may have the majority, because you know that who will next become the Prime Minister and he can change the ministers. So in that case, if the Prime Minister or the Chief Minister dies also, the other ministers cannot retain. Unless until the new Chief Minister or the new Prime Minister again recommend the same name to the President and the Governor respectively. Okay. So this particular statement is definitely true. Which of the statements given above are correct? Both 1 and 2. Right? So these are all minute understanding. Just by reading the books, you will not have this understanding. Okay, you should have an understanding of how things happen in our country. Come to the next question, question number 19. India after independence adopted first past the post system. You know what is this first past the post system? It's a very simple method. In first past the post system, what is the majority one is required to get elected, to be declared to be the winner? What majority is required? Simple majority, absolute majority, no majority. There is no majority that is required. First past the post system is very simple. First past the post system is very simple. What is first past the post system? Whoever is getting maximum number of votes, that is what is required. So here I just asked, what is the first past the post system? What is the majority that is required? So here it is very simple. India after independence adopted the first past the post system. Which among the following is not a reason? So among them, he'll have to identify which of the following was not the reason to adopt this first past the post system. Statement A: proportional representation is complicated system which may not work in small country, but is difficult to work in large countries like India. So you should also have an idea as to what is proportional representation. I hope you have an understanding of proportional representation. But just try to have this understanding right now. Proportional representation is a very complex system. It's very complex. But whereas first past the post system is relatively very, very simple. India is a big country or a small country? It's a very big country. In a very big country, we need to have a simple system or a complex system? Simple system. So here, proportional representation is a complicated system which may work in a small country, but it is difficult to work in a large country like India. So this is the reason. So this reason is there, but they are asking what, not the reason. So this is not the answer. The entire election of first past the post system is extremely simple to understand even for the common voters. So this is also true. So here they are asking not the reasons. That is not the answer. First past the post system is constituency based system and representatives are responsible for one locality. So today in our country, which system do we follow? First past the post system. And do we have constituencies in our country? And from every constituency, how many person is elected? One member, one constituency is what we follow. And that person is responsible to that particular constituency. So this particular statement is also correct. So it cannot be the answer. So come to option D. In first past the post system, voters often asked to choose a party and the representatives are elected based on the party lines. Okay. In first past the post system, this does not happen. It happens in proportional representation. In proportional representation, we vote to party, whereas in the first past the post system, we vote to whom? We vote to the candidates. So how many of you voted in any elections here? Lok Sabha elections or... So when you voted to a party or you voted to a candidate? No, you want one party to win, but ultimately to whom you can cast your vote? You can vote your vote only to a candidate who represents a particular political party. So that is exactly what happens in the first past the post system. But in proportional representation, you will not vote to the candidate, but you vote to the party. and depending upon the vote that is secured by the party, proportionate members will represent that particular party in the parliament. Okay, so that is not the case when it comes to first past the post system. The right answer is option D here. Okay, so D is the right answer. Yes, one locality here means a particular constituency. Anything common. It can be legislative assembly constituency, it can be Lok Sabha assembly constituency, whatever may be the case. Alright, so this is a very important area. Okay, so try to have an understanding. Come to the next question quickly. Ravinder sir is already waiting, so let me just fast track a little so that he'll take up questions after a few more questions. He'll take up for some time. So come to the next question, question number 20. The privileges of the state legislature are extended to which of the following? So privileges, anyone recollect the articles 11 to the parliamentary privileges? So article 105 provides for certain privileges for whom? For the members of the parliament. A similar privilege is also given to the members of the state legislature. Which article? Article 194. You don't have to remember all the articles, but yes, few articles you'll have to remember. It is for the state legislature. Okay, now these are the articles, but what is the privilege that they have got? Certain privileges are given to the members of the parliament and state legislature. What are the privileges that is given to them? They have the right to speak, they have the right to vote, and they are not answerable to court of law for whatever speech or whatever vote they have done in the houses of the parliament. So this is one privilege. And as a house collectively, this is an individual privilege. As a house collectively, they have the right to publish and not to publish certain things. Now, have you ever seen Lok Sabha debate and Rajya Sabha debate? It is live telecasted today. But do you think that all that is spoken in the houses will also be part of their official records? Live telecasting is something, but not everything that is spoken in the house will be part of their official records. Because there can be false allegations also, but they have the right to freedom of speech though, so they can talk, but not necessarily everything can be part of the official records. So who will decide what to be part of the official records and what not to be part of the official records? The presiding officer, but on behalf of the house. That is also a privilege of them. Now this privilege is extended to who? Who are the people who will exercise this privilege? The chairman, legislative council, will he exercise this privilege? He is a member of that particular house. The chairman of a legislative council, in a state, let us assume there is a legislative council. The chairman is a member of that particular house. The chairman of Rajya Sabha, is he a member of that particular house? The chairman Rajya Sabha is not. He is vice president who becomes ex officio chairman. But in case of the legislative council, only a member of that particular council can be elected as a member. Only a member of that particular house can become the chairman. So this is true. Member of the legislative assembly will they exercise a privilege? In both the cases, they exercise privilege under Article 194. And then you see a member of a legislative council, again Article 194. And you see the Advocate General of a state. Do the Advocate General of the state exercise the privileges of the members of the parliament? So whenever he is taking part in the proceedings in the state legislature. So suppose the Advocate General is normally not the member of the house. The Advocate General is the law officer for the state government. But this law officer, whenever he is called upon to take part in any proceedings in the state legislature, in that circumstances, he will also have all the privileges. Except the right to vote. He will not have the right to vote, but otherwise he will exercise the privilege. So the privileges are also extended to him. The same thing is true with regard to the members of the parliament under Article 105. But the governor has no such privilege. The governor under the constitution does not exercise the privileges that of the members of the parliament or the members of the state legislature. The governor has different set of privileges, but not these privileges. Do you know that any article that provides any privilege to the governor? Article 361 of the Constitution. Note it down and go and look into it. What this privilege is given to the governor under Article 361 of the Constitution. Okay. So what is the answer in this case? 2, 3, 4 and 5. Very good. Come to the next question. Which of the following statement is not correct regarding the Delimitation Commission of India? So what is the position of Delimitation Commission of India today? Is it a constitutional body? Is it a statutory body? Is a body which is established by executive order? In the last class itself I told what is the position of? It's a statutory body. Statutory body means it is established by way of a law. And what is the law that is there? Delimitation Act. there is a Delimitation Act which establishes this Delimitation Commission. So it is a statutory body. Okay. So now look into this particular thing. So what is the idea behind this Delimitation Commission? Is that this commission will determine the number of seats, not only the number of seats. So it has three functions. Try to understand the Delimitation Commission or the Delimitation Act. The Delimitation Commission has got three functions. So what are the three functions of the Delimitation Commission? One is it will determine the number of seats for both Lok Sabha. One is determine the number of seats. Two, it will not only determine the number of seats, it will draw the boundaries of each and every constituencies. It will draw the boundaries. And then the third thing is, it will also determine the number of seats reserved for the scheduled caste and scheduled tribe. All these functions are done by the Delimitation Commission. Now with this, just come to this thing. It's a permanent body constituted under the Delimitation Commission Act enacted by the Parliament. It's partially true. It is enacted by an act of Parliament, but it is not a permanent body. It is established from time to time. Okay, so it is not a permanent body. So here it is wrong. The delimitation would apply to every general elections to the House of People or to the State Legislative Assembly. This is true. So whenever the election happens, the Delimitation Commission has to draw the boundaries. They will keep on changing the boundaries. So this is true. The orders issued by it are final and cannot be challenged in a court of law. So this is also, so the delimitation would apply to every general election to the House of People or to the Legislative Assembly. So this is also true. So this is also true that the orders issued by them is final and it cannot be challenged in a court of law as per the Delimitation Act. Okay. And then come to the last statement. The Delimitation Commission is headed by a retired judge of a Supreme Court. Okay, so this is also true. Okay, so this is also true. So normally who will head the Delimitation Commission? So it will be headed by the by the retired judge of a Supreme Court, and then there are certain members, the Chief Election Commissioner or any of the other election commissioners as nominated by the Chief Election Commissioner, and then the State Election Commissioner. In whichever state they are doing the delimitation process, that State Election Commissioner will also be part of it. So this is also true. So what is the answer here? Because they are asking which of the statement is not correct. The answer is option A. A is the right answer. Come to the next question. Come to the next question. Consider the following statements with reference to the Estimates Committee. So there are three financial committees that have said in the Parliament. What are the three financial committees? Public Accounts Committee, Estimates Committee, Committee on Public Sector Undertaking. So at least these three committees has to be in your mind. Their composition is also very important. Apart from these three committees, you should also look into the departmental related standing committees, DRSCs. From both the areas, questions can come. But financial committees are more important for the prelims. So we have already seen what is the function of the Public Accounts Committee also. We have also seen what is the function of the Committee on Public Sector Undertaking as well. So they both scrutinize the report of the CAG. That is their major function, although in different area. But what is this Estimates Committee? This Estimates Committee will scrutinize the estimates that is presented in the Parliament. Where the estimates are presented? In the budget there is an estimate. What is budget? Budget is a statement of estimated receipts and estimated expenditure. So in the budgetary process, you see, even before it is presented in the Parliament, the Estimates Committee will scrutinize the estimates and it will give its opinion to the government. And then the government can accordingly modify the estimates. That's a major function of this Estimates Committee, although they perform other functions also. So if you look into as per the present rules, as per the Parliament, as per the parliamentary rules, the Estimates Committee will have 30 members. How many members? And all the 30 members are from which house? All the 30 members are from Lok Sabha. This is one area which UPSC is repeatedly asking. Because the other two committees, that is the Public Accounts Committee and in case of the Committee on Public Sector Undertaking, PAC and the Committee on Public Sector Undertaking, what is the membership in both the cases? 22 members. In both the cases it is 22 members. Out of these 22 members, 15 from Lok Sabha, 7 from Rajya Sabha. While the other two committees have representation from both the houses, this has got representation only from the Lok Sabha. And how many members are two? 30 members. There can be one more question that can be asked. Which is the largest financial committee in the Parliament? Which is the largest committee? Estimates Committee, and in Estimates Committee 30 members, all from Lok Sabha. Why? These are all matters of finance, which is related to budget. And to whom the government is accountable? The government is accountable to Lok Sabha or to the Rajya Sabha? The government is accountable to the Lok Sabha. So that is why in case of this, all the members are from where? Only from the Lok Sabha. And one general rule is that no minister can be part of this committee. Because if a minister is part of this committee, the objective of this committee is to make the government accountable. And how can you put a minister who is part of the government as a part of this committee? It will create a conflict of interest. So no minister can ever be a part of this particular committee. That is not going to happen. That is not possible at all. Okay. So with that, come to the information. The main function of this committee is to scrutinize the audit report of the CAG relating to revenue and expenditure of the government. Is that true? Who does this function? This function is done by the PAC, Public Accounts Committee, not by the Estimates Committee. Okay, so it is done by the Public Accounts Committee, not by the Estimates Committee. Come to statement number 2. It consists of members of both houses of the parliament. Is that true? It consists of members only from the Lok Sabha. A minister can be elected as its member but cannot be appointed as its chairman. A minister cannot be elected as a member also. He cannot be appointed as a chairman also. Okay, a minister can never be a member of this particular committee. Which of the statements given above are correct? What is the answer? None. Option D is the right answer. Very, very important area. You can definitely expect a question from the parliamentary committees, especially from the financial committees. Go home today, try to understand Public Accounts Committee, or at least try to recollect the points that you have discussed. Come to the next question. Question number 23. In which of the following cases the bills does not lapse when the Lok Sabha is dissolved? Now there are certain circumstances. This is a very confusing area for most of the students. Okay, so just keep this in your mind. Whatever rule that I am going to say, just keep this in your mind, apply that rule, you will be able to do that. So what are the circumstances under which the bills are likely to lapse? 2 minutes, have a proper listening to what I am going to say. Now as per the general rule, what is there in the constitution, whenever the Lok Sabha dissolves, the bill will lapse. So whenever the Lok Sabha dissolves, just keep this in your mind. If the bill has got any relation to Lok Sabha, the bill will also lapse. So what is the constitution is saying? When the Lok Sabha dissolves, what will happen? Lok Sabha dissolves, the bill is going to lapse. When you say that the Lok Sabha dissolves, the bill is going to lapse. So any bill which has got any relation to Lok Sabha, the bill will lapse or not? It is going to lapse. This is a general understanding issue. This is one principle if you remember. Any bill which has got any relation to Lok Sabha will lapse on dissolution of Lok Sabha. It may be introduced in the Rajya Sabha, passed from Rajya Sabha, but from Rajya Sabha it has been passed to Lok Sabha. It is there in the Lok Sabha, but the Lok Sabha is dissolved. Will the bill lapse or not? It is introduced in the Lok Sabha, it is pending in the Lok Sabha is dissolved. The bill will lapse or not? Okay, it is introduced in the Rajya Sabha and it is pending in the Rajya Sabha, the Lok Sabha is dissolved. What is going to happen? It will not lapse because it is yet to establish relation with Lok Sabha. It has not yet established relation with Lok Sabha. So what is the general thing that you have to understand? Any bill which has got any relation to Lok Sabha, it will lapse on dissolution of what? On dissolution of Lok Sabha. But an exception to this, there is an exception to this. This is general rule. What is an exception? If the president is involved in the process, even it has got a relation with Lok Sabha, still the bill will not lapse on dissolution of Lok Sabha. How it may have a relation with the president? Suppose let us assume the bill is passed by both the houses. Will it have a relation to Lok Sabha in this case? It has a relation. It is passed by both the houses, but it has already gone to the president. The president is yet to act. But because it has gone to the president, although it may have a relation to Lok Sabha, even though the Lok Sabha is dissolved, the bill will not lapse. Clear? What is the general rule? If it has got any relation to Lok Sabha, on dissolution of Lok Sabha, the bill is going to lapse. But the exception is if the president is involved, the bill is not going to lapse. Passed by both the houses, gone to the president. Even on dissolution of Lok Sabha, the bill is not going to lapse. That means when the new Lok Sabha comes, when the new ministers advise, still the president can give the assent. Second thing, has been passed by both houses, gone to the president has sent it for reconsideration. Because the president can send it for reconsideration once. And then let us assume when he send it for reconsideration, the Lok Sabha dissolves. Will the bill lapse? The bill will not lapse because the president is already involved. Third thing, there is a deadlock between both the houses. And because there's a deadlock, to resolve the deadlock, the President has convened a joint sitting. And after he convenes a joint sitting, the Lok Sabha dissolves. Will the bill lapse? The bill will not lapse. So the exception is, under all the circumstances, wherever the bill has got a relation to Lok Sabha, it is going to lapse. What is the exception? If the President is involved, then the bill is not going to lapse. The same thing applies in case of the governor also in the state. If the governor is involved, the bill will not lapse. Okay, so this is the basic understanding you should have. Now with that, just come to the question. A bill pending in Rajya Sabha but not passed by the Lok Sabha, will it lapse? It is still introduced in Rajya Sabha and it is pending in Rajya Sabha. It has no relation to Lok Sabha. So in this case, it will not lapse. So in which of the following cases the bill does not lapse? So in this case, the bill does not lapse. So this is true. A bill passed by Lok Sabha but pending in Rajya Sabha, what will happen? It will lapse because it already has a relation to Lok Sabha. It will lapse. A bill passed by both the houses but turned by the President for the consideration, will it lapse? It will not lapse because the President is already involved. It does not lapse. Because it is already established relation with Lok Sabha. Where it is introduced? It is introduced in the Lok Sabha. What if the Rajya Sabha sends it for again making amendments and send it to Lok Sabha? There is no. So anyways, it has a relation with Lok Sabha and Lok Sabha job is not yet over. So it has already established relation with Lok Sabha and it has gone to the Rajya Sabha and Rajya Sabha has not decided this. Rajya Sabha is still considering. What if Rajya Sabha wanted to make some amendments and send it back to Lok Sabha and the Lok Sabha is dissolved? Anyways, whether it is, because we do not know what the Rajya Sabha is going to do because it is still pending in the Rajya Sabha. So in that case, when the Lok Sabha is dissolved, the bill will lapse. Come to statement number 4. A bill pending in Lok Sabha which was transmitted to it by Rajya Sabha. In this case, will it lapse? Means a bill is introduced in the Rajya Sabha passed it, it has come to Lok Sabha. When the Lok Sabha is considering it, the Lok Sabha is dissolved. Will it lapse or will it not lapse? Do not go with what Mukesh said, think independently. It will lapse or it will not lapse. Once it is there in the Lok Sabha and when the Lok Sabha is dissolved, it is going to lapse. Any relation with the Lok Sabha, it is going to lapse unless until the President is involved. So this is also going to lapse. So what is the answer here? In which of the cases the bill does not lapse? 1 and 3 only. So I am just repeating it again. Just write down this rule, go back home and try to get this rule. So under what circumstances the bill is going to lapse? Any relation with Lok Sabha, the bill is going to lapse. If it has no relation to Lok Sabha, the bill will not lapse. No relation means only one case. The bill is introduced in Rajya Sabha, pending in Rajya Sabha. At the time the Lok Sabha is dissolved, the bill is not going to lapse. Even if it has got a relation to Lok Sabha, assume, even if it has got a relation to Lok Sabha, but if the President is involved, the bill is not going to lapse. If you remember this, you don't have to memorize these things. If you memorize, you will get confused. If you remember this rule, you will not get confused. It will not lapse. It may be anything. He has sent it for reconsideration, or he is yet to act, or he has convened a joint sitting. It is not going to lapse. A bill? President is involved. Who is retaining for reconsideration? You cannot send it for reconsideration. I cannot send it for reconsideration. Who can send it? The President. That means the President is involved in this. Okay? Okay, no issues. If you have made a mistake, very good. Then why so many doubts if you already got it right? Come to question number 24. Come to question number 24. So how many of the following statements are correct with regard to the mentioned rules in the Rajya Sabha? So how many of you heard about this rule number 176 and rule number 276, which has been many times there in the news? In which context it was there in the news? No, it is not related to anti-defection. During the Manipur violence, how many of you followed this Manipur violence? During the Manipur violence, the opposition parties wanted to have a discussion in the house. And then the government was not willing to have this discussion. And this debate happened in the Rajya Sabha especially. So this was asked in this particular context. So you should be aware of such current things which was very much highlighted in the paper also. Now there are two rules that you should be aware of, because I'm not saying every rule you should be aware of, but rules which is there in the newspaper and again you should be aware of. One is rule number 176 in the Rajya Sabha. As per rule number 176 in the Rajya Sabha, if any member wanted to discuss a matter of urgent public importance, was a Manipur issue of an urgent public importance? So if you wanted to discuss, they can have a short duration discussion on that. Short duration means for a limited duration they can discuss. That means the discussion can happen for 2.5 hours under this rule. Okay, under rule 176. But there's another rule, that is rule number 267. If you see rule number 267, it's an extraordinary device which any member of Rajya Sabha can use. So if this rule, a motion is admitted, if any member wanted to introduce a particular motion under this particular rule, so under rule 267, all the existing business in the house can be suspended. Suppose let us assume that on a given day 10 matters are to be taken up in the Rajya Sabha. But if this motion is admitted under rule 267, all the 10 business can be suspended and this will be given priority. And there's no time limit for how long you can discuss. So it will be given a lot of priority. So in both the cases you can discuss matters of urgent public importance, but in 176 it's a short duration discussion. Under 267, you can discuss it for the whole day and you can suspend the other business. Whereas in 176, you cannot suspend the other business. That means under 267, more priority is given. Under rule 176, the priority is not that much. Okay, that's basically you have to understand between these two rules. There was a face-off between the government and the opposition. The opposition wanted to discuss Manipur under rule 267, where the government were ready to discuss the Manipur issue under rule 176. They are willing to have a short discussion, but the opposition wanted a big discussion on this. So that was repeatedly there in the newspaper. So that's why you should be aware of this. Okay. So what is the answer here? Just look into it. Rule 176 enables any member of Rajya Sabha to raise a short duration discussion on a matter of urgent public importance. Is that true? True. An opposition member can give notice under rule 267 requesting suspension of all the listed business of the day and to discuss the urgent matter. Is it true? This is also true. This is what I discussed. The only difference is here there is no time limit. Here there is a time limit. And here they can suspend all the matters. That is not possible here. This is also true. The discussion under rule 267 is time bound and limited to 2.5 hours. Is it true? That is true in case of 176, not in case of 267. This is not true. So how many of the following statements are correct? It is option B. 2 only is the right answer. Try to revise these things today itself. Go home and revise. Okay? The suspension of members of Rajya Sabha is not related to this question. I'll take up your doubt later. Okay? You can make a note of that. So come to the last question. Then after that, briefly, Ravindra sir will take up the discussion from here. So just look into question number 25. Transparent election process are critical to any functioning of the democracy. Do you agree? Transparent election process is very important. Consider the following statements regarding the election process. According to the constitution, there can be no longer than 6 months between the last session of the dissolved Lok Sabha and the recalling of the new house. That means once the 17th Lok Sabha is dissolved, the 18th Lok Sabha elections happens and the first session of the 18th Lok Sabha has to happen between what time? Between 6 months, because under Article 85 of the Constitution is clearly saying that there shall not be a lapse of more than 6 months between 2 consecutive sessions. So definitely it has to happen within 6 months. This is true. The model code of conduct comes immediately into effect after the announcement of the election schedule. Is it true? What is this model code of conduct? Who issues this model code of conduct? The Election Commission of India issues this model code of conduct. It is a simple guideline which talks about certain do's and don'ts for the political parties as to how they have to conduct themselves during the election process. Is the model code of conduct legally enforceable? The model code of conduct is not legally enforceable. There is some overlap between model code of conduct and the representation of people act. They can enforce what is in the representation of people act, but not as a model code of conduct. That is why it is also said the model
एक बार देख, तो आप बोला है फिर सही है सर। देखना अभी ठीक है ना। ऑनलाइन स्टूडेंट्स, कैन यू हियर मी? नहीं देख। सो हियर रमेश जी, नो वॉइस सर। काना मीना, देर इज नो वॉइस। ठीक है अभी आ रहा है, ठीक है। या सो वोट डालने के लिए 18 ईयर्स, टू पार्टिसिपेट इन द लोकल इलेक्शन 21 ईयर्स, देन एमएलए एंड लोकसभा एमपी के लिए कितना ईयर्स रहना चाहिए? 25 ईयर्स। देन राज्यसभा एंड एमएलसी मेंबर ऑफ लेजिस्लेटिव काउंसिल, हाउ मेनी ईयर्स? 30 ईयर्स। Then to participate in the election of the governor, president, vice president of India, how age कितना रहना चाहिए माँ? 35 years. So 18 years, 21 years, 25 years, 30 years, 35 years. Try to write this one. Most of the students, they are confused with this one. 18 years to vote in the election, to participate in the election, especially local election, panchayati municipalities. 21 years to participate in the MLA, Lok Sabha, MP, Lok Sabha, 25 years, Rajya Sabha, 30 years. Online students, Rajya Sabha 30 years, member of Legislative Council, yes, state में भी. Then when it comes to 30 हो गया, then 35 years, Governor, President of India, Vice President of India, 35 years, है ना? क्यों बोलो तो इसमें बच्चा भी बहुत गलत कर दिया, ठीक है ना? So here our answer is, बता सकते हो क्या ऑनलाइन स्टूडेंट्स? ऑनलाइन स्टूडेंट्स नहीं, यस सर, नो, फाइन, ठीक है रमेश्री। सो व्हाट इज योर आंसर माय हियर? 3 निकाल दो, ओनली 3। सो सी इज अवर आंसर, राइट? देन so an electronic voting machine, EVM, is a simple electronic device used to record votes in place of ballot papers and boxes. And what advantage do EVMs, electronic voting machines, hold over the traditional ballot box system? Ballot box बोले तो पेपर वाला, ठीक है ना? So what are the advantages here? ऑनलाइन स्टूडेंट्स बता सकते हो क्या? ऑनलाइन स्टूडेंट्स, रमेश जी एंड अदर स्टूडेंट्स, हाँ? ऑप्शन ऑल 3. सो हियर इट एलिमिनेट्स द पॉसिबिलिटी ऑफ इनवैलिड वोट्स. पहले क्या हो रहा था? इनवैलिड वोट. सो पीपल आर वोटिंग 2-2, है ना? सो इट विल एलिमिनेट द इनवैलिड वोट्स, यस. देन इट मेक्स द प्रोसेस ऑफ काउंटिंग वोट्स मच फास्टर थ्रू इलेक्ट्रॉनिक वोटिंग मशीन. Earlier where we are using man, so human resource को ज्यादा यूज कर रहे हैं. Now direct by machines only. So this is also right. Then it reduces the cost of printing almost nil, as only one sheet ballot paper. For example, earlier we are importing the paper from the Canada. समझो ना, बैलेट के लिए क्या कर रहा है? We are importing from the paper from the Canada. So obviously we are losing foreign exchange reserves, yes or no, है ना? And it emits also greenhouse gases also, right? Now because of the electronic voting machine you can reduce all the papers, है ना? आप eliminate कर सकते हो और complete nil कर सकते हो. That's why you are saving here. So it reduces the cost of printing. No need to print, no need to import from the other countries, है ना? No need pollution, and everything is safe. Almost nil, as only one sheet ballot paper is enough now, required for each polling station. समझ हो गया ना? So here क्या हो जाएगा आपका आंसर? आंसर is D. Any doubt here? जब आते हो ना ऐसा पॉइंट थोड़ा लिखने का ट्राई करो, आपको हाथ थोड़ा घूमेगा. Then consider the following statement regarding the adjournment motion. एक पॉइंट लिख लो ऑनलाइन स्टूडेंट्स. adjournment motion पहले half an hour discussion, please write. half an hour discussion बोले तो only 30 minutes discussion in the parliament, and short duration discussion means only 2 hours. Adjournment motion is 2.5 hours. समझ हो रहा है ना? half an hour discussion means only 30 minutes discussion. half an hour में half है बस 30 minutes discussion. Short duration discussion 2 hours only. Adjournment motion is here, adjournment discussion here only 2.5 hours. Only 2.5 hours. ये लिख लो, कल एग्जाम में आ जाएगा कितना आवर्स, हाफ एन आवर, 2 hours, 2.5 hours. ठीक है ना? Because many people are confused with this. Online students, can you hear me? Rameshri, yes, you are right, ma. And other students, those who are watching online. मीना किधर गया? ऑनलाइन स्टूडेंट्स, ठीक है. सो हाँ 2.5 hours, 30 minutes. Short duration discussion only 2 hours. कल एग्जाम में आ जाएगा मैच द फॉलोइंग, इधर हाफ एन आवर अर्जेंटमेंट डिस्कशन एंड अदर थिंग्स है ना. हाफ एन आवर, 2 hours, 2.5 hours, ये याद रख लेना अच्छा सर, ठीक है ना. बिकॉज नाउ डेज अर्जेंटमेंट मोशन, शॉर्ट ड्यूरेशन डिस्कशन, हाफ एन आवर डिस्कशन चर्चा में है, न्यूज में है, आ जाएगा कल. ट्राई टू अंडरस्टैंड, राइट. सो कंसीडर द फॉलोइंग स्टेटमेंट रिगार्डिंग adjournment motion. So adjournment motion, पहले बताओ, adjournment motion can be introduced in the parliament or either house of the parliament. Either house of the parliament means you are saying Lok Sabha plus Rajya Sabha also, or Rajya Sabha or Lok Sabha. See, the adjournment motion only be introduced in the Lok Sabha, not in the Rajya Sabha. But हम generally बोलते हैं parliament. But in parliament what? Again, Lok Sabha. It should be passed only in the Lok Sabha. For that purpose, you need to have how much support is required? 50 members. ठीक है ना, ये याद रख लो. कितना hours में इसको duration? 2 hours 30 minutes. This is the duration, 2.5 hours. Try to understand this point, right? Here, it can be introduced in either house of the parliament. Either बोलो तो क्या हो जाएगा? दोनों हाउस में, इधर लोकसभा भी हो सकता है, राज्यसभा. इट कैन बी इंट्रोड्यूस्ड इन द पार्लियामेंट बोलो तो जनरल पार्लियामेंट बोलो. एक दिन बोला था मैं, इट शैल बी काउंसिल ऑफ मिनिस्टर्स शैल बी कलेक्टिवली रेस्पॉन्सिबल टू द लोकसभा, काउंसिल ऑफ मिनिस्टर्स कलेक्टिवली रेस्पॉन्सिबल टू द पार्लियामेंट. डजंट मीन दैट राज्यसभा हियर, इन जनरल. दैट्स व्हाट आई एम कन्वेइंग हियर, राइट. या इन जनरल पार्लियामेंट सही है, बट शैल बी आ गए तो क्या है? ही इज बी स्पेसिफिक. रॉन्ग हो गया ना, ऑलरेडी आया हुआ ना, बहुत बार पूछा था स्टेटमेंट. काउंसिल ऑफ मिनिस्टर्स शैल बी कलेक्टिवली रेस्पॉन्सिबल टू द ओनली लोकसभा. ये स्पेसिफिक वाला शैल बी बोल दिया तो डिमांड कर रहा है पर्टिकुलर. काउंसिल ऑफ मिनिस्टर्स कलेक्टिवली रेस्पॉन्सिबल टू द पार्लियामेंट, यस, इन जनरल, राइट. हियर it can be introduced in either house of the parliament to draw the attention of the house on a matter of urgent public importance, yes, but in either house of the parliament, ठीक है ना. Then it needs the support of at least 50 members to be admitted, yes, yes or no. Then matters related to the question of parliamentary privilege can be raised under it, no. Adjournment motion always be specific, फैक्चुअल, डेफिनेट है ना. प्रिविलेज बारे में नहीं रहता है. प्रिविलेजेस, सी हियर यू कैन, पार्लियामेंटरी प्रिविलेजेस कौन सा आर्टिकल डील कर रहा है? आर्टिकल 105. आर्टिकल 105 डील्स विथ, ठीक है ना, आर्टिकल 105 डील्स विथ द पार्लियामेंटरी प्रिविलेजेस एट द सेंट्रल लेवल. इफ यू ऐड द 89 नंबर, क्या बोल रहा हूं, 89 नंबर ऐड किया तो आपको क्या आ जाएगा? स्टेट का आ जाएगा. सो कितना हो रहा है? 105 प्लस 89, 194. कैन वी से दैट? यस और नो? सो 194 इज द स्टेट प्रिविलेजेस वाला. दिस पार्लियामेंटरी प्रिविलेजेस वी हैव ड्रॉन फ्रॉम विच ऑफ द फॉलोइंग कॉन्स्टिट्यूशन? ब्रिटिश कॉन्स्टिट्यूशन. प्रीलिम्स में आया हुआ है. सो पार्लियामेंटरी प्रिविलेजेस अगेन वी कैन डिवाइड इनटू 2, कलेक्टिव प्रिविलेजेस, इंडिविजुअल प्रिविलेजेस. यस और नो? These parliamentary privileges applicable to the governor as well as the president. President को रहता है क्या parliamentary privileges? No, है ना. ये भी पॉइंट लिख लो, स्पेस रहा तो मुकेश बाद में पूछेगा फिर घुसा के, ठीक है ना. So it needs the support of at least 50 members to be admitted. Yes. Online students, कितना लोग पार्टिसिपेट हो रहा है देख रहा हूं इधर. यस सर नो, कुछ तो बताओ यार. ऑनलाइन स्टूडेंट्स, कना, मीना, रमेश श्री. ऑनलाइन स्टूडेंट्स, आपको समझ हो रहा नहीं हो रहा मुझे? यस सर नो, कुछ तो बताओ इधर, देखता हूं. हाउ मेनी स्टूडेंट्स आर पार्टिसिपेटिंग एक्टिवली हियर? एंड सी सेट का स्टूडेंट्स, कॉम्प्रिहेंसिव पैसेज वाला, वेरी फ्यू स्टूडेंट्स आर पार्टिसिपेटिंग. ठीक है. सो फर्स्ट सेकंड स्टेटमेंट सही है ना? देन मैटर्स रिलेटेड टू द क्वेश्चन ऑफ पार्लियामेंटरी प्रिविलेजेस कैन बी रेज्ड. नो. सो ये स्टेटमेंट भी हटा दो, इधर ये भी हटा दो. क्या हो जाएगा मां? ओनली टू, ये वाला. ठीक है ना? सो पार्लियामेंटरी प्रिविलेजेस कौन सा कंट्री बोला था मैं, हम डिराइव किया था? ब्रिटिश कॉन्स्टिट्यूशन. कौन सा आर्टिकल? 105. कलेक्टिव, इंडिविजुअल. सेंट्रल गवर्नमेंट आर्टिकल को 89 नंबर ऐड कर दो. सेंट्रल गवर्नमेंट आर्टिकल को 89 ऐड कर दो तो आपको स्टेट आ जाएगा. यू नीड नॉट टू रिमेंबर, है ना? मोस्ट ऑफ द टाइम करेक्ट होता है. ट्राई टू अंडरस्टैंड व्हाट आई एम कन्विंग. ठीक है ना? सो स्टेटमेंट 2 इज करेक्ट. इट नीड्स द सपोर्ट ऑफ एटलीस्ट इन. हियर क्या बोल रहा है? इनकरेक्ट स्टेटमेंट बोले तो 1 2 बी इज द आंसर. सो हमारा इसमें ये सही है and first statement and second statement is wrong. Then consider the following statement is the context of the calling attention motion. Calling attention motion. ठीक है ना? What do you know about the calling attention motion? Online students, calling attention motion क्या होता है? It is very urgent. Okay. To notify. Okay, very good. So, calling attention motion is the Indian innovation. In the part of the parliamentary procedure में क्या है? Indian innovation. पहले ये लिख लो आप थोड़ा. Indian innovation. And apart from the calling attention motion, 0 hour discussion also Indian innovation. ठीक है ना? Apart from the calling attention motion, 0 hour discussion also Indian innovation. But 0 hour discussion is not mentioned in the rules of procedure, but when it comes to calling attention motion has been mentioned in the rules of procedure. Try to write this point. कल आ जाएगा ये statement, match the following statement किसी में आ जाएगा. Calling attention motion mentioned in the rules of procedure and it is Indian innovation and in 1954 में आया था है. But when it comes to 0 hour discussion, it is also Indian innovation, but it has not been mentioned in the rules of procedure. ठीक है ना? Indian innovation कब आया था? 0 hour discussion 1962 में आया था, याद रख लेना. Now, calling attention, it is introduced to deal with very important matters like the impeachment of the president. नहीं, calling attention motion is you are taking the opinion of the attention of the minister. But here president क्यों? Not required, right? First statement is wrong. And it is an Indian innovation in parliamentary procedure. Yes or no? Yes. Already मैं इधर बता दिया हूं. So हमारा स्टेट क्या हो जाएगा हमको इधर? So B is our answer. Option 2. Yes or no? Then, how many of the following cases does the Rajya Sabha not have equal powers with Lok Sabha? बताओ. ऑनलाइन स्टूडेंट्स आप आंसर बताओ इधर. यू पीपल आर नॉट पार्टिसिपेटिंग एक्टिवली हियर. रमेश्री, Gayasri and Meena, other people. So in which case not having equal powers? The matters of creating new all India service. New all India service always the initiative taken by the Rajya Sabha. Rajya Sabha करेगा with special majority. Once Rajya Sabha करने के बाद लोक सभा को power आ जाएगा. Means they are having equal powers. Greater power, but initiative taken by the Rajya Sabha. Right? So here, so the matter of creating new all India services and amending the constitution, Lok Sabha, Rajya Sabha are equally participating. What is the procedure of the amendment of the Indian constitution? Huh? What is the procedure? व्हाट इज द प्रोसीजर भाई? सिंपल स्पेशल बोल रहा, प्रोसीजर बोले तो समझ हो गया क्या? बिल लोकसभा और राज्यसभा, मिनिस्टर और प्राइवेट मेंबर, स्पेशल मेजॉरिटी, है ना? इज देयर एनी जॉइंट सिटिंग? नो. इन केस फेडरल प्रोविजन, देन स्टेट, देन प्रेसिडेंट ऑफ इंडिया. विच मेजर हियर कौन सा मैंडेटरी किया था? 24th कॉन्स्टिट्यूशनल अमेंडमेंट एक्ट ऑफ 1971. Again and again I am repeating, you people are forgetting this one. ठीक है ना? So here Lok Sabha and Rajya Sabha is having equal powers here. दोनों को equal powers है. Then the removal of the government, just before I mentioned that Council of Ministers collectively responsible to the shall be collectively responsible to the Lok Sabha or Parliament. Lok Sabha. Then how it comes? The removal of the government. Rajya Sabha is not participating. Rajya Sabha participating नहीं हो रहा. So Rajya Sabha को equal power है क्या इधर? No. So here ये statement भी गलत हो जाएगा. तो क्या हो जाएगा बा हमारा आंसर इधर? What are the statement? कौन सा statement सही है इधर? Not have equal powers. Equal powers में कौन सा नहीं? अमेंड तो इक्वल पावर से. सो ये भी इसमें नहीं है तो कौन सा हो जाएगा मैं इसमें आंसर? देन फोर्थ स्टेटमेंट यू कैन सी मेकिंग कट मोशन लोकसभा राज्यसभा बोथ आर हैविंग इक्वल पावर्स. सो इसमें आप ये निकाल दो 2 and 4 दो हो गया ना. मेकिंग द रिमूवल ऑफ द गवर्नमेंट कौन सा पार्टिसिपेट हो रहा? ओनली लोकसभा. सो अनइक्वल. देन द मैटर ऑफ क्रिएटिंग न्यू ऑल इंडिया सर्विसेज किसको पावर ज्यादा है? राज्यसभा. सो हम कितना बोल सकते हैं? क्या व्हाट वुड बी आवर आंसर? बी 2 ओनली. ठीक है ना? एनी डाउट हियर ऑनलाइन स्टूडेंट्स? कट मोशन राज्यसभा कैन आल्सो इंट्रोड्यूस, राइट? पार्लियामेंट राज्यसभा कैन आल्सो इंट्रोड्यूस. ठीक है ना? We are having a policy motion, policy cut motion, token cut motion, economic cut motion. 3 मोशन है. PET बोले तो पॉलिसी, इकोनॉमी एंड टोकन. लिख लो ना शॉर्टकट. अब देखते हो सिनेमा देखते थे, मैं कुछ नहीं बोला, भाड़ में जा. ठीक है ना? पीटी सर बोलते हैं ना हम. पीटी क्लास में पीटी सर आ गया. PET पॉलिसी, इकोनॉमी, टोकन. पीटी याद नहीं आया? पीटी लिख दो, है ना? पीटी पॉलिसी कट मोशन, इकोनॉमिक कट मोशन, टोकन कट मोशन. गलती किया क्या सर? ठीक है. किसका? आप गलत करते हो. ठीक है ना? कंसीडर द फॉलोइंग स्टेटमेंट. ऑनलाइन स्टूडेंट्स व्हाट इज योर आंसर हियर? बताओ ऑनलाइन स्टूडेंट्स. ठीक है ना? सो हियर सीएम कैनॉट advise the governor regarding the appointment advocate general but members of the state public service commission and state election commission. CM cannot interfere in the choosing of the members of the ministers. तो फिर पॉलिटिक्स हो जाएगा ना. So CM governor is the constitutional head of the state. He is the constitutional head of the state, not head of the government. Head of the government politics. Head of the state is neutral. He should not interfere in the politics. So here CM cannot advise the governor, इधर तक सही है, regarding the appointment advocate general but members of the state public service commission. गलत है ना? है ना? So here क्या पूछ रहा है हमको? इनकरेक्ट वाला पूछ रहा है. देखो, so ये सही है, फिर इनकरेक्ट. Then when no party gets a majority in the elections, governor exercise his own discretion and appoint as a chief minister. सही है ना? He can use his discretionary powers when no party is forming government. So he can correct. ये correct है हमको, but we have to choose incorrect वाला. Then a person not belonging to either house of, that is the legislative assembly, council, can also be appointed as the chief minister. Yes or no? But within 6 months he has to be member of the इधर लोकसभा आई मीन स्टेट लेजिस्लेटिव असेंबली और लेजिस्लेटिव काउंसिल से रहना चाहिए. इधर एक प्रोविजन ऐड करना है, इधर ये मिस हो रहा है. देखा ना? विद इन 6 months ये ऐड करना जरूरी है इधर, बट ऐड नहीं किया तो क्या बोल सकते हैं हम? गलत. बाय विच कॉन्स्टिट्यूशनल अमेंडमेंट एक्ट इट हैज बीन इंट्रोड्यूस्ड? 91st कॉन्स्टिट्यूशनल अमेंडमेंट एक्ट ऑफ 2003, ये बहुत बार प्रीलिम्स में आया था. So without the member of the state legislative assembly and council can be appointed, but within 6 months he must be elected or nominated either of the house. Elected भी कर सकते हो, nominated भी कर सकते हो. समझ हो रहा ना? So कौन सा 91st कॉन्स्टिट्यूशनल अमेंडमेंट एक्ट ऑफ 2003. ठीक है ना? कुछ तो कुछ लिखो भाई. ठीक है ना? Then fourth is the governor can remove the chief minister at any time. Yes or no? He can remove, but council of minister as long as they are having the majority, then no problem. तो इसमें कौन सा आपको गलत लग रहा है? हाँ? So हमको पहले स्टेटमेंट सही है वो निकाल देते हैं. ये स्टेटमेंट सही. देन और क्या बोला था? ये भी सही. रॉन्ग वाला कौन सा हमें इनकरेक्ट देखना पड़ेगा ना इसको, फिर ये स्टेटमेंट को. तो दो ऑप्शंस रॉन्ग है. तो कौन सा बता सकते हैं हम इधर? ओनली 2. दो ऑप्शंस रॉन्ग. यही है ना? हेलो सर. बी इज अवर आंसर. ट्राई टू राइट दीज पॉइंट्स. 91st कॉन्स्टिट्यूशनल अमेंडमेंट एक्ट 2003. हाँ सर. ये पर्सन नॉट बिलोंगिंग टू ईदर हाउस ऑफ द लेजिस्लेटिव असेंबली एंड काउंसिल also be appointed as the chief minister. Yes, but within the 6 months he has to be member, right? Either elected or nominated. वो provision रहना चाहिए ना. That is added by the 91st Constitutional Amendment Act 2003. इसके बाद ये ऐड करना जरूरी है. Then this statement is correct. हाँ, otherwise wrong है ना. See, मैं क्या बोल रहा हूं? He can be out. I mean with लेजिस्लेटिव असेंबली, लेजिस्लेटिव काउंसिल बिना मेंबर भी हो सकते हैं, बट विद इन 6 मंथ्स होना जरूरी है ना. ये प्रोविजन इधर रहना पड़ेगा ना. 91st कॉन्स्टिट्यूशनल अमेंडमेंट 2003 बोल रहा है उधर देखो. तो फिर हाउ तो इसमें डालना पड़ेगा ना. कौन डालेगा? मुजफ्फर जाएंगे. ठीक है ना. सो देख लो. देन सर जनरल नहीं उधर ही मस्ट बी. नहीं वो ब्रैकेट में विद इन 6 मंथ्स ही हैज टू बी इलेक्टेड. ठीक है ना. सप्लीमेंटरी नहीं, ही हैज टू बी इलेक्टेड और नॉमिनेट. हाँ क्या? हाँ हाँ चीफ मिनिस्टर. बट क्या बस, अरे भाई अच्छे से बात कर. ठीक है ऐसा नहीं. विद इन द 6 मंथ जो बोल रहा हूं रिस्पेक्ट दे के बात कर. ठीक है ना. मैं क्या बोल रहा हूं? तो हिंदी में बोलो इंग्लिश में बोलो तो वही तो फर्क होता है ना. रिस्पेक्ट वाला कोई हिंदी में बोलो तो बदल जाएगा क्या? आप बताओ. चीफ बट विद इन 6 मंथ्स ही हैज टू बी इलेक्टेड और नॉमिनेटेड. ये प्रोविजन साइड में रहना जरूरी है. दैट्स व्हाट आई एम कन्वेइंग. देन इट विल बी करेक्ट. Otherwise it is a semi information this one. Are you getting my point? आज जाके एक बार देखो फिर भी आपको लगा देना. you come and ask me. विद इन 6 मंथ्स ये प्रोविजन साइड में रहना चाहिए. नहीं हो तो गलत. दैट्स व्हाट आई एम कन्वेइंग. इन केस इधर है तो सही है. आपका आंसर 100% सही. दैट्स व्हाट आई एम कन्वेइंग. No, yeah, in general, he can remove any time. तो ऐसा बोलो तो पूरा प्रोविजन को इधर ऐड करना पड़ेगा फिर. ठीक है. बट इधर इन दिस केस 91st कॉन्स्टिट्यूशनल अमेंडमेंट 2000 सब्सटैंशिएट किया था. देखो उधर एक पॉइंट देखो. देन यू कैन आस्क मी. ठीक है ना. एक बार जाके देखो. देन यू कैन आस्क मी बिकॉज दिस पॉइंट एडेड बाय दिस एक्ट. दैट्स व्हाट आई एम कन्वेइंग हियर. ठीक है ना. देन फिर भी आपको डाउट आया तो मुझे पूछ सकते हो आप. ठीक है ना सर. यस रिमूव सही है. बट वो जनरल में सही है. बट एज यू सेड जगदीश, एज लॉन्ग एज ही इज हैविंग रिटेनिंग मेजॉरिटी, तो फिर क्यों करेगा? यानी ऑल द टाइम नहीं करेगा ना. सो 2 स्टेटमेंट क्या बोल रहा था? So 2 statements wrong. Incorrect वाला है ना, 2 statement correct. D, B, B, yes, you are right. अच्छा सा पढ़ के आ जाओ. ऑनलाइन स्टूडेंट्स वो रिस्पॉन्ड नहीं होता ऑनलाइन वाला, ठीक है. देन if the president of India exercise his power as provided under article 356 of the constitution in respect of a particular state, then so article 356 deals with president rule. So president rule also can be called as, president rule को क्या बोल सकते हैं मुकेश? स्टेट इमरजेंसी. वेरी गुड. और क्या बोल सकते हैं? कॉन्स्टिट्यूशनल इमरजेंसी और गवर्नर रूल. हम बोल सकते हैं ना? बोल सकते हैं, यस और नो? सो प्रेसिडेंट रूल वी आर डिक्लेयरिंग अंडर आर्टिकल 356. यही है ना? अंडर आर्टिकल 356. And why we are calling state emergency? Because it is imposed in the, declared in the state level, at the state level. That's why we are calling state emergency. Why we are calling constitutional emergency? Whenever the state government violating the constitutional provisions, then President of India declare you are violating the constitutional provision. That's why I am declaring constitutional emergency. है ना? Governor rule. गवर्नर को जनरली गवर्नर विल बी रिपोर्टिंग टू द प्रेसिडेंट, देन प्रेसिडेंट उनको पावर देगा आपको एडमिनिस्टर करो, आई मीन ये चलाओ, ठीक है ना. सो इन दिस केस वी आर हैविंग 356, 365, बट प्रेसिडेंट ऑफ इंडिया इंपोज हियर 356 नीचे ही डालेगा. 356 डील्स विथ व्हेनेवर द स्टेट गवर्नमेंट है ना कॉन्स्टिट्यूशनल प्रोविजंस को वायोलेट कर रहा है, देन प्रेसिडेंट रूल. And if state government is not complying with the central government directives, again 356 आ जाएगा. This is the central government directives. Here constitutional provisions. Try to understand here. 356 is constitutional provisions. This one when the state government not complying with the directives of the central government. Then किसका साथ आ जाएगा? Under article 356 प्रेसिडेंट ऑफ इंडिया इंपोज ये प्रेसिडेंट रूल डालेगा, ठीक है ना. कल एग्जाम में आ जाएगा प्रेसिडेंट रूल, स्टेट इमरजेंसी, कॉन्स्टिट्यूशनल इमरजेंसी और गवर्नर रूल. इतना नाम बोल सकते हैं इसको, ठीक है ना. नाउ क्या बोल रहा था? एक्सरसाइज बोर्ड. द असेंबली ऑफ द स्टेट इज ऑटोमेटिकली डिसॉल्व्ड. यस और नो? ऑटोमेटिकली डिसॉल्व्ड नहीं होता है. इवन प्रेसिडेंट ऑफ इंडिया इंपोज्ड प्रेसिडेंट रूल that has to be approved in the parliament. फिर पार्लियामेंट में करना पड़ेगा. समटाइम्स व्हाट हैपन, गवर्नर किस रिपोर्ट बायस्ड रिपोर्ट देगा तो पार्लियामेंट देगा, इमीडिएट बता दिए तो सही नहीं है ना. फिर ऑटोमेटिकली डिसॉल्व्ड इज रॉन्ग थिंग. बम्बई केस में भी बताया था, केस बना बम्बई केस, याद रख लो. सो ये स्टेटमेंट गलत है. देन हाँ वो हो जाएगा, बट इधर क्या बोल रहा है आपको? असेंबली ऑफ द स्टेट, ठीक है ना. द पावर्स ऑफ द लेजिस्लेचर ऑफ दैट स्टेट शैल बी एक्सरसाइज्ड बाय और अंडर द अथॉरिटी ऑफ द पार्लियामेंट. यस, ड्यूरिंग प्रेसिडेंट रूल पार्लियामेंट इज द पावरफुल. देन आर्टिकल 19 इज सस्पेंडेड इन दैट स्टेट. आर्टिकल 19 सस्पेंडेड ड्यूरिंग द नेशनल इमरजेंसी, नॉट हियर. प्रेसिडेंट रूल में नहीं है ना. आर्टिकल 358, 359 उधर आ जाएगा. आर्टिकल 358 सस्पेंड, आर्टिकल 19 ऑटोमेटिकली इन द नेशनल इमरजेंसी. बट व्हेन इट कम्स टू हियर प्रेसिडेंट रूल में कुछ देना लेना कुछ नहीं है, ठीक है ना. ये भी निकाल दो. द प्रेसिडेंट कैन मेक लॉज रिलेटिंग टू द स्टेट. द लॉज मेड बाय द पार्लियामेंट, नॉट द प्रेसिडेंट. प्रेसिडेंट क्या करेगा? पार्लियामेंट क्या करेगा? जनरली प्रेसिडेंट ऑफ इंडिया को देखो आप, यू कैन मेक द लॉज, बट रियल पावर कौन है? पार्लियामेंट. सो हियर पार्लियामेंट शुड बी आंसर, पार्लियामेंट रहना चाहिए इधर. सो हमारा गलत क्या क्या था मां? ये गलत, ये गलत. राइट थिंग्स क्या था? ये भी गलत है. बी इज आवर आंसर. ऑनलाइन स्टूडेंट्स समझ हो रहा है ना? देन कंसिडर द फॉलोइंग स्टेटमेंट रिगार्डिंग गवर्नर ऑफ ए स्टेट. बताओ मैं इधर. गवर्नर होल्ड्स ऑफिस ड्यूरिंग द प्लेजर ऑफ द प्रेसिडेंट. यस और नो? See here, President of India, Governor, both are constitutional head of the state. Both are independent in there. At the central level, President of India, country level, here state level, Governor. Both are head of the state, not head of the government. Try to understand. कल एग्जाम में आ जाएगा गवर्नर इज द हेड ऑफ द गवर्नमेंट. नो, गवर्नर इज द हेड ऑफ द स्टेट. He holds office during the pleasure of the President of India, right? Then he is an agent of the central government. In general, he is the agent. Excuse me here, भाई थोड़ा चुप रहो, नहीं तो otherwise you can go outside. ठीक है ना? Because you are inter class ले रहा हूँ ना भाई. Try to understand. Generally, I told them so not to sit in the class. आपको मैं बोला था, already बोला था मैं, क्लास में आप नहीं बैठना दो मैथ स्टूडेंट, because whenever we are taking discussion, it disturbing our class. Try to understand. Because of you, other people should not be affected. ठीक है ना? Now, he is an agent of the central government. So, whenever any decision regarding with the state government, who is passing to the central level? Governor is the agent. Agent is not subordinate post here. We are not talking about the subordinate. Because he is an independent, constitutional head. But you are saying in that context, in general that is the true, but इधर क्या बोल रहा है, governor of a state बारे में particular पूछ रहा है. So a statement को निकाल दो. Then, as per the Sarkariya Commission recommendation, the governor should not be removed from his office before completing their 5-year tenure, except in rare and compelling circumstances. Sometimes committee reports also पूछ रहा है. Rajendra committee, Sarkariya Commission report. So a statement उसमें recommend किया. First point only in the Sarkariya Commission recommendation. ठीक है ना? ये point सही है. Then there are provisions laid down in the constitution for the manner in which the governor and the state must engage publicly when there is a difference of opinion. So here there are provisions. बोलो, there are no provisions. Try to write that point. There are no provisions. So there are no provisions laid down, बोलो तो सही हो जाएगा. Otherwise this is also wrong thing. This is right, ये wrong. कितना स्टेटमेंट सही है? मैं इधर इनकरेक्ट पूछ रहा था क्वेश्चन में, देखो इनकरेक्ट. हाउ मेनी इनकरेक्ट? ओनली 2. ऑनलाइन स्टूडेंट्स? यस सर. ही इज एन एजेंट, बट एज पर द एजेंट बोले तो इधर सबऑर्डिनेट हो जाएगा. एज पर द कान सेंटर इन द, बट एज पर द कॉन्स्टिट्यूशन ही इज द इंडिपेंडेंट, is the constitution head, but he is acting, but उनका काम उनका सप्लाई करने के नहीं है ना. एज ए कॉन्स्टिट्यूशनल हेड बैठा हुआ है, नॉट टू पास इंफॉर्मेशन टू द सेंट्रल. उनका पोस्ट क्या है? इंडिपेंडेंट है उधर. जनरल जो पॉइंट है आप सही बोल रहे हो, मैं भी बोल रहा हूँ. ही इज द एजेंट ऑफ द सेंट्रल गवर्नमेंट इन जनरल. आई एम ऑल्सो एक्सेप्टिंग दैट. आई एम नॉट डिनाइंग दैट फैक्ट, बट हेड ऑफ द रिगार्डिंग गवर्नर ऑफ ए स्टेट है ना. Next, which of the subsequent positions are occupied by the chief minister of a state? बताओ. So state planning board and नीति आयोग में मेंबर है ना. नीति आयोग बोले तो क्या, नीति बोले तो क्या? नेशनल न्यूट्रिशन. ठीक है क्या ना सर. चेयरपर्सन ऑफ स्टेट डिजास्टर मैनेजमेंट अथॉरिटी. सो एट द सेंट्रल लेवल हु इज द हेड ऑफ द डिजास्टर मैनेजमेंट अथॉरिटी? सो क्या हो जाएगा आंसर? ऑल द अबव. डी इज द आंसर. देन दिस वन 35 लास्ट क्वेश्चन. मेरा क्वेश्चन लास्ट, ठीक है ना. कंसिडर द फॉलोइंग सब्जेक्ट्स हियर. How many of the above subjects come under the union list? So बताओ पहले, how many subjects we are having? Union, state, concurrent, residuary नहीं है. ठीक है ना. यूनियन में कितना है मां? 98 सब्जेक्ट. स्टेट में 59. हियर नो यूपीएससी ले पूरा 52. ये साल देर ऑन अटेम्प्ट 2026 में. ठीक है ना. सो यूनियन सब्जेक्ट, state subject, concurrent. So if there is a conflict between the union and the state, कौन सा prevail हो जाएगा? Union. In case there is a conflict between the state and concurrent, concurrent will be prevailing. Right? Now, residuary powers means what? So residuary powers which are not mentioned union list, state list, concurrent list, it is given to the पार्लियामेंट। समझ हो रहा ना? 1935 एक्ट में किसको दिया था? वाइसराय ऑफ इंडिया, वाइसराय को दिया था ना। 1935 एक्ट में किसको दिया था? गवर्नर जनरल को बोलते हैं ना, वो प्रीलिम्स में आया था। 1935 एक्ट में रेसिड्यूरी पावर्स वर गिवन टू द गवर्नर जनरल, बट व्हेन इट कम्स टू हियर पार्लियामेंट, दिस प्रोविजन रेसिड्यूरी पावर्स हम सेंट्रल को दे रहा है ना, पार्लियामेंट को, वी हैव ड्रॉन फ्रॉम द कैनेडियन कॉन्स्टिट्यूशन, है ना, कैनेडियन कॉन्स्टिट्यूशन से लिया है। सो 98, 59, 52 समझ हुआ ना? एनी डाउट हियर? सो कंकरेंट में क्या किया था आपको? सर्टेन सब्जेक्ट 5 सब्जेक्ट 42nd कॉन्स्टिट्यूशनल अमेंडमेंट एक्ट 1976 ट्रांसफर कर दिया था, वो अलग बात है। हियर बैंकिंग इज द यूनियन सब्जेक्ट और स्टेट सब्जेक्ट? यूनियन सब्जेक्ट। एग्रीकल्चर स्टेट सब्जेक्ट, पब्लिक हेल्थ स्टेट सब्जेक्ट, देन प्रिजन स्टेट सब्जेक्ट। क्या हो जाएगा आपका आंसर हियर? यूनियन लिस्ट कौन सा है? ओनली वन, ओनली वन। जब बोल रहा हूं ना एग्रीकल्चर बोल तो स्टेट में लिख लो, स्टेट, पब्लिक हेल्थ स्टेट, प्रिजन स्टेट, बैंकिंग, कम्युनिकेशन, अदर थिंग्स क्या हो जाए? सेंट्रल लिस्ट हो जाएगा। यूनियन लिस्ट और सेंट्रल लिस्ट सेम, ठीक है ना? एनी डाउट? हाँ सर, हाँ क्या क्या? हाँ 1935 में ये प्रीलिम्स में आया था, द रेसिड्यूरी पावर्स गिवन टू द गवर्नर जनरल। पहले क्या कर रहा था? जिन्ना, जिन्ना बारे में पता है ना? जिन्ना बोल रहा था रेसिड्यूरी पावर स्टेट को देना है, बट नेहरू क्या कहता? नहीं नहीं नहीं, गवर्नर जनरल को देना है। समझो ना, इंटरलिंक करो, मेंस में ऐसा ही होता है, ठीक है ना? बट आफ्टर कॉन्स्टिट्यूशन मेकिंग क्या किया था हमको? दिस रेसिड्यूअल पावर्स हमको स्टेट सेंट्रल को दे रहा है। दिस प्रोविजन है ना, ये दिस काइंड ऑफ रेप्लिकेशन वी हैव टेकन फ्रॉम द कैनेडियन कॉन्स्टिट्यूशन। इंडिया कैनेडिया कॉन्स्टिट्यूशन बहुत लिया है ना, वो पॉइंट लिख लो उधर, ठीक है ना? देन द पार्लियामेंट ऑफ इंडिया acquires the power to legislate on any item in the state list in the national interest if a resolution to that effect is passed by the, just before mention किया था क्या मां? राज्यसभा विथ स्पेशल मेजॉरिटी, है ना? देखो इधर क्या हो जाए? लोकसभा बाय सिंपल मेजॉरिटी ऑफ द टोटल, लोकसभा, राज्यसभा सिंपल मेजॉरिटी, राज्य मेजॉरिटी ऑफ नॉट लेस देन 2/3 ऑफ द मेंबर्स, ये हो जाएगा डी, ठीक है ना? बिकॉज बहुत बार आया था एग्जाम में। सो जनरली पार्लियामेंट इज मेकिंग लॉस ओवर द पार्लियामेंट, आई मीन सेंट्रल गवर्नमेंट मेकिंग ओवर द सेंट्रल सब्जेक्ट, स्टेट गवर्नमेंट ऑन द स्टेट सब्जेक्ट, है ना? इन नॉर्मल सिचुएशन मींस दे आर इंडिपेंडेंट। फेडरल स्टेट में क्या है? इंडिपेंडेंट। सेंट्रल गवर्नमेंट हैविंग पावर्स, स्टेट गवर्नमेंट इज हैविंग। But when it comes to extraordinary situation in 5 conditions like national emergency, president rule, financial emergency, under Article 312 and international convention and all agreements, in this case क्या हो जाएगा? The central government is having more power than the states, unilateral power. In extraordinary situation अंबेडकर बोला था, but nowadays what we are doing? We are encroaching or trespassing over the state laws, ठीक है ना? ऐसा नो सर, मुकेश थक गया क्या? बाबू सर को बुलाओ ना। हाँ? मुझे रूम में भी सुबह सुबह खा लेते हो, इधर भी खा लेते हो, हाँ? आना स्टूडेंट्स, ना सर, नहीं तो मैं पूरा ले लूंगा, फिर बाबू सर भी लेना चाहिए ना। बाबू सर लेगा तेरे। आना स्टूडेंट्स, इफ यू आर हैविंग एनी डाउट, बिकॉज नेक्स्ट टेस्ट वी आर हैविंग ज्योग्राफी आल्सो, रिमेनिंग क्वेश्चंस विल बी डेल्ट बाय दी बाबू सर। हाँ? तो नेक्स्ट ज्योग्राफी नहीं करना है, एनवायरमेंट नहीं करना है, इकोनॉमी नहीं करना है। हाँ तो फिर सर ब्रेक दे दूं क्या? यू वांट ब्रेक? चलो 5 मिनट 10 मिनट्स ब्रेक लेते हैं जब तक बाबू सर आ जाएगा, ठीक है ना? आना स्टूडेंट्स, प्लीज वेट, बिकॉज थोड़ा ब्रेक लेते हैं 5-10 मिनट, देन वी विल बी कंटिन्यूइंग द सेशन। बाबू सर विल बी टेकिंग, ठीक है ना? थैंक यू। सो सीसेट बच्चा जो हमारा टेस्ट सीरीज का बच्चा, यू पीपल आर नॉट रिस्पॉन्डिंग, क्या हो गया आपको?
पीडीएफ मिल गया तो नहीं आ रहा है क्या? आने स्टूडेंट्स? नो, ठीक है, आप कर दो।
Okay, students, we'll continue with the discussion. What is the last question that was discussed? 35. All right, so we'll move to the next question, question number 36. Have a look into the question number 36. Again, very important topic. Question number 36 is related to center-state relationship. If you see center-state relationship, this is a topic every year there's a question from what is called as the center-state relationship. Look into question number 36 and then we'll proceed with the things. The Parliament of India acquires the power to legislate on any item in the state list in the national interest if a resolution is passed. So we know that there is something which is called as division of powers, or there is something which is called as a federal political system, where certain powers are given to the state authorities, certain powers are given to the center, certain powers are given to the parliament, certain powers are given to the state legislature. So which is elaborated in the Schedule 7 of the Constitution. I think you have a basic idea as to what is Schedule 7. Schedule 7 clearly gives us an idea what is the power of the parliament and what is the power of the state legislature. So if you look into Schedule 7 of the Constitution, whatever item in the union list, only the parliament can make laws. Whatever an item is in the state list, only the state legislature can make laws. There are three lists, you know that, list 1, 2 and 3, where list 3 is what is called as the concurrent list, where both the parliament and the state legislature can make laws. But one thing that you have to keep in your mind is that while under no circumstances, whatever is a power that is given to the parliament, the state legislature can make laws. Can the state legislature make laws on the items where the parliament can make laws? It is definitely not possible. But under the Constitution of India, under certain circumstances, the parliament can make law on an item in the state list. That is possible. Few exceptions has been given, and one such exception is Article 249 of the Constitution. What Article 249 is saying? Article 249 is allowing the parliament to make a law on an item in the state list, but with a condition. What is that condition? That if Rajya Sabha gives a permission first by a resolution, first a proposal has to be introduced, and for this proposal, for the parliament to make a law on item in the state list, a resolution has to be passed, and it has to be approved by whom? It has to be approved by the Rajya Sabha. So now the question is, what is the majority with which the Rajya Sabha has to give the approval, so that the parliament can make law on an item in the state list? What is the majority here, Mukesh? Special majority. But what is the special majority? There are different types of special majority. The special majority in this case is not less than 2/3 of the members present and voting. Okay, so what is the option here? The Rajya Sabha by a majority of not less than 2/3 of its members present and voting. So the right answer is what? The right answer is option D. D is the right answer. Okay. So Article 249 is very important. Rajya Sabha has this power, that is important. The majority is important. So any of these things can be asked in the examination. Come to next question, question number 37. With reference to India, consider the following statements. Statement 1. When a prisoner makes out a sufficient case for parole. So do you know what is this parole? Parole means that depending upon the obedience of the prisoner, or depending upon his conduct, so certain element of leniency can be shown. So temporarily he can be released from the jail, and he has to again come back to the jail. That is basically what is parole. And today the prisoners in our country can be released on the grounds of what is called as parole. But what the question is asking, when the prisoner makes out a sufficient case, suppose that a prisoner is having a good conduct, he has conducted himself very well in the prisoner, he has been kind to others, he has been doing his duty. So the question is asking, is it a matter of his right? So can he demand this parole as a matter of right? So today there is no legal provision where he can demand this as a matter of right. So this is not mandatory for the state to send him on parole. That is not mandatory. Okay. So here, because the question is asking mandatory, that is not right. Now the state government have their own prison release, on parole rules. Is this statement true? Now, even for students who are not having an idea, so the prisons and the regulation of the prisons is an item in the state list. So state can make a law. So of course, when the state can make a law, they can have their own rules. Okay. So this particular statement is true. So which of the statements given above are correct? What is the correct answer? Option B. Only 2 only is the correct answer. In case of furlough, it is a matter of right. In case of furlough, when it is a matter of right, so furlough is a different scenario. So furlough is not on the basis of good conduct and other things. Furlough in general for the person to establish social ties with his family members. Suppose an individual is in prison for 10 years. 10 years you cannot put him in jail. So every now and then he has to be sent to his home for yearly one month or something, so that the social ties is not broken up. So that is a matter of right, but not parole. Yes? It is on the basis of his conduct. If the individual is conducting himself well in the jail, depending on his conduct, some element of leniency can be shown, but it is not mandatory. If the government want, they can allow. If they do not want, they will not allow. So it is the discretion of the government. Yes, depending upon the government wish. Come to the next question, question number 38. Consider the following statements regarding governor. This year, governor, mark my words, governor is a very, very important topic. Online students also. Governor question is definitely going to come this year because there's a lot of controversy that is going on governor. So try to look into the constitutional provisions of the governor. Okay, statement 1. The executive power of the state is vested in the governor. Is it vested in the governor? The union executive power is vested on whom? President. So here it is there in the governor. So it is executive power is vested in the governor. This is true. The governor has a constitutional discretion for the reservation of bill for the consideration of the president. So can someone tell me under which article the governor can exercise the power whenever a bill is presented to the governor? First tell me what are the options. I'll give you the article, article 200. Remember this article. What are the options? He can assent, no problem. That is the best thing that he can do. He can withhold, very good. He can send it for reconsideration, very good. Very good. He can also reserve it for the consideration of the president. He can reserve it for the consideration of the president. Of the 4 options, try to understand this. Reserving it for the consideration of the president is his discretionary power. He can exercise that at any time. Whichever bill he wanted to reserve, he can reserve it for the consideration of the president. So that is his discretionary power, any type of bill. So any type of bill is his discretionary power. He can reserve it for the consideration of the president. But under the Constitution of India, in one case he has to definitely reserve the bill. In other cases it is discretion, but in one case he has to definitely reserve the bill for the consideration of the president. When any bill is trying to take away the power which is guaranteed or which is given to the High Court concerned in that particular state. In all other cases, what it is discretionary power. Okay, so try to remember this. Very, very important. Now tell me, whenever the governor reserves a bill for the consideration of the president, if the governor is reserving, then it goes to the president. Then who will determine the fate of this particular bill? The president will determine the fate of this particular bill. So once he reserves it, then it goes to the president under Article 201. So under Article 201, what the president can do once a bill is reserved? The president can give the assent, then he can withhold the assent, and he can send it for reconsideration. But here, the president can send it for reconsideration as many times as he wants. There is no restriction as to how many times the president can send it for reconsideration. So now with that information come here. The governor has constitutional discretion for the reservation of a bill for the consideration of the president. Is it true? It is of course true. So what is the answer here? Which of the statements given above are correct? Option C. Both are the correct answers. Come to the next question. Come to the next question. The privileges of the state legislature extend to both the governor and the advocate general of the state. So we already discussed about the privileges, so I'm not going much into this. Can you tell me the relevant articles? Please wait. Do not talk in between, okay? So it is unnecessarily disturbing the class. So you are here to listen, you are not here to teach me. So the purpose, I do not know what is your purpose, but I think the purpose why the students are coming here is to learn from the teacher, not to teach the teacher. If you have the answer, just keep it with yourself. I'm not asking, expecting the answers. Let the other students listen. Do not unnecessarily disturb the momentum in the class. Okay. So what is statement number 1? The privileges of the state legislature extends to both the governor and the advocate general of the states. So the privileges is given under which article? Just now we had this discussion, Mukesh. Which article? Article 105 for the members of the parliament and Article 194 for the state legislature. So the privileges of the state legislature, which is given under Article 194. Under Article 194, does it extend to both the governor and the advocate general? Does it extend to the governor the privileges? It is not to the governor, but yes, to some extent it is to the advocate general, but overall the statement is not right. So the statement is wrong. Okay, so come to statement number 2. The state legislature can punish the members as well as outsiders for the breach of its privilege or contempt. Is that true? Does the state legislature has a power to punish its members for the breach of parliamentary privilege? Can they punish? But the important point here is, can the state legislature punish the members? Members means even the MLAs or MLCs as well as the outsiders. Can they punish both? Even the insiders as well as the outsiders? They can of course punish the outsiders. Definitely they can punish the outsiders. In the history of India, many outsiders has been punished already. There are a number of cases also on that. But my other question is, can they punish the insiders also? The members of the parliament, can they be punished for the breach of parliamentary privilege? Can the members of state legislature, can themselves be punished? It is very much possible. So the parliamentary privileges, whenever who is violating it, not only to the outsiders, but also to the insiders as well. Okay, so this is definitely true. I'm not discussing much about the privileges because we have discussed enough about the privileges. Come to statement number 3. The members of House can refuse to appear as a witness in the court when the state legislature is in session in respect of civil cases. Is it possible? So whenever the state legislature is in session, can the MLAs or the MLCs, can they be summoned by the court to be a witness? So as per the privileges that they exercise, not everything is mentioned in the constitution, some privileges also by conventions. As per the conventional practice today, 40 days before the session and 40 days after the session, they cannot be summoned by the court. But the key word here is in case of civil cases. This privilege does not extend in case of a criminal case. But here the question is what? Here the question is civil case. So of course they exercise this privilege. So this is true. Which of the statements given above are correct? What are the correct statements here? Statement 1 is wrong. Statement 2 and statement 3 is correct. So the answer would be what? The answer is option B. It is a wrong thing. So this privilege extends only in case of civil cases. That is why I encircled that. That is a very important thing that you have to remember. Come to the next question. Question number 40. With reference to the State Legislative Council, consider the following statement. Statement 1. The governor of the state acts as an ex officio chairman. So in case of the parliament, in case of Rajya Sabha, who acts as ex officio chairman? The vice president. So in case of the states, not many states is having a legislative council. So can someone tell me how many states in India do have legislative council today? Today, presently. Bihar, UP, correct. Then Maharashtra, correct. In the south, you can remember 4 states including Maharashtra, all the nearing states. Andhra Pradesh, Telangana, and then you have Karnataka, Maharashtra. And then in the top, you have Bihar and Uttar Pradesh. Okay, so these are the 6 states that is having. Not all the states are having. Suppose let us assume a state is having a legislative council. So who is going to preside over the legislative council? So he or she has to be elected from that particular house. Okay, so that is very, very important. So the governor of the state acts as the ex officio chairman of the, that is wrong because he or she has to be elected from that particular house. And with what majority he or she has to be elected? They have to be elected by simple majority. Very good, Mukesh. Elected by simple majority. Elected by simple majority. Its maximum strength is fixed at 1/2 of the total strength of the state legislative assembly. What is the maximum strength in the legislative council is established? A range is given in the constitution. Who can tell me the range? What is the range? It shall not be less than 40 and it shall not be more than 1/3 of the size of the legislative assembly of that particular state. Okay, so range is between 40 and it shall not be more than 1/3 of the size of the legislative assembly. This is the range. Okay, so it has to be the range legislative assembly. So this is basically the range. So here it is saying 1/2, so this particular statement is wrong. It can be established and abolished by the respective state legislative assembly. So legislative assembly has the power to abolish the legislative council. So who has the final authority? The parliament. Although the parliament can do that only on the basis of resolution that is passed by the legislative assembly, not by Rajya Sabha, by the legislative assembly. But the legislative assembly does not have the power to do this. And what is the majority by which the legislative assembly has to pass a resolution? Both for creation as well as abolition of the legislative council. They have to pass it with the special majority. So once the legislative assembly passes a resolution with special majority, they have to pass a resolution. And once they pass a resolution, then the parliament will make a law. So it is only based on the parliamentary law the legislative assembly can be abolished or created. So okay, it can be established or abolished. State legislative assembly, that is not possible. By the parliament would be the appropriate answer. So what is the right answer here? Yes, what is the right answer? Option D, because none of the statement is correct. It is asking for correct or incorrect statement. Correct statement. So the answer is option D. Come to next question, question number 41. Both for abolition and creation. Special majority in the legislative assembly. Then the parliament has to make a law. Come to the next question, question number 41. So we already discussed this. What is the answer? The question is, consider the following statements. Which of the states mentioned above have a bicameral legislature? So what do you mean by bicameral legislature? Bicameral legislature means two houses. In case of states, two houses means legislative assembly as well as the legislative council. So what is the answer here? Which of the states has this? Andhra Pradesh is there, Madhya Pradesh it is not there, Maharashtra is there, Karnataka is there, Tamil Nadu is there. What is the answer? The answer is? Okay, so Tamil Nadu does not have. Then what is the answer? 1, 3 and 4. So what is the answer? Andhra Pradesh has it, Maharashtra has it, Karnataka has it. What is the answer? 1, 3 and 4. So option D is it. D is the right answer. So you can note down the other states also. Other states are Telangana. We already discussed that. And then you have Bihar. And then you have Uttar Pradesh. So these are the 6 states today which has got these things. Come to the next question. In which areas do the powers of the state legislative council equate to that of the state legislative assembly? That means the question is very simple. Where there is equal power to both legislative assembly as well as the legislative council. That's the question. Do they have equal powers? Introduction of money bills, do you think that they have equal powers? Because in case of money bills, there is no equal power, because money bill can be introduced where? Only in the legislative assembly, not in the council. And also that once it is passed by the assembly, the council can delay it by maximum of what? 14 days. So there is no equal power. So this is definitely not the case. Removal of council of ministers by no confidence motion. So both in the parliament as well as in the state legislature also, the no confidence motion can be introduced there in Lok Sabha, here in legislative assembly. Okay. So here there is no equal power. That is also wrong. Approval of ordinances issued by the governor. So whenever the ordinance is issued by the governor, it has to be placed in front of both the houses or one house. If there are two houses, it has to be placed before two houses. And what is the time limit within which they have to give the approval? Once it is placed in front of both the houses, both the houses have to give the approval within which point of time? Both houses have to give the approval within 6 weeks. So this is also very important. They have to give approval within 6 weeks. Once it is placed, so this is again very important. So within 6 weeks they have to be placed. And if there are two houses, it has to be done. So here it is correct. Approval of ordinances issued by the governor. 4. Enlargement of jurisdiction of the State Public Service Commission. Now if you look into the constitution itself says these are the functions that the State Public Service Commission has to perform. These are the functions UPSC has to perform. But that's only an indication. If their scope, if their function is to be expanded, it can be expanded by way of a law. In case of UPSC, it can be expanded by way of law made by the parliament. In case of state legislature, sorry, in case of state public service commission, it can be expanded by way of a law made by the state legislature. So this is definitely true. And in case if there are two houses, both houses have to make that law. Enlargement of jurisdiction of the state public service commission. So this is definitely true. So what is the answer here? So the answer is option D. Very good. So D is the right answer. Okay, so come to the next question. So come to the next question, question number 43. Examine the statements concerning the lapse of bills upon the dissolution of the legislative assembly. The same principle as I already said. If the bill has got any type of relation to the legislative assembly, it is going to lapse. And the exception would be the governor is involved or the president is involved. Because the governor can also reserve the bill for the consideration of the president also. That's the exception. Otherwise, in all the cases, it is going to lapse. So examine the statement concerning the lapse of bills upon the dissolution of the legislative assembly. Online students, I hope you are following it. So you can put your doubts if you have any doubts. Okay, so just try to just keep following the things. Which one? I'll explain that later, okay? So after the class is over, you ask me because it's a very long concept. You can ask me after the class. Just to not to take the time of all the students. Okay, so see here. A bill passed by the assembly but pending in the council. Will it lapse? Does it have a relation to the assembly? So it has relation to the assembly. So it is likely to lapse. So this will lapse. A bill pending in the council but not passed by the assembly. That means what? That means it is introduced in the council and it is in the council. In the meantime, the assembly has lapsed. So it has got a relation to the assembly. It has no relation to the assembly, so it will not lapse. A bill passed by the assembly, and here it is an unicameral legislature. There's only one house. The bill passed in the assembly or passed by both the houses in case of bicameral, but returned by the governor for its consideration. Will it lapse? It will not lapse because the governor is already there. A bill pending in the assembly. A bill pending in the assembly, whether originating in the assembly or transmitted by the council. Will it lapse on dissolution of Lok Sabha? It will lapse because it has the relation there. Okay, so this will lapse. So what is the answer? What is the correct answer here? Only 2. Option B is the right answer. Very, very important area, both in case of parliament and the state legislature. Students who are not understood that, you can ask me after the class, this particular question. After the class, you come and ask me, okay? Correct, but conceptually, maybe you remembered or you memorized, but that is not going to help, okay? So you'll have to just remember the concept that I said. You can easily solve these questions. Okay, you can memorize also. It is up to you. But if you remember in this way, there's a possibility that even if you forget, you can answer the questions. Come to the next question, question number 44. Online students, please keep following. So look into question number 44. Consider the following statements regarding sessions of state legislature. So we are going to see with regard to the sessions of the state legislature. Statement 1. Adjournment sine die means break in the sitting of the state legislature for a definite period. So there's a difference between adjournment and adjournment sine die. So who will do this adjournment and adjournment sine die? In both the cases, in case of adjournment or adjournment sine die, in both the cases it is done by the presiding officers. In both the cases, who does that? Presiding officer of that respective house. But adjournment, we have seen that what is adjournment? Adjournment is a definite break. What we have seen adjournment is a suspension of the house for a specific time period. Not 2.5 hours, maybe a lunch break. Maybe there is some indisciplinary activities, so during the time there is a break. It's basically what? It's basically a definite break. That's basically what is adjournment. When I say it is a definite break, that means after that point of time, people will again sit and they'll start discussing. They'll meet together. That's basically what is adjournment. But what is adjournment sine die? Adjournment sine die is also a break, but it is an indefinite break. It's an indefinite break. That's basically the difference between adjournment and adjournment sine die. While adjournment is a definite break, adjournment sine die is an indefinite break. And when this indefinite break happens, that once in that particular session, all the business is over. then the presiding officer will pass an order what is called as adjournment sine die. Now once the presiding officer passes the adjournment sine die, then the president will prorogue the session. That means the president will terminate the session. Okay, that's basically the difference between adjournment and adjournment sine die. So both are breaks, but one is definite, other is indefinite. What is definite? Adjournment is definite and indefinite is adjournment sine die. So now come to the question. Adjournment sine die means a break in the sitting of the state legislature for a definite period. Is it for definite period? It is for indefinite period. Statement 2. A prorogation terminates the session of the House. Will it terminate? Prorogation. Of course, it's a termination of the session. So this is true. In case of Parliament, it is President. Here it is state legislature. So it is Governor. Okay, so come to statement number 3. The Governor has to issue notification for the dissolution of the Legislative Council. The Governor has to do that. The Governor has to issue notification to dissolve the Legislative Council. But when he does that usually? At what point of time he does that? No. When the term is over. When the 5-year term is over, the Governor doesn't have to wait for this. So whenever the term is over, he can dissolve by issuing a notification. Or when the government loses the majority, even when the term is not over, then also he can issue a notification. He can dissolve the Legislative Council. Okay, sorry, here it is Legislative Council. I thought it is Legislative Assembly. So here it is Legislative Council. Legislative Council is a permanent house. So whatever I discussed in case of the Assembly, but Council is what? It's a permanent house. So here if you see, the Governor has to issue notification for the dissolution of Legislative Council. Because it's a permanent house, that cannot be dissolved. That is wrong. The state legislature should meet at least thrice in a year. Is it mandatory? Is it mandatory that they should meet at least 3 times in a year, or at least 3 sessions in a year? All that is mentioned in the Constitution, both in case of Parliament and state legislature, is that there shall be no lapse of more than 6 months. So this is exactly what is mentioned. That means there is a constitutional requirement that they meet at least twice in a year, but there is no specific time that they have to mention. Nothing is mentioned in the Constitution. So this is also wrong. Okay. So what is the answer now? So only one. A is the answer. Very good. Come to next question. Question number 45. Look into the next question. Question number 45. Consider the following statements regarding the State Council of Ministers. If you see, consider the following statements regarding the State Council of Ministers. The Chief Minister shall be appointed by the Governor, and the other ministers shall be appointed by the Governor on the advice of the Chief Minister. Is that true? Who appoints the Chief Minister and the other ministers? The Governor. But the other ministers are appointed by Governor on the advice of the Chief Minister. So definitely constitutionally it is true. There shall be Council of Ministers with the Chief Ministers as the head to aid and advise the Governor. This is true. There shall be a Council of Ministers which is there in Article 163 of the Constitution. What is the relevant article for the Union Government? Article 74. 74, here it is Article 163. This is also true. The advice tendered by the Minister to the Governor shall not be inquired into in any court of law. Is it true? So as per the Constitution of India, whatever advice that they give shall not be inquired in a court of law. So this is definitely true. As per the Constitution, this is true. So how many of the statements given above are correct? All the 3. So C is the right answer. Come to next question. So again a very easy question. Which Constitutional Amendment Act added the provision that the total number of ministers, including the Chief Minister, in the Council of Ministers in a state shall not exceed 15%. Shall not exceed 15% of the total strength of the Legislative Assembly. So originally there was no such restriction in the Constitution, but today there is a restriction. So what is the restriction today? It shall not be more than 15% of the strength of the House. 15% of the strength of the Legislative Assembly. But there is an exception in case of certain union territories. There are few union territories which has got the Legislative Assembly. Can you tell me the union territories which has got the Legislative Assembly? National Capital Territory of Delhi, sorry, Puducherry and Jammu and Kashmir. In all these cases, it shall not be more than 10% of the strength of the Legislative Assembly. Whereas in case of states, it is 15%. Now this was brought in by the 91st Constitutional Amendment Act in 2003. This is when this change was brought in. So what is the answer here? Option D is the right answer. 91st. In case of states, this is when the changes were brought in. 91st Constitutional Amendment Act. This is again very important. 10% in case of National Capital Territory of Delhi, Puducherry and Jammu and Kashmir. Before it was state, when it was a state, it was 15%. Now it is 10%. In case of small states, why they have also got legislative assembly members. They have 40 members. 40 means out of 40 there can be 6 ministers. They will because even though there are a number of portfolios, their responsibility is less. So a single minister will have responsibility of 7-8 portfolios. Okay, come to the next question. The minister shall hold office during the pleasure of the governor. Is it true? This is in case of the state legislature. Shall the ministers hold office during the pleasure of the governor? Is it true? This is it constitutionally true or false? Constitutionally, this statement is exactly given. They hold office during the pleasure of the governor. But this pleasure of the governor cannot be misused. When he can use this pleasure is only when the government loses the majority. When the government loses a majority, he will have this pleasure. Okay. So the ministers shall hold office during the pleasure of the governor. This is true. Minister who is not a member of the state legislature for any period of 6 consecutive months shall cease to be a minister. Is it true? So even a person who is not a member of parliament or a member of state legislature, still he can be a minister. But for how long? 6 months. Within 6 months, he has to become a member of state legislature. Either houses, be it elected or nominated, it doesn't matter. He has to become a member of that particular house. Okay, so a minister who is not a member of a state legislature for a period of 6 consecutive months shall cease to be a minister. This is true. The salaries and allowances of the minister shall be determined by the governor. Is it true? The salaries and allowances of the minister shall be determined as per the law made by the state legislature. The state legislature can make a law, and by that law they can determine this. So the salaries and allowances of the ministers shall be determined by the law made by the state legislature, not by the governor. So this is wrong. Which of the statements given above are correct? 1 and 2. So option B. B is the right answer. Right? Come to the next question. Which option? The previous question? A minister who is not a member of the state legislature for more than period of 6 months, 6 consecutive months, shall be ceased to be a minister. If 6 months is not mentioned, without 6 months time, you cannot answer this question because you need to have the time limit. So within 6 months, not required, but after 6 months, you cannot continue. So 6 months time is mandatory in this question. Then only you can answer this question. Okay, otherwise the question itself is incomplete. Okay, so come to the next question. Question number 48. The Constitution of India does not specify the size of the State Council of Ministers. Does it specify the size of the State Council of Ministers? I mean, is the exact number prescribed in the Constitution? It does not specify. Only the range is given. What is the range? It shall not be more than 15%. Council of Ministers. It shall not be more than 15%. So only the range is given. It does not specify the exact number. So this particular statement is right. Okay. So it does not give what? It is not talking about the exact thing. So come to statement number 2. The total number of ministers in a state council of ministers, including the chief minister, cannot be greater than 10% of the members of the state legislative assembly. Is it 10%? It is 15%. And 10% in case of what? In case of union territories. So this is wrong. Which of the statements given above are correct? Only one is correct. Very good. So option A is correct. Come to the next question. Question number 49. So consider the following statements regarding the socio-economic caste census Recently, in one state, the socio-economic caste census was conducted where? Bihar. Otherwise, in India, normally every 10 years we do the census, which is regulated under the Census Act. So that is why this question has been put in here. So let us try to understand. Article 340 mandates the appointment of a commission to investigate the conditions of socially and economically backward classes. Is it true or false? There is a national commission for backward classes, and this commission is different, which mandates the appointment of a commission to look into the position of the socially and educationally backward classes. This the president can do under Article 340. And that National Commission for Backward Classes is appointed under Article 338B. Okay, so this is different. So this is true. And just to see how normally the people are doing, what is their social and economic status. So to analyze that, a commission may be appointed by the president under Article 340. According to the socio-economic caste census, all the personal information in the SE, social and economic caste census, so open for use by the government departments to grant or to or restrict benefits to the households. Now tell me, now what is the relevance of the socio-economic caste census? It acts as a data, and this data can be used for what? To devise better strategies, policies for the beneficiaries. Now this data can be used to see as to how many people from this caste is there in government job. So if their involvement is less, or if their contribution, if their representation is less, they can be given more reservation. So definitely this can be used for all the purpose. Okay, so this is definitely true. SEC at the national level was first conducted in 1931 to identify the indicators of deprivation. Is it true? This is factually true. In 1931, when India was British India, it was done by the Britishers. And in fact, why this is important, it was based on this 1931 census. The Mandal Commission has recommended the government to give 27% reservation to the backward classes. So at that point of time, which data was used by the Mandal Commission? This 1931 socio-economic caste census. So this is true. So here the socio-economic caste census is not about counting the people, it is about looking into the various deprivational factors. Okay, so that's the idea behind this socio-economic caste census. What is the answer here? The answer is option D is the right answer. Alright, come to the next question. That is question number, what is the next question here? Guys, what is the next question? Question number 50. Look into this question. Consider the following statements regarding the Legislative Council. So please understand, Legislative Council, they are all a very important topic. Every year there can be a question that can be asked from this particular topic. So look into this particular question. What the question is saying. Statement 1. Parliament can create or abolish. So who is authority to create or abolish Legislative Council? Parliament can create or abolish Legislative Council if the state legislature passes a resolution to that effect. So what is the majority with which the state legislature has to pass the resolution? What majority? Special majority. Special majority. So the statement is right. Statement 2. Any such resolution passed by the Legislative Assembly should be passed by simple majority. Is it simple majority? It should be special majority. So which of the statements given above are correct? What is the answer? Statement, the right answer is option A. A is the right answer. Come to the next question. Okay, so online students, keep watching it, and if you have any questions, you can put it in the comment box. Come to the next question, question number 51. So we are halfway through. So I'll just carry it forward. We'll try to minimize the duration so that we're not taking too much of time also, because your time examinations are approaching. So that is also important. So come to question number 51. Which of the following states can have strength of representatives less than 60 in their Legislative Assembly? Now, why this particular question is, what is the general rule in the Constitution? If you see the general rule in the Constitution, the general rule specifies a range for the members of the Legislative Assembly. So what is the range? It shall not be less than 60. It shall not be less than 60, the number of members, and greater than what? Greater than 500. We are talking about the Legislative Assembly. the number of members in the legislative assembly should not be less than 60, and at the same time it shall not be greater than 500. This is the range. Now, which state has got the highest number of representation? Uttar Pradesh. Can someone tell me how many members? 403. Very good. So 403 is the right answer. So everything has to fall within the range. This is a general principle. This is what? This is just a general principle, but we have an exception also under the constitution. Some of the states are given special status. In some of the states, there is less than 60 also. So among these states, which states have got less than 60 members? Goa has got 40. Arunachal Pradesh has got 60, exactly 60, the minimum number. Kerala has got 140. Because this is allowed, because there's an exception in case of Goa. Goa has a special status under the constitution. So what is the answer here? So these two cannot come. What is the answer? Answer is option A. How many of you got this right? Good. Very good. Come to next question. Question number 52. Consider the following statements regarding the pardoning powers of the president. Which article provides the pardoning power? Article 72 of the Constitution. A similar pardoning power is also given to the governor under Article 161. Although there is a difference between them, but let us just try to understand this particular question. Now the president can exercise pardoning, means you know that the president has a power to release someone from the jail. He can completely absolve all the punishment. He can completely set someone free. So this power that the president is exercising under Article 72 was brought into the Constitution with the objective that there is a possibility of judicial errors. Even judges can make mistakes. So after all the judicial mechanism is exhausted, somebody has to given this power to pardon. And who is the highest authority to do this? The president at the national level, the governor at every state level. Now the question here is, does the president has to exercise this power based on the aid and advice of the Council of Ministers, or can he do it on his own? So the president cannot exercise his power of pardon independent of the government. Is it true? He cannot do it independent. He has to do that on the advice of the Council of Ministers. So this particular statement is true. Okay, this is not explicitly mentioned in the Constitution, but number of judgments of the Supreme Court has said that the president has to do that based on the advice of the ministers. Statement 2. The pardoning powers of the president does not extend to death sentence. That means in case of death sentence, can the president exercise his power or not exercise his power? He can exercise. So this particular statement is wrong. When it says it does not extend, this is wrong. Come to statement number 3. The Constitution empowers the president to return the mercy plea for the reconsideration once. Is it true? Means the Constitution empowers the president to return the mercy plea for the reconsideration to the Council of Ministers. Suppose let us assume that the Council of Ministers are telling him that yes, this person can be given relief. So can this advice be sent for reconsideration by the president once to the Council of Ministers? He can do that. Any advice which is given to the president can send it for reconsideration. But how many times he can send it for reconsideration? Once. Which Constitutional Amendment Act allowed the president to send it for reconsideration? The 44th Constitutional Amendment Act 1978. 44th Constitutional Amendment Act 1978 allows the president to send it for reconsideration. Well, the 42nd Constitutional Amendment Act 1976 made the aid and advice binding. Made the aid and advice binding. The 44th Constitutional Amendment Act allowed it once for reconsideration. So what is the answer in this case? While this particular statement is wrong, this particular statement is true, this is true. So what is the answer here? How many of the statements given above are correct? Only 2. Option 2 is the right answer. Clear? Very quickly we'll move to the next question. Come to the next question. Consider the following statements. No criminal proceeding shall be instituted against a governor of a state in any court of law during his term of office. Is it true? The same privilege is also given to the president. I just told you to look into the Constitution which article gives this privilege. Can anyone tell me which article gives this privilege to the president and the governor? Article 361 of the Constitution. Article 361 of the Constitution gives this privilege both to the President and the Governor. So it is very important you remember this. So no criminal proceeding shall be instituted against the Governor of a state in any court of law during his office. But what if the proceeding is a civil proceeding? Can it be done? In case of civil proceedings, it can be done, but giving a prior notice of 2 months. So in case of civil proceedings, it's perfectly all right, but a prior notice has to be given to the President and the Governor for 2 months, before 2 months. Okay, that's exactly what you'll have to understand. So this particular statement is true. The emoluments, allowances of the Governor of a state shall not be diminished during his term of office. Diminished means, suppose let us assume at the time of appointment of the Governor's salary is 3.5 lakhs. Can it be reduced to 3 lakhs? Can it be increased to 5 lakhs? Increase is possible, but not decrease is possible. It cannot be varied to his disadvantage. Very good. So here it is saying the emoluments and allowances of the Governor of a state shall not be diminished during his term of office. This is also true. What is the answer? Both 1 and 2. Okay, so the answer is option C. Mukesh, सही हुआ question? Second statement wrong कर दिया, नहीं करना है, ठीक है? Come to the next question. That is question number 54. With reference to legislative assembly of a state in India, consider the following statements. So this is related to the legislative assembly of a state. The governor makes address to the members of the house at the commencement of the first session every year. Does it happen? After the legislative assembly election is over, when the new government is formed, in the first session, the governor will make an address. Similarly, the president will make an address in the parliament. Okay, so this is true. This is true. The article relevant for here is Article 174 of the Constitution. So under Article 174 of the Constitution, the governor makes this, but it is not very important to remember this. Come to the next statement. When the state legislature does not have a rule for a particular matter, it follows the Lok Sabha rule on that particular matter. Is it true? Now see, as per the Constitution of India, who will make the rules with regard to the state legislature? The speaker has to make the rules. But today there is a convention in our country. If the speaker has not made any rule as to how to do certain things, then they will follow the rule that is there in the Lok Sabha. Okay, it's only a conventional practice which has been followed. But they don't have to follow this rule. They themselves can make the rules. And who has the power to make the rules? The speaker of the legislative assembly. But if the rule is absent, if the rule is not there, then they can follow. So this is true. So which of the statements given above are correct? Both 1 and 2. Okay, so both 1 and 2 are correct. Come to the next question. What discretionary power is or conferred upon the governor of a state? So here we will have to understand what is a discretionary power. What do you mean by discretionary power? Where he can act on his own. That's basically what is called as a discretionary power. So yes, he doesn't have to act on the aid and advice of the Council of Ministers. Statement 1. Sending the report to the President of India for imposing President rule. Is it his discretionary power? Of course, the Chief Minister and the other ministers will not advise the governor to impose President rule in that particular state. That is unlikely to happen. So definitely this is a discretionary power which is there to the governor under Article 356. Appointing the ministers, is this a discretionary power? He can appoint the ministers but not on his own, but on the advice of the Chief Minister. So this is wrong. Reserving bills for the consideration, reserving bills passed by the state legislature for the consideration of the president. Is it his discretionary power? Under Article 200, of course it is his discretionary power. Making the rules to the conduct of business of the state legislature. Is it his discretionary power? Making rules for the conduct of business to the state legislature. So making rules to the conduct of the business of the state legislature is not his discretionary power. He does that based on the aid and advice of, for the state government. Making rules for the conduct of the business of the state government. In fact, there is something which is called as transaction of business rules. This transaction of business rules has to be done by the governor only for the state government under Article 166. But he does not do that on his own, but based on the aid and advice of the Council of Ministers. So this is also wrong. So what is the answer here? Which of the statements given above are correct? 1 and 3 only. Yes, transaction of business rules. Come to the next question. Question number 56. 56, right? We'll move forward. Which of the following federal principles are not part of the Indian Federation? Which means in the Indian Federation, which is not there, not a part of the Indian Federation. There is no provision for independent judiciary in India. In India, do you have independent judiciary? Not independent judiciary. We have independent judiciary. When they ask which of the following is not, so it goes with the question. So this is definitely true. Because we have independent judiciary, we are saying no independent judiciary. Equality of representation of states in the upper house of the federal legislature. In the Rajya Sabha, do we have equal representation from all the states? So it is an example of asymmetrical federalism, which means unequal representation, because here it is saying equal representation. This is wrong. The union cannot be destroyed by any state by seceding from the union at its will. Is it true? That means otherwise the statement is saying, can the states move from the union at its will? Not possible. That is what it is saying. It cannot be destroyed. So it is definitely a true thing, but not as per the statement. So the following is not a feature. The federal government can redraw the map of the Indian Union by forming the new states. Is it a true statement? See, that statement is true. But the question is asking which of the following are not a feature of Indian federalism. It's a feature of Indian federalism. Okay, this is the representation of states in the upper house are equal. This is not a feature of Indian federalism. And the federal government can redraw the map of the Indian Union by forming new states. So this can be done under Article 3. So this is also true, but here they are asking not. So this is also not the correct answer. So if you eliminate all these things, what is the right answer? Option A is the right answer. So what is the answer here? Okay, so let me just check further. The equality of representation of the states in the upper house of the federal legislature. Okay, so there is no equality of representation. So this is not a right statement. So because it is not a right statement, not it is asking. So this is true. So what is the answer here? Option C, 1 and 2 is the right answer. Come to the next question. This is a very simple question. Which of the following suggested that the governor should be an eminent person from outside the state and should be a detached figure without intense political links, or should not have taken part in politics in the recent past? Which committee? Sarkaria Commission. In fact, Sarkaria Commission has extensively thought about, researched about the center-state relationship. And one of the area within the center-state relationship is the independence of governor. How to make the office of the governor more independent. Okay, so they talked about the independence of governor. So this is exactly recommended by the Sarkaria Commission. So National Commission to review the working of the Constitution is overall review about the Constitution. What are the changes can be made in the Constitution? Administrative Reforms Commission is how many Administrative Reforms Commission has been appointed so far? 2. One in 1966 and then later in the early 2000. But that is related to the entire overall of the administrative system in our country, not related to the office of the governor. And the Rajendra Committee was appointed by the state government of Tamil Nadu. Again, center-state relationship, but it was not a very prominent committee because it was appointed by a state government, whereas Sarkaria Commission was appointed by the central government. So the answer is option C. Come to the next question. Under the Constitution, the residuary powers is vested in whom? What is residuary powers? That means powers that is given to an authority to make law on those items which is not mentioned in any of the 3 lists. That is state list, union list, or the concurrent list. So today who has the residuary power? The Parliament. Before the commencement of the Constitution, the country was governed by the Government of India Act 1935. So the Government of India Act 1935, who had this power? It was in the hands of the Viceroy. Okay, so that was also asked in the prelims examination. So very important. So here the answer is option C. In fact, the Indian Independence Act, sorry, not the Indian Independence Act, the Government of India Act 1858. So in the Government of India Act 1858, when they transferred the control from the East India Company to the British Crown, When they transferred the power, they said that henceforth, whoever will be the Governor General will be called with a nomenclature which is called as a Viceroy. Because earlier the Governor General was to report to the company. Now this Viceroy will directly report to the Secretary of State. So otherwise there is no difference in terms of their work. But because now the control is changing, the government, that the expression that has to be used is what? The Government of India Act 1935, the expression that has to be used is the Viceroy. Come to next question. What is the next question? Question number 59. If you come to question number 59, the Parliament can make any law for whole or any part of India for implementing international treaties. Suppose let us assume an item is in the state list. Can the Parliament make law on an item in the state list? Normally, is it possible? It is not possible under all these circumstances. Normally, generally it is not possible, but there are few exceptions. And one such exception is Article 253 of the Constitution. So what is Article 253 of the Constitution is saying? Article 253 of the Constitution is giving the power to the Parliament. And what kind of power it is giving to the Parliament, Article 253 of the Constitution? It is giving power to the Parliament to make a law on an item in the state list, provided this law that is made by the Parliament is to implement an international treaty. So when they have to implement an international treaty, even if the Parliament has to make a law on an item in the state list, still they can do it. Can they do it or not do it? They can do it. So in the process of making that law, do they have to take the permission from the states? Without taking the permission from the states, they can do it. Otherwise, generally they are not allowed to do this. Okay, so here the answer is without the consent of the state or with the consent of the state? Without the consent of the state. So the answer is option D. D is the right answer. Come to the next question. Consider the following statements regarding recently passed Cinematographic Amendment Act 2023. Statement 1. It emphasized the autonomy of the Central Board of Film Certification. So there is something which is called as the Central Board for Film Certification, which is established under the Indian Cinematographic Act. Now what is the role of the Central Board for Film Certification? They will censor the movies, and then only when they certify, they will certify and they will censor and they will certify the movies, and then only it can be screened. Without that, they cannot be screened in to the public. In fact, they give different types of rating. They give different types of ratings for that, like universal is one rating, and then universal with adult supervision is another rating, and then they can give a specific category, specific audience can watch that. EA only category, which only the adults can only watch. So who is going to give all these classification? The CBFC, the Central Board for Film Certification. Now recently some change has been made to that particular body by amending the Cinematographic Act recently. That's why this question is there. And in fact, the major objective is that this particular act emphasizes more autonomy to the body. So this is definitely true. Now this can be a general knowledge also. Whenever a law is amended, the law will try to take away the power or to give more power. In general, the law has to be progressive. In general, the law has to be progressive, which means more autonomy is given to this particular body. Okay, so the statement is true. That's the objective. And then the second thing is implementation of graded age classification for the streaming platforms on the recommendation of Sham Benigal Committee in 2017. Now this person was having a lot of, has done a lot of contribution to the cinema industry. So under his leadership, a committee was appointed way back, and he has given certain recommendations. So this person has suggested today that graded age classification has to be done, especially under this UA category, universal under adult supervision. That means under adult supervision the movies can be watched, but that also within that classification he has made a lot of gradation. I think he has made a classification of, I think, some age classification. So just give me a moment. Some classification he has made in this category. What is the question number? 60. So 7 plus, you can make a note of this, 7 plus years, 13 plus years, 16 plus years. So some age gradation has been done. So earlier this age gradation was not there. Okay, so this is definitely true. Universal means everybody can watch, but with adult supervision. So only when an adult is there, the child can watch. Without the adult supervision, the child cannot watch. And in that also there are gradation. Only children above 7 plus can watch. Only children 13 plus can watch. Only children 16 plus can watch under the adult supervision. So that gradation has been now brought in. See, adult means, suppose let us assume you are an adult and a child wanted to watch a movie along with you. So if that movie is graded universal under adult supervision, an adult has to be there, along with adult the child can watch. But if it's under this category, only a child of 7 plus years can watch. Okay, not below that. Okay, come to the next statement. The Act grants 10 years of validity restriction on CBSE certificates. Now, earlier, whatever is the decision that is given by the CBSE was having a validity of 10 years. Now, that has been done away with. Now, the validity is given perpetuity. There is no time limit. Okay, so it has been modified. So, there is no 10 years of validity. Okay, so that is in perpetuity. So, this is wrong. So, what is the right answer here? Statement 1 and statement 2 is right. What is the answer here in that case? Option B. B is the right answer. All right. Come to the next thing. #61. Consider the following statements regarding the recently passed the Registration of Birth and Death Amendment Act 2023. So this is a recent amendment that has happened. So under this law, every birth that is happening in our country, every death that is happening in our country has to be registered, so that the government has a data as to how many people are there in our country. So that is a specific act, and there's a database to maintain all these things. At the national level, there's a database. At the state level, there's a database. There is coordination between the national and the state database. Now with this, let us just come to what has happened with the recent amendment. The Act provides linking of Aadhaar details of the parents and the informants to the birth certificate. Whenever a child is born, a birth certificate has to be prepared. So this Act provides for linking of these people. So the Act provides for the linking of these people. So here, earlier it was only the parents whose Aadhaar was to be attached. Now it is also about the informants. Who are the informants? So when you say the informants, you will understand that who are the informants. Suppose let us assume a child is born in the hospital. When the child is born in the hospital, then in that case, who will inform about that particular birth? The doctors, the managers in the hospital. Suppose if it is in the jail, then the warden of the jail. So anywhere the child can be born. Okay, so these are all the informants. It should also be there. So this is true. The Act makes it voluntary for the state to register births and deaths on the Central Civil Registration System CRS portal and to share the data with the Registrar General of India. So here the key word is the Act makes it voluntary for the states. So it should be voluntary or it should be mandatory. Suppose a child is born in a particular state, so it should be allowed voluntary to on the state, or it should be mandatory for the state to share this data. Only when it is mandatory it can work. So it is not voluntary, it is mandatory. So to that extent it is wrong, while the statement 1 is right. So what is the right answer here? Only one. Option 1 is the right answer. Come to the next question. Next question is question number 62. So consider the following statements. The Legislative Assembly of Delhi was created by the 69th Constitutional Amendment Act. Is that true? When was the Legislative Assembly? When was a special status was given to Delhi? The special status was given to Delhi by way of the 69th Constitutional Amendment Act. It was only by the 69th Constitutional Amendment Act the special status was given. And by the 69th Constitutional Amendment Act in 1992, the special status was given, and a number of special status has been given. First of all, to have a Legislative Assembly, and after the Legislative Assembly is there, there will be a Council of Ministers, there will be a Lieutenant Governor. So there can be 10% of the ministers from the Legislative Assembly who can become the ministers. These are all the special status that is given to Delhi. That is true. So this is definitely true. Now recently a law was enacted. That is the Government of National Capital Territory of Delhi Amendment Act 2021. How many of you know about this particular act? The controversy about this particular act is that they are trying to give more power to the lieutenant governor than the elected government. There are a number of provisions. Overall, the essence of this act, I would say, is that they are trying to give more who was the boss. In case of the Delhi, it is the lieutenant governor rather than the elected government. So in that context, read this particular statement. The Government of Delhi Amendment Act 2021 gives primacy to the lieutenant governor over the elected government in Delhi. Is that true? That is definitely true. So what is the answer here? Both 1 and 2. That is the right answer. 1991. 69th Constitutional Amendment Act 1991. Okay, 69th Constitutional Amendment Act 1991. Come to the next question. Consider the following statements regarding the State Legislative Council. If you see, consider the following statements regarding the State Legislative Council. The maximum strength of the council is fixed at 1/5 of the total strength of the Legislative Assembly. Is it fixed at 1/5? What is the maximum strength? It is maximum is 1/3. 1/3 of the size of the Legislative Assembly and not 1/5. This is wrong. The minimum strength of the council is fixed as 60. Is the minimum strength fixed at 60? What is the minimum strength? What is the minimum strength? The minimum strength is 40. And it is not 60. So here this is also wrong. So what is the answer? Answer is option D. D is the right answer. D. Come to the next question. In the context of Indian Constitution, which of the following contains the provisions related to the local self-government? So which of the following? Part 9 is related to what? The panchayats. Does it have a relation here? Panchayats, it deals with the panchayats. What about part 3? Part 3 is related to fundamental rights. No relation. Article 324 is related to the election commission. The election commission under Article 324, there is no relation because the election commission of India is to conduct election to whom? To the Lok Sabha and to the Legislative Assembly. To the Panchayat, do they conduct the election? State Election Commission. So here you can cut it down. Part 4 is related to what? Directive Principles of State Policy. But under Directive Principles of State Policy, there is an article which is called as Article 40. What is Article 40 talking about? State to establish Panchayats. So it has a relation. To some extent it is related. So this is true. Statement 1 is true. What about Article 280? Related to Finance Commission. If you look into one of the functions of the Finance Commission, one of the functions of the Finance Commission is also to what? One of the important functions of the Finance Commission is also to recommend as to how the revenues that can be given to the Panchayat can be increased. So the Finance Commission is also related to the local bodies. Okay, although not directly, indirectly there is a relation to that. So if you eliminate option 3 and option 4, what is the answer? 1. If you eliminate 2, 1, 3, what is the answer? 1. Okay, 1, 4 and 5. Very good. It is option A. A is the right answer. Come to the next question. The subordinate judiciary. What is called a subordinate judiciary in our country? Below the high courts. Whatever below the high courts, it is called as the subordinate judiciary. That's exactly what is the subordinate judiciary. So here the question is trying to assess that we have a Supreme Court, then every state we have a High Court. Below that we have district courts and other subordinate courts. So is the hierarchy of subordinate courts same throughout the country? After High Court, the hierarchy, the nomenclature is different. It can be different in terms of whether it is a city or it is a rural area. It can be different in terms of the other differences also. So there is no uniformity in that regard. The subordinate judiciary has strictly uniform organization. Do they have uniform organization? They do not have uniform organization. This is wrong. Statement 2. The district judges are appointed by the governor, while the judges below the district judges are appointed by the High Court concerned. Is it true? While the district judges are appointed by the governor, the judges below the district judges are also appointed by the governor, not by the High Court. All the judges are appointed by whom? By the governor. But the judges below the district judges, they're all recruited by the state judicial service examination. Are you aware of judicial service examination? So who carries out the state judicial service examination? The State Public Service Commission. The State Public Service Commission recruits the officers, and once the State Public Service Commission recruits the judges, and then finally who will appoint them? The governor will appoint them. So who is going to make the appointment? Not the High Court, but the governor. In this case also it is the governor. So this is also wrong. The State Public Service Commission has to carry out the recruitment based on the rules that is made by. Who will make the rules for this examination? The governor will make the rules. The governor will make the rules in consultation with the State Public Service Commission and also in consultation with the State Public Service Commission and the High Court. So the governor will consult the State Public Service Commission and the High Court. He will make the rules. Based on the rules, the State Public Service Commission will carry out the examination, and then the successful candidates will be announced, and those successful candidates will be appointed by whom? By the governor. Okay, so this is the understanding you should have. We are saying because it is there in the constitution. This is what the constitution says. Alright, so what is the answer here? So which of the statements are correct? It is option D. Okay, so quickly let me move to the next question. So come to the next question, question number 66. So consider the following statements with regard to senior advocates. Do you know who are senior advocates? It is not like that, exactly not like that. The senior advocates are those people who have got excellent knowledge, who have done extremely well in their career, and after a certain point of time, there is no fixed time limit for this. After a certain point of time, depending upon their experience and all those things, certain advocates can be designated as senior advocates by the Supreme Court and High Court. Only the Supreme Court and High Court has authority, the judges have the authority to designate certain advocates as senior advocates. Okay, these are advocates who are designated as senior advocates by the Supreme Court of India or by the High Court. So this is true. They cannot appear in the Supreme Court without an advocate on record. Okay, that is also true. Now we'll have to understand who is an advocate of record. So advocate of records are those people who are eligible to file cases in the Supreme Court. Except for the designation of advocate on record, they will not be able to file cases in the Supreme Court. Not any lawyer in the country can come and file a case. No, not possible. Who can file a case? As in, we as an individual can file a case, but when you are approaching a lawyer, which lawyer can put this particular case in the Supreme Court is that who is an advocate on record. And there are certain conditions to be an advocate on record. Even for the senior advocate, they cannot approach, they can appear in front of the Supreme Court without the advocate on record. So let us assume an advocate on record is filing the case, then the senior advocate can go and discuss the case, he can appeal in the, he can discuss and he can have the discussion in front of the judges. The trial can happen, but who can file the case? The advocate on record. So this is true. Only senior advocates are entitled to file any matter or document before the Supreme Court. No, not the senior advocates. Who is eligible to do that? The advocate on record. So what is the answer here? Which of the statements given above are correct? Option 1 and 2 only. A is the right answer. Come to the next question. Question number 67. So consider the following statements. The capital punishment passed by a trial court cannot be executed without the concurrence of the state high court. Can the trial court means usually the district court, can they give death sentence? Can they give capital punishment? They can give. They can give capital punishment as well, but it cannot be executed unless and until it is approved by the High Court. So this is based on the Criminal Procedure Code. Today we have a law which is a Criminal Procedure Code, and that law says that. So this is definitely true. Come to the reason. In India, we have a pyramidal and an integrated judicial structure that provides for the control of the High Court over the subordinate court. So this statement is true. In general, the High Court has supervisory jurisdiction over the subordinate courts, but that's not exactly the reason why this is happening. This is because the law mandates the High Court to look into that. It is not just because the High Court is exercising, the High Court is not changing the judgment. It is just that the High Court has to look into the judgment, and then once it is approving it, then it can be done. So the right answer here is both are independently true, but it is not the correct explanation. Answer B is the right answer. Come to the next question. Which of the following is directly related to the appellate jurisdiction of the Supreme Court? Appellate jurisdiction of the Supreme Court means that you go for an appeal against the order of the High Court. So when you will go to the Supreme Court for an appeal? Only from the High Court. You cannot skip the High Court. So in which cases you can go? appeals made in the civil and the criminal cases. Okay, so not in the other cases. Okay, so appeal made in the civil and criminal cases. Here it is saying appeals made only in the constitutional cases. That is not wrong. Appeal made in the civil cases is right. Adjudication of disputes between union and the states. So here it is not under the appellate jurisdiction. It is under which jurisdiction? Under the original jurisdiction. So here under which jurisdiction? Adjudication of disputes between the states. Again original. It is not appellate jurisdiction. So appeal means only in civil and criminal cases. Very easy. The jurisdiction of the court is very, very important. Every year there is a question in this topic. Okay, so just try to keep it in your mind. Very, very important. Option A. Come to the next question. Question number 68 or 69? 69. Come to 69. Very simple question. Now, because of the National E-Governance project, they also try to bring in e-courts to resolve and to fast track the cases. So with that, this question is asked. E-courts project is a mission mode project monitored and funded by the Department of Justice, Ministry of Law and Justice. This is true, factually. So who is funding this particular project? It's a national level project. It's done by the Ministry of Law and Justice. E-courts project will be housed within the Home Ministry under the interoperable criminal justice system. This is also true. They will fund it, but the Home Ministry will have oversight about the criminal justice system. So this is also true. The ambit of e-courts project includes not just the constitutional courts but also the lower courts. Now today this e-courts is only implemented at the district courts and below. And what are all considered to be constitutional courts? What are constitutional courts? No, you are talking about a constitutional bench. High Court and Supreme Court is a constitutional court which is established by the Constitution itself. Okay. So the e-courts today, this project is not working with the constitutional courts but with the subordinate courts. So here it is saying not just the constitutional but also the lower courts. It is only the lower courts, not the constitutional courts. Now the last thing is the E-Committee of the Supreme Court is the governing body charged with the oversight of the e-courts project. So this is true. Factually, these are factual things. So what is the answer here? Except option 3. Option D is the right answer. Come to the next question. So this is again a factually right thing. Which of the following police forces are designated by the Ministry of Home Affairs as a central armed police force? What is the answer? The answer is all. Every force is a paramilitary force. Indo-Tibetan Border Police, Assam Rifles are those people who are there in the insurgency areas in the northeast. Indo-Tibetan, everybody in this. You can just go to the Home Ministry website. You can see all these forces are listed. You just tell me what about the Indo-Tibetan Border Police, where they are involved? India and China. What about the Border Security Police? India, Pakistan and India and West Bengal, in both the places. What about Central Reserve Police Force? They are mostly used for all the duties, especially the Naxal affected areas and the other areas also. What about Shastra Seamable? India and Nepal border, very peaceful, no problem. Central Industrial Security Force, major industries, airports, industrial establishments. National Security Force, VIP security. Yes, VIP security there. Majorly national, they are all VIP security. So for terrorism, they can be called different force, but they are majorly related to what? VIP security. So what is the answer here? It is option D is the right answer. Come to the next question. Consider the following statements about the National Company Law Tribunal. So this Company Law Tribunal will look into the cases related to the malpractices by the companies and all those things. There is something which is called as Competition Commission of India. Have you heard of the word Competition Commission of India? Which is to ensure that all the companies are doing fair practices. And if they are doing unfair practices, they can punish. Against the order, they can go for the cases in the Company Law Appellate Tribunal. So now the first statement is the Company Law Appellate Tribunal has been constituted by the central government under the Companies Act 2013. Is it true? This is factually true. It's a statutory body established here. The tribunals may provide such exemptions to the parties in compliance with the rules as it may consider just so as to deliver a substantive justice. So this is what is there in the objectives of this act. So the tribunal has the power to give such punishment or to exempt from such punishment in order to ensure justice in that particular matter. So this is true. Come to statement 3. The tribunal has investigative power and also can deregister the companies accused of malpractices. So this is also true. This is one of their functions along with the other functions. So this is definitely true. So which of the statements given above are correct? What is the answer? Option D is the right answer. Yes. Against the order of the tribunal, they can go to the High Court. Against the order of the tribunal, as a High Court, they can again go to the Supreme Court if they want. Yes, they can go if they want. National Green Tribunal, they say, although the Act says that they can appeal can be made only in the Supreme Court, but there are instances it has gone for appeal in the High Courts as well. There's a case regarding that L. Chandra Kumar case, which made it mandatory that the tribunal's order can be appealed in the High Court. Come to the next question, question number 72. Which of the statements given below is not correct regarding the State Election Commission? So regarding the State Election Commission, which is not correct, that is what we'll have to understand. Statement 1, it consists of State Election Commissioners to be appointed by whom? It consists of the State Election Commissioner to be appointed by the Governor, this is true. It prepares the electoral roll for Panchayat elections, is it true? So here it is asking not correct, so first let us try to make the correct thing and then we'll come to the answer. This is also true, that is the function. The conditions of service of the State Election Commissioner shall not be varied to his disadvantage after his appointment, true? That is also true as per the Constitution. It works under the overall supervision of Election Commission of India, no. The State Election Commission is not subordinate, the State Election Commission is not subordinate to the Election Commission of India, there is no such thing. So this is definitely wrong. So what is the answer here? D is the right answer. It is an independent body at the state level. Come to question number 73. Option D is the right answer. Come to question number 73. Consider the following statements. Statement 1. The Constitution of India is based on the principle of parliamentary sovereignty. What do you mean by parliamentary sovereignty? Parliamentary sovereignty means that they can do anything. They can amend the Constitution to any extent. They can make any type of law. So is it based on parliamentary sovereignty? In India, we are not based on the principle of parliamentary sovereignty, but on the principle of constitutional supremacy. Can the parliament amend the entire constitution? So there are some limitations, isn't it? So that is definitely not possible in our country. Okay, that is not possible. So it is based on the principle of what? Constitutional supremacy, not parliamentary sovereignty. But in UK, it is based on the principle of parliamentary sovereignty. That's why one constitutional expert has said that in UK, the Parliament of UK can do anything except changing a man into a woman and a woman into a man. But which is not the case in India. In India, it is based on the principle of constitutional supremacy. The Parliament of India can be considered sovereign in the sense it has legal omnipotence. Legal omnipotence means unlimited powers. The meaning of the word omnipotence means unlimited powers. So do you think that the Parliament has got unlimited powers? In fact, its power is limited by what? By the Constitution and through the various judgments like basic structure and all those things. So this is also wrong. So what is the answer? Which of the statements given above are correct? Neither one nor two. Alright. So with that, I'll pass it over to Rajendra sir for some time, and then after some time I will discuss unlimited powers.
Thank you, sir. Thank you, sir. Thank you, sir. Hello, students. सुन रहे हो क्या? मुकेश, सुन रहे हो क्या मेरा आवाज? नहीं, सुनना पड़ेगा.
ठीक है ना? अभी सुना नहीं तो फिर यूपीएससी समझाएगा आपको अच्छा से, ठीक है ना? धीरे धीरे बुलेट स्पीड। ऑनलाइन स्टूडेंट्स कितना लोग है ऑनलाइन देखता हूं? यस सर, नो, अदरवाइज आप ऑनलाइन नहीं तो फिर फास्ट चल जाएगा। सो बेटर इधर रेस्पॉन्स हो कुछ तो कुछ, ठीक है ना? ठीक है, चलो 74th क्वेश्चन। एज पर द इंडियन कॉन्स्टिट्यूशन, किसी जगह में आपको इंडियन कॉन्स्टिट्यूशन अकॉर्डिंग टू द कॉन्स्टिट्यूशन बोले तो आप रुक जाना। इफ यू आर नॉट हैविंग क्लैरिटी देन डोंट अटेम्प्ट, है ना? क्यों बोले तो ये गलत होने का बहुत चांस होता है, ठीक है ना? द सेपरेशन ऑफ जुडिशियरी फ्रॉम दी, क्या बोल रहा है? द सेपरेशन ऑफ जुडिशियरी फ्रॉम एग्जीक्यूटिव इज प्रोवाइडेड अंडर विच ऑफ द फॉलोइंग आर्टिकल्स, राइट? ऑनलाइन स्टूडेंट्स, ठीक है। सो टेल मी, as per the Indian Constitution, directive principles of state policy classified into how many ways? As per the Constitution, there is no classification. ठीक है ना? देखो मत, लिखते रहो, कुछ तो कुछ लिखो भाई, क्लास में आए तो। As per the Constitution, there is no classification of the directive principles of state policy, but our administrative convenience purpose, we classified into 3. What are they? Mr. Sai? फर्स्ट गांधी ने बता देगा, पहले क्या था? सोशलिस्टिक, गांधीयन एंड बस लिबरल, बस इतना ही है। लियो सिनेमा बता रहे हो क्या? हाँ, तम भी है। क्या है? फर्स्ट सोशलिस्टिक लिखो। एज पर द कॉन्स्टिट्यूशन देयर इज नो क्लासिफिकेशन ऑफ द डायरेक्टिव प्रिंसिपल्स ऑफ स्टेट पॉलिसी, बट आवर एडमिनिस्ट्रेटिव कन्वीनियंस वी क्लासिफाइड इनटू 3, ठीक है ना? वन इज क्या है? सोशलिस्टिक, एंड सेकंड गांधीयन, देन लिबरल इंटेलेक्चुअल। लिबरल, अरे अबे मैं कुछ बोल रहे तो सर मेरे ऊपर गुस्सा करते हैं, सर बोलते हैं, ठीक है ना? मेरे को तो वो फ्रीडम रहता है ना, इतना ओल्ड स्टूडेंट तो ये तो बनता है, ठीक है ना? ठीक है। As per the Indian Constitution, the separation of judiciary from the executive is provided under which of the following? So, Article 40 क्या होता है? It deals with Article 40, Panchayatis. So, Article 40 is the Panchayatis. It is part of the socialistic, Gandhian or liberal intellectual? Gandhian. So, can we write here Article 40 in the Gandhian में हम लिख सकते हैं ना? तो लिख लो. Then, Article B, Article 45 is रिलेटेड विद दी बिलो 6 years को लिए हमें एजुकेशन देना है। सो क्या एजुकेशन कौन सा है? लिबरल इंटेलेक्चुअल। चलो इसमें लिख दो आर्टिकल 45 को। आर्टिकल 45 कम्स अंडर द लिबरल इंटेलेक्चुअल। देन आर्टिकल 50 सेपरेशन ऑफ जुडिशियरी फ्रॉम द एग्जीक्यूटिव, कौन सा फिर? लिबरल इंटेलेक्चुअल। आर्टिकल 50 आल्सो लिबरल इंटेलेक्चुअल। देन Article 51, it deals with the international peace and agreement and all. The only one constitution in the world is having in the constitution हमारा देश है, कौन सा? Under Article 51, right? Through arbitration process में हम problems को address करना चाहिए, resolve करना चाहिए. So it is also again under liberal intellectual, Article 51. ऐसा classify कर लेना किसी में article आ रहा है, yes or no? So socialistic, Gandhian and liberal. So liberal intellectual. So here 3 articles which come under the bracket of the liberal intellectual. Try to understand what I am conveying here, right? So here पहले बताओ, directive principles of state policy we have derived from, अरे रशिया बोल रहा है फिर, भाड़ में जा। आयरिश कॉन्स्टिट्यूशन, आयरिश कॉन्स्टिट्यूशन लिया है ना? Which article to which article? Count 36 to 51. They are justiciable or non-justiciable? Non-justiciable means, online students, what do you mean by the non-justiciable? Cannot file. Court cannot enforce. What? Courts cannot enforce. So you can write non-justiciable in nature. and directive principles of state policy also called welfare state are instrument of instruction to the government, that is the legislature and executive, not judiciary. प्रीलिम्स में बहुत बार आया था, try to understand, है ना. Liberal directive principles of state policy non justiciable in nature. समझ हो रहा है ना. क्या बता सकते हैं DPSP, welfare state, instrument of instruction, 36 to 51, basic idea. As per the constitution there is no classification, but for our admin क्या क्या है, socialistic, Gandhian, liberal, intellectual. So here 40 article is under the bracket of क्या है, अंडर द ब्रैकेट ऑफ, कौन सा में आ रहा है इधर, गांधीयन. ठीक है ना. इवन दो यू आर whatever you are saying that is true regarding पंचायत only, because पंचायत सिस्टम पार्ट, कौन सा पार्ट था, पार्ट शेड्यूल 11 is based on the article 40. समझ हो ना. देन आर्टिकल 45, 50, 51, हमारा आंसर क्या हो जाएगा इधर, C is our answer. Even though other articles 45, 51 they come under the liberal intellectual, but exclusively here separation of judiciary from the executive provided under which of the following article, article 50. Yes or no sir? Jabardast sir. ठीक है sir, thank you. Then second question, online students. Then the fundamental object of the Panchayat Raj system is to ensure which among the following? सोच के बताना. So पंचायत राज सिस्टम का कौन सा पार्ट है, पार्ट 11 और शेड्यूल 11, शेड्यूल 11 पार्ट 9 लिख लो ना, पेन पकड़ के बात करना है. पार्ट 9 शेड्यूल 11, सही है नहीं है. सो शेड्यूल. सो हाउ मेनी फंक्शंस पंचायत राज सिस्टम इज हैविंग, 29. क्यों रुक रहे हैं, चेन्नई जाना है क्या, 29 फंक्शंस. ठीक है ना. 243 फंक्शंस, कौन सा आर्टिकल, 243 जी. ठीक है ना. नाउ पंचायत राज सिस्टम इज टू एंश्योर व्हाट पर्पस पंचायत राज सिस्टम, democratic decentralization. The democratic decentralization recommended by Balwant Rai Mehta Committee. It is a 3-tier system of the government. Ashok Mehta Committee 2-tier system of the government. But which one we accepted? Balwant Rai Mehta Committee. Right? Now, the fundamental object of the Panchayat Raj system to ensure, क्या ensure कर रहा है, people's participation. देखो, MLA MP, what? MLA MP is representation, our representative. वो कौन है, हमारा representative. But we are not participating directly, we are participating indirectly. On behalf of you someone is representing, means you are indirect. But in local election, direct election, people's participation है ना, people's participation, समझो ना, people's participation in development. Yes or no sir? So representative democracy in Lok Sabha and Assembly, but when it comes to Lok Sabha, I mean Gram Sabha, people's participation. Then political accountability. It is not for political accountability purpose, rather democracy strengthen. The only one constitution in the world which is having 3-tier form of the government, India. Central, state, local. At the local level we are missing. People participation is missing. That's why the Panchayat Raj system and municipality has given power to the public to choose, to participate in the local election. समझो ना, local government nothing but, मुकेश, local government किस जगह में है, गांव में है. पंचायत नहीं, not only पंचायत but also municipalities. लिखो ना सर, बोल दिया पहले, हो गया. Local government prevails in India. Panchayat, at the Panchayat Raj system as well as municipalities also. सौरभ दीपक बता रहे हैं उधर, आपका नाम दीपक ही है ना, दीपक आंसर बता रहे हैं क्या सर? See, in honest student, original constitution is having 2 tier of government. One is central and state. लिखो, बता रहा हूं आपको, दिमाग ये पेन चलता रहना है. in the कल आ जाएगा original constitution is having 3-tier form of government. No, the original constitution is having only 2 tier of government. What are they? Central and the state. But later, by 73rd Constitutional Amendment Act of 1992 or 3, 1992 and 74th Constitutional Amendment Act of 92 क्या किया था? One more tier added, that is local government. Local government into Panchayat Raj system and municipalities. लिखो. So here you can write. So original Constitution में कितना था? Central and state. 2-tier form of. But rather later introduced local government. Local government में क्या है? Again, most of the people are conveying that local government Panchayat Raj system. No, local government में Panchayat Raj plus municipalities. That should be specific रहना चाहिए, नहीं तो इल्ले. ठीक है ना? So try to understand whenever you are writing, these points must be required. Political accountability में नहीं है, accountability नहीं है. Political accountability के we have MLA MPs. MLA MPs हमको है accountability के. But here participation, direct participation, people's participation, not representation. Somewhere we are missing the people at the local level. That's why we have created it. Are you getting my point? So political accountability हटा दो. Then democratic decentralization. Yes or no? So democratic बलवंत राय मेहता कमेटी लिख दो इधर शॉर्टकट. बलवंत राय मेहता कमेटी recommended 3-tier form of government. अशोक मेहता कमेटी recommended 2-tier form of government. ठीक है ना? इधर कमिटीज भी हो जा रहा है. Then financial mobilization. So पंचायत राज system purpose is not mobilization, even though they are having some outright tax ऐसा collect कर दे, but their major function is not to mobilization. Mobilization बात ही नहीं है here. Try to understand. So here you can eliminate political accountability, then financial mobilization, है ना? तो क्या हो जाएगा मैं आपको 193 बोलो तो C is your answer. Yes, you want to join ma? You can also join. People you are आगे बैठ जाओ. ठीक है, समझ हुआ है ना? हाँ 2-tier अभी तक वही तो बताया ना, फिर भाड़ में जा. ठीक है ना? अच्छा, अच्छे से नहीं ले रहा. ठीक है. Consider the following statement. लिखो लिखो करो. Done? The minimum age prescribed for any person to be a member of a Panchayat Raj system is 25 years. Yes or no? Why? 21. पहले क्या वोट डालने के क्या रहना चाहिए? 18. Local election 21. MLA MP at the state legislature कल आ जाएगा. कल अच्छा से एक स्टेटमेंट बताता हूं. To become a member of the state legislature, 25 years should be required. To become a member of the parliament, 30 years is required. Yes or no? Huh? To become a member of the state legislature, 25 years is required. Yes or no? तुम बाहर में जा. कैसा होता है बताओ? स्टेट लेजिस्लेचर बोर्ड क्या है? स्टेट लेजिस्लेटिव असेंबली प्लस स्टेट लेजिस्लेटिव काउंसिल. स्टेट वही तो है. देखो स्टेट लेजिस्लेटिव काउंसिल में 30 इयर्स रहना जरूरी है भाई. पर तो स्टेट लेजिस्लेचर में जब सर नहीं है बोलना पड़ेगा ना आप. स्टेट लेजिस्लेचर ठीक है ना? गवर्नर, लेजिस्लेटिव असेंबली, लेजिस्लेटिव काउंसिल. So I am mentioning here to become a member of the state legislature 25 years should be required. Means you are indirectly conveying the legislative council also. Legislative council को 30 years रहना चाहिए. एग्जाम में ये स्टेटमेंट आ गया खत्म. जगदीश here, are you getting my point? State legislature अलग, legislative assembly is अलग. Legislative assembly is part of the state legislature. Try to understand. हाँ ये स्टेट लेजिस्लेचर ही है ना. स्टेट लेजिस्लेचर बोलो तो क्या है? लेजिस्लेटिव असेंबली है, लेजिस्लेटिव काउंसिल भी है. सो 25 years applicable to legislative council also? No. 30 years. इनको समझ नहीं है. ठीक है. हाँ, तो देन बोलना सर ये स्टेटमेंट गलत है सर बोलना है. टू बिकम, क्वेश्चन आ जाएगा, टू बिकम ए मेंबर ऑफ द स्टेट लेजिस्लेचर 25 years शुड बी रिक्वायर्ड. यस सर, नो. नो. क्यों बोले तो उसमें एमएलए भी है, एमएलसी भी है. इनकेस एमएलए बोले तो आज यू सेड दैट इज करेक्ट. पार्लियामेंट में ऐसा बोले तो वो फिर रॉन्ग हो जाएगा सर. हाँ ठीक है सर, लड्डू खिलाना है पूरे लोग को. ठीक है ना. Now the minimum age prescribed for any person to be a member of the panchayat system is 25 years. Yes sir, no दीपक? No. कितना रहना चाहिए? 21. A panchayat reconstituted after premature dissolution continues only for the remainder period. Yes or no? Yes or no? Yes. For example, अभी इलेक्शन हुआ, ठीक है ना, 1 2 3 4 5, ठीक है ना. अभी बाई मिस्टेक कुछ हो गया, 3 साल इधर डिसोल्यूशन हो गया. कितना साल था? और 5 साल है ना. रिमेनिंग पीरियड को वो इलेक्शन कंडक्ट करेगा, रिमेनिंग पीरियड. बट हियर फॉर एग्जांपल 4 years 4 months और 6 months कुछ है, बट रिमेनिंग कितना है? जस्ट 6 months है ना. इतना 6 months को फिर रिमेनिंग पीरियड को करना जरूरी नहीं है. रैदर फ्रेश इलेक्शंस आ जाएगा. आर यू गेटिंग माय पॉइंट? सो हियर ए पंचायत रिकॉन्स्टिट्यूट आफ्टर प्रीमेच्योर डिसोल्यूशन कंटिन्यूज ओनली फॉर द रिमेनिंग पीरियड. यस, ओनली रिमेनिंग पीरियड ओनली, नॉट कंप्लीट 5 years. समझ हो रहा है ना. बट व्हेन इट कम्स टू प्रेसिडेंट ऑफ इंडिया, इलेक्शन को कंडक्ट हुआ तो रिमेनिंग कंप्लीट पीरियड हो जाएगा. पार्लियामेंट को, लोकसभा को रिमेनिंग पीरियड हो जाएगा. आर यू गेटिंग माय पॉइंट? ट्राई टू अंडरस्टैंड. प्रेसिडेंट वाइस प्रेसिडेंट को एंटायर पीरियड हो जाएगा, नॉट रिमेनिंग पीरियड. ट्राई टू अंडरस्टैंड. इंटरलिंक करना जरूरी है. अभी लोकसभा इलेक्शन गया, कुछ गड़बड़ हो गया, तो 2 साल के बाद क्या फिर इलेक्शन कंडक्ट करेगा ना? 5 साल रहेगा, फिर 3 साल रहेगा. 3 साल ही करेगा भाई, रिमेनिंग पीरियड ही रहेगा यार. समझ नहीं आ रहा है आपको? ठीक है ना. इतना लॉजिक बताओ तो दिमाग चलता नहीं है. ठीक है. सो आंसर क्या हो जाएगा इधर? बी इज द आंसर. यस सर, यस सर, यू आर राइट सर. देन 77 करो. ऑनलाइन स्टूडेंट्स, ऑनलाइन स्टूडेंट्स कोई नहीं है क्या? दीपक इधर कौन देख रहा है, कितना लोग देख रहा है, पता नहीं हो रहा है. कुछ तो बताओ यार. कुछ लोग हैं ऑनलाइन में? तो आपको मोबाइल में, ठीक है ना. समझ हो रहा ना मैं जो बता रहा हूं? ट्राई टू अंडरस्टैंड द वर्ड्स, दे विल बी प्लेइंग विद द वर्ड्स. नेक्स्ट, कंसिडर द फॉलोइंग स्टेटमेंट. द इलेक्शन कमीशन, the election commission of India, election commission of India is a constitutional body or statutory body? On which grounds you are saying that? It is placed in the original constitution. constitutional body को क्या रहेगा? independence रहेगा, autonomy रहेगा. yes, parts रहेगा, है ना, more powers रहेगा. if you want to change something, special majority रहना चाहिए. derived from the consolidated fund of India, whatever the salary expenditure made or charged. What is the difference between made and charge? हाँ, ठीक है ना. So election of Commission India is empowered to determine the manner in which Lok Sabha seats are allotted to each state. दीपक ठीक है. No. So अब किधर क्या हो रहा है? Empowered to determine the manner Lok Sabha seats are allotted to each state. Who is determining the each state? Delimitation कौन सा था? Here Parliament, not Election Commission. Parliament. Try to understand what I am conveying here. Parliament is the deciding authority to decide the Lok Sabha seats are allotted to each state, then you are calling territorial constituency. For example, what do you mean by territorial constituency? For example, इधर ले लो, चलो तमिलनाडु को भाई है, तमिल को करते हैं थोड़ा शांत. इधर देखो जगदीश, हियर तमिलनाडु है ना, तमिलनाडु में कितना कॉन्स्टिट्यूएंसी है? हाउ मेनी एमपी सीट्स आर प्रेजेंट? यू डोंट नो, आई थिंक 39 सीट्स, राइट? 39 सीट्स, एक सीट एमपी का क्या हो जाएगा? टेरिटोरियल कॉन्स्टिट्यूएंसी. एक सीट्स है ना. आई एम नॉट टॉकिंग अबाउट द राज्यसभा एमपी, लोकसभा एमपी, टेरिटोरियल कॉन्स्टिट्यूशन. अभी फॉर एग्जांपल वो ये जगह है ना, यू कैन क्लासिफाई एवरीथिंग इज टेरिटोरियल कॉन्स्टिट्यूशन, टेरिटोरियल कॉन्स्टिट्यूएंसी. जगदीश को पता नहीं, तमिलनाडु तंबी है, ठीक है ना. 39 MPs. So every territory is a constitution, territorial constituency. In territorial constitution, first past the post system means direct election, adult franchise. In proportional representation, indirect election, proportional representation. Proportional representation present at what level? President, vice president, Rajya Sabha, legislative council. Are you getting my point? लिख लो ना भाई, बाद में बोल दो. हाँ हाँ लिखो. प्रोपोर्शनल रिप्रेजेंटेशन, प्रोपोर्शनल रिप्रेजेंटेशन प्रेजेंट प्रीवियस में आया था. प्रोपोर्शनल रिप्रेजेंटेशन प्रेजेंट एट दी किसको? प्रेसिडेंट ऑफ इंडिया, वाइस प्रेसिडेंट ऑफ इंडिया, राज्यसभा एंड स्टेट लेजिस्लेटिव काउंसिल. देन फर्स्ट पास्ट द पोस्ट सिस्टम किसको है? लोकसभा, स्टेट लेजिस्लेटिव असेंबली एंड ग्राम सभा को भी है ना. बट अब सेंट्रल एंड स्टेट में ग्राम सभा को भी फर्स्ट पास्ट पोस्ट सिस्टम, इनडायरेक्ट नहीं है ना. आर यू गेटिंग माय पॉइंट? ग्राम सभा में वो जो डायरेक्ट वोटिंग, ठीक है भाई. अभी तो लोकसभा लेजिस्लेटिव असेंबली कन्फाइन करो, ठीक है ना. इधर कौन कर रहा है? पार्लियामेंट. देन द 87th अमेंडमेंट एक्ट ऑफ 2003 प्रोवाइडेड फॉर द डिलिमिटेशन ऑफ कॉन्स्टिट्यूएंसी ऑन द बेसिस ऑफ द 1991 सेंसस. यस सर? यस सर? नो? No, it is based on the 2001 census. Try to write. Online students. वो 1976 प्रेसिडेंट का, ये तो delimitation. So how many times the delimitation commission has been come? 1952, 1962, 1972, 2002. मुकेश हमेशा मेरे से डांट लेता है. मैं कितना बात करता हूं उनको गुस्सा नहीं आता है, इसे फिर चलो सर. 1952, 62, 72, 2002. Are you getting my point? So the Delimitation Commission Act is the statutory body. Means what? Established by an act of parliament. कुछ आर्टिकल है क्या डिलिमिटेशन को सर? मुकेश इल्ले सर, मैं पुदुचेरी में पढ़ा सर, नई बात. सो कुछ आर्टिकल नहीं है, ठीक है ना. समझ हो गया ना. इधर क्या लिखना है? 2001 सेंसस, इधर पार्लियामेंट. क्या आंसर हो जाएगा इधर? डी, नाइदर 1 नर 2. दीपक साइलेंट रह सकते हो क्या? देन मैंडामस, ये करो क्वेश्चन. सौरभ थोड़ा रुको यार. मैंडामस बोलो तो क्या है? सो मैंडामस इज पार्ट ऑफ द आर्टिकल. कौन सा आर्टिकल? इट इज पार्ट ऑफ द आर्टिकल 32. पता नहीं क्या यार? हाँ, इट इज द हार्ट ऑफ द कॉन्स्टिट्यूशन. है आपको? है तो इसमें मैंडामस डाल देना. सो हियर कॉन्स्टिट्यूशनल रेमेडीज, Dr. B.R. Ambedkar, heart and soul of the Indian Constitution, Article 32. Article 32. What are the points present in that Article 32? One is habeas corpus, mandamus, certiorari, then quo warranto, and prohibition. These are mentioned. So here we are discussing about the mandamus. Mandamus is nothing but a weak command. मैं कमांड कर रहा हूं. फॉर एग्जाम्पल, यू आर द गवर्नमेंट ऑफिशियल बट यू आर नॉट डूइंग योर ड्यूटी, देन एज ए हायर कोर्ट सौरभ को क्या बोलूंगा? अभी तो मैनेज कर रहा है, तो मैं टीचर हूं ना, मेरा काम देखना पड़ेगा ना. मैं बोलूंगा डायरेक्ट करूंगा, आपका काम आप करो. क्या सौरभ? देन वो करो, वो काम करेगा. सो ऑलवेज सुपीरियर डायरेक्ट द लोअर लेवल, आपका काम आप करो. सर दिस डायरेक्शन कैन बी अप्लीकेबल टू चीफ जस्टिस ऑफ इंडिया? नो. चीफ जस्टिस ऑफ हाई कोर्ट? नो. प्रेसिडेंट ऑफ इंडिया? नो. गवर्नर ऑफ स्टेट? नो. Are you getting my point? So mandamus is not applicable to these persons. But when it comes to Supreme Court or High Court can direct the lower level. और ट्रिब्यूनल भी है, कुछ भी है, उनको डायरेक्ट कर सकते हैं. आपका काम आप करो, डू योर ड्यूटी. बिकॉज यू आर हैविंग दैट पोस्ट, तो ऑब्वियसली आपका काम करना पड़ेगा. आई एम कमांडिंग, आई एम डायरेक्टिंग यू, डू योर ड्यूटी, डू योर एक्ट. प्रोहिबिशन क्या बोलेगा? इनएक्टिवेट करो मत यार. इनएक्टिविटी, एक्ट, इनएक्ट, पॉजिटिव, नेगेटिव, अगेन हायर. ठीक है ना? सो हियर to indirectly restrain the authority from exercising statutory, indirectly नहीं, डायरेक्ट बोलेगा ये. indirectly restrain authority, तो indirect बोले तो क्या हो जाएगा? गलत. राइट? अगेंस्ट द चीफ जस्टिस ऑफ इंडिया, मैं क्या बोला था अभी? प्रेसिडेंट को, गवर्नर को, चीफ जस्टिस ऑफ सुप्रीम कोर्ट को एंड चीफ जस्टिस ऑफ हाई कोर्ट को नहीं देगा. लिख लो, ये भी गलत. To enforce contractual obligation against a private body performing public duty. For example, you are given some function to perform, even though you are the private person, but you have taken some permission from the government, either state or central. You have to do because you accepted that rules and regulation. So you are public person, even though you are the private person. है ना? Then you have to do. So here statement 3 is correct. Yes or no? C is your answer. Then 79. Online students कितना देख रहे? Three watching. Online students, you people are not responding यार. कोई नहीं दे रहा इधर. Girls, boys, कोई नहीं respond हो रहा है. क्या चल रहा है पता नहीं. हाँ ठीक है. Next, please attempt this question according to the Constitution of India. देखा ना? According to the Constitution of India. Again, they are playing with the words. Just playing with the words. है ना? According to the Constitution of India, the expression district judge includes which of the following judges? District judge. To become judge of the district, क्या रहना चाहिए? 7 years experience रहना चाहिए ना? पढ़ा है कभी? है कुछ experience? 7 साल तो रहना चाहिए ना. ही शुड नॉट बी आइदर सेंट्रल और द स्टेट, नहीं रहना चाहिए. रेकमेंडेड, ठीक है. वो डिस्ट्रिक्ट जज क्या क्या हो सकता है? एडिशनल डिस्ट्रिक्ट जज, जॉइंट डिस्ट्रिक्ट जज, चीफ. सो हियर सेशंस जज बोलो तो डिफरेंस क्या है? सेशंस जज व्हेनेवर ही इज डीलिंग विद द क्रिमिनल केसेस, देन ही इज कॉल्ड सेशंस जज. ट्राई टू राइट सर. सौरभ का काम अच्छा है, हम चिल्ला रहे हैं इधर. क्या सर आपको ऐसा लग रहा है? सर ऐसा कुछ नहीं है सर. हाँ ठीक है. सेशंस जज, ठीक है ना? सेशन जज व्हेनेवर द डिस्ट्रिक्ट जज डील्स विद क्रिमिनल केसेस इज कॉल्ड सेशंस जज. डिस्ट्रिक्ट जज ही है. सिविल बोलो तो डिस्ट्रिक्ट जज, क्रिमिनल बोलो तो सेशन जज, सेम बात सर. राइट? सो इधर क्या हो जाएगा मां? ऑल द ऑप्शन. हाँ है सर. पढ़ा, पढ़ो. हाँ पूरा देखो. नेक्स्ट, दिशा, वेयर दिशा? चीफ जज ऑफ ए स्मॉल काज कोर्ट. हाँ डिस्ट्रिक्ट जज इंक्लूड्स विच ऑफ द फॉलोइंग जजेस. पूरा आ जाएगा ना पूरा. तीसरा चीफ जज ऑफ ए स्मॉल काज कोर्ट. स्मॉल काज कोर्ट पता नहीं तो फिर क्या पढ़ रहे हैं आप? हाँ ये कर, मैं बताता हूँ. कर, टाइम नहीं यार बाबू सर को. हाँ ये कर. हाँ 1 2 3 4 5. आपको एवरी वर्ड को अभी पूरा बताना, एक्सप्लेन करना पड़ेगा. बहुत ही मैं उसमें घुस गया तो दूसरा भी बताना पड़ेगा अभी. हाँ ना, ये 80th क्वेश्चन प्लीज डू. अब आपका नाम भी सौरभ, उनका नाम भी सौरभ. ऊपर भी सौरभ है ना? अच्छा हिमांशु. कंसिडर द फॉलोइंग स्टेटमेंट, क्या वहां जगदीश क्या आंसर ये। सो द असर्शन, ये नया ट्रेंड बना दिया, पहले 2009-10 में ऐसा क्वेश्चन आ रहा था, है ना, पेपर 1 पेपर 2 पब्लिक ज्योग्राफी में पहले था ना कॉम्प्रिहेंसिव, ऐसा आ रहा था, अभी नया ट्रेंड बना दिया। सो ये साल वी आर एक्सपेक्टिंग मोर क्वेश्चन लाइक दिस, है ना। ये स्टेटमेंट हमेशा गलती करता है, इफ यू आर हैविंग कमांड ओवर द टॉपिक यू कैन डू, अदरवाइज ठीक है ना। असर्शन क्या बोल रहा है, द प्रेसिडेंट ऑफ इंडिया इज एन इंटीग्रल पार्ट ऑफ द पार्लियामेंट, यस और नो, ठीक है ना। देखते हैं हम, ए बिल पास्ड बाय बोथ द हाउसेस ऑफ पार्लियामेंट कैन नॉट बिकम लॉ विदाउट द प्रेसिडेंट असेंट, यस और नो। सो हियर कौन है इधर, प्रेसिडेंट ऑफ इंडिया, हियर लोकसभा, हियर राज्यसभा, मीन्स ऑल द come under the bracket of the parliament. Now first statement क्या है, the president is an integral part of the parliament, so integral है ना, he is not member of the house, he is not member of the house, but he is integral part of the parliament. On which grounds we are saying, एक ही assent है क्या, summoning of the house, adjourn of the house, है ना, dissolution of the house, giving permission, अलग अलग functions है ना, without him so parliament is null, कुछ भी है जो है उसमें वो उनका रोल है, so he is part of the integral part of the, so what are the qualifications should be required to become a president of India, citizen of India, by birth or naturalization also, ठीक है, in USA by birth only, not natural, not required, ठीक है ना। और क्या बोल रहे थे, citizen of India 35 years, बस यही है, पूरा पॉलिटी पढ़ के। लोकसभा लिख लो ना कुछ तो कुछ साइड में, ठीक है ना। सो इंटीग्रल पार्ट बोल दिया। देन ए बिल पास्ड बाय बोथ द हाउसेस ऑफ पार्लियामेंट कैन नॉट बिकम लॉ विदाउट द प्रेसिडेंट असेंट, इवन व्हाट एवर यू आर पासिंग एनी बिल, प्रेसिडेंट ऑफ इंडिया थंब रहना जरूरी है। क्वालिफाई, बट लोकसभा को अदर क्वालिफिकेशन, इट डजंट मीन दैट 25 इयर्स 35 इयर्स रहना जरूरी है, ठीक है ना। फर्स्ट सेकंड स्टेट में बोल दिया ना 35 इयर्स रहना, अदर क्वालिफिकेशन, वाइस प्रेसिडेंट को राज्यसभा रहना चाहिए, ठीक है ना। सो हियर व्हाट एवर यू आर पासिंग इन द पार्लियामेंट, आइदर लोकसभा राज्यसभा ज्वाइंट, दैट शुड बी द प्रेसिडेंट ऑफ इंडिया असेंट रहना जरूरी है। विदाउट हिज परमिशन, विदाउट हिज असेंट नो बिल बिकम एन एक्ट। कुछ भी करो, कितना भी मेजॉरिटी लगा लो, स्पेशल लगा लो, धमाका लगा लो, कुछ भी, बट प्रेसिडेंट बोल दिया, अंदर रख लिया, खत्म, है ना। मुकेश क्या आंसर है इधर, ए एंड आर बोथ आर ट्रू एंड आर इज द करेक्ट एक्सप्लेनेशन फॉर ये। जगदीश यस सर, नो सर, कुछ तो रेस्पॉन्ड हो सर, मुझे देख रहे हो तो डर लग रहा है, मैं कुछ गलत बोल रहा हूं क्या। नेक्स्ट करो, कंसिडर द फॉलोइंग स्टेटमेंट विद रिस्पेक्ट टू जजेस ऑफ द सुप्रीम कोर्ट ऑफ इंडिया। बाबू सर आ गया, बताओ। हाँ, सुप्रीम कोर्ट जज ऑफ इंडिया क्या है, जजेस ऑफ द रिस्पेक्ट टू, पहले देखते हैं। सो ए पर्सन हु हैज बीन एडवोकेट फॉर ओवर 10 years, यस और नो। पहले सुप्रीम कोर्ट जज को क्या क्या रहना चाहिए, क्वालिफिकेशन बताओ। सिटीजन रहना क्या चाहिए, ऑनलाइन स्टूडेंट, ही मस्ट बी सिटीजन ऑफ इंडिया। सो जज ऑफ हाई कोर्ट कितना रहना चाहिए, कम से कम 5 years, एडवोकेट 10 years, और डिस्टिंग्विश्ड जूरिस्ट और एमिनेंट जूरिस्ट इन द ओपिनियन ऑफ द गवर्नर और मुकेश, प्रेसिडेंट ऑफ इंडिया। तो इधर क्या बोल रहा है, ये पर्सन हु हैज बीन एन एडवोकेट फॉर 10 years, सही है नहीं है। In any high court can be appointed as the judge of the Supreme Court, yes. Then the constitution has not fixed the tenure as well as the minimum age of a judge of the Supreme Court. क्या एज रहना चाहिए सुप्रीम कोर्ट को, 65 रहना चाहिए टू बिकम ए जज ऑफ द सुप्रीम कोर्ट। सर सो एज प्रिस्क्राइब नहीं किया यार, ओनली 65 years, ठीक है ना। अब रुक गया सर. सो इधर क्या हो जाएगा आपको? हैज नॉट फिक्स्ड. बोथ द स्टेटमेंट आर करेक्ट. हाँ, हैज नॉट फिक्स्ड बोल तो सही है ना. हैज नॉट फिक्स्ड. उनके एज मिनिमम एज किया क्या? क्या बोल रहे हो सर? हाँ, आपको समझ नहीं आता, बाद में आ जाए. नेक्स्ट क्वेश्चन, लास्ट क्वेश्चन सर. विथ रेफरेंस टू ग्राम सभा. ग्राम सभा पंचायत राज सिस्टम में रहेगा या म्युनिसिपालिटी में रहेगा? कौन सा कॉन्स्टिट्यूशनल अमेंडमेंट लेके आया था? विच कॉन्स्टिट्यूशनल अमेंडमेंट एक्ट? 73rd कॉन्स्टिट्यूशनल अमेंडमेंट एक्ट ऑफ 1992. अंडर विच पार्ट कौन सा डील कर रहा है ग्राम सभा को? 9th. कौन सा शेड्यूल? 11th. वेरी गुड. नाउ इट इज अ विलेज असेंबली कंसिस्टिंग ऑफ ऑल द एलिजिबल वोटर्स. सुनो, ऑल द एलिजिबल वोटर्स सही है, बट वो क्या रहना चाहिए? रजिस्टर होकर रहना चाहिए. रजिस्टर होना रहना जरूरी है. समझ नहीं आया? ठीक है ना. एलिजिबल ठीक है, आपको 18 ईयर्स है, बट उसमें रजिस्ट्रेशन में आपका नाम ही नहीं है, तो फिर क्या फायदा है? राइट. सो कंसिस्टिंग ऑफ ऑल द एलिजिबल वोटर्स मींस रॉन्ग. इन केस इधर रजिस्टर्ड एलिजिबल वोटर तो ठीक है ना. इन द एरिया ऑफ योर पंचायत, सो उधर रजिस्टर्ड नहीं है, इसलिए स्टेटमेंट गलत. लिख लो ना थोड़ा, रजिस्टर्ड. ठीक है ना. इट में एक्सरसाइज पावर्स एंड परफॉर्म फंक्शंस एट द विलेज लेवल. देखो ना, ये वर्ड वेरी वेरी इंपॉर्टेंट. मे, नॉट, शुड और मस्ट. एग्जाम में पूछ लेगा. इट में एक्सरसाइज बोल रहा है. कल एग्जाम में इट शुड एक्सरसाइज पावर्स एंड परफॉर्म फंक्शंस एट द विलेज लेवल एज द स्टेट लेजिस्लेचर डिटरमाइंस. नो, इट में डिसाइड करेगा नहीं करेगा, दैट इज द अप टू द स्टेट लेजिस्लेचर. इसीलिए इट में एक्सरसाइज पावर्स एंड परफॉर्म फंक्शंस एट द विलेज लेवल और कौन सा? स्टेट डिसाइड. स्टेट लेजिस्लेचर डिसाइड. कल बोलेगा स्टेट लेजिस्लेटिव असेंबली डिसाइड. यस और नो? इधर क्या बोल रहा है? स्टेट लेजिस्लेचर बोल रहा है. फिर ठीक है ना. स्टेट लेजिस्लेचर करेक्ट, नॉट स्टेट लेजिस्लेटिव असेंबली और स्टेट लेजिस्लेटिव काउंसिल. समझ हो रहा है ना? टर्म्स ऐसा ही प्ले करते हैं यार. मे जगह मस्ट लगाते हैं, स्टेट लेजिस्लेचर जगह स्टेट लेजिस्लेटिव असेंबली और स्टेट लेजिस्लेटिव काउंसिल बोलते हैं, और गवर्नर डिसाइड्स. ट्राई टू अंडरस्टैंड. समझ हो रहा है ना? सो दीज आर द स्मॉल थिंग. सो हमारा आंसर क्या हो जाएगा? मैं इधर ओनली वन और ओनली टू और बोथ और नन ऑफ द अबव. ओनली बी इज आवर आंसर. ठीक है ना. छोटा छोटा बाद में बड़ा इंफॉर्मेशन बढ़ता है. समझ हो गया मुकेश? सो नेक्स्ट में ऑनलाइन स्टूडेंट्स वी आर गिविंग ब्रेक. 10 मिनट्स ब्रेक दे रहा हूं एंड विल कम अप विद दी बाबू सर एंड मी. अच्छा से फिर एनर्जेटिक लगाएंगे. ठीक है ना. ओनली 15 क्वेश्चंस, नो ब्रेक रहना जरूरी है. ठीक है ना. ऑनलाइन स्टूडेंट्स जस्ट 10 मिनट्स. 10 मिनट्स में फिर आने के बाद 15 क्वेश्चन करते हैं. ठीक है ना. कॉम्प्रिहेंसिवली वी विल बी डीलिंग एंड आई विल बी गिविंग सम स्ट्रेटजी रिगार्डिंग द हाउ टू प्रिपेयर द प्रिपरेशन. बी राइट. थैंक यू.
All right, students, will continue with the next question. So please come to question number 83. So we'll move to the next question, question number 83. Online students, please you can continue with what we have discussed. So looking to question number 83, I think these questions are now coming from the topic of panchayats. So looking to question number 83, statement number 1, consider the following statements regarding the duration of the panchayats. If you look into the duration of panchayats, statement 1, panchayat at every level are provided with a 5-year term of office. What is the term of the panchayat? What are the different levels of panchayat as per the constitution? The 73rd Constitutional Amendment Act 1992 has given constitutional status. And with the constitutional status, it has made certain things mandatory. Has it made something mandatory? And one thing that it has made mandatory is the 3-tier structure of panchayat. So every state should have 3-tier structure. You have not the gram panchayat, village panchayat, then district panchayat. In between them, there is an intermediate panchayat. So what would be the term of these panchayat at all the 3 levels? Is it same at all the 3 levels? What is the term of the panchayats? The panchayat at every level is provided with a 5-year term. That is true. Every level the panchayat is, what is the term? 5 years. At the village level, intermediate level, and at the state level as well. Sorry, district level. Second statement, a first election to be conducted should be conducted in all the cases. The key word here is in all the cases where a panchayat prematurely dissolved. Now what do you mean by premature dissolution of panchayat? Before completing 5 years term. Okay, suppose before completing 5 years term, let us assume the Lok Sabha is dissolved before completing 5 years term, or the Legislative Assembly is dissolved before 5 years term. Then we have to constitute a new Lok Sabha and a new Legislative Assembly. What will be the term of the new Legislative Assembly or the Lok Sabha? Full 5-year term. Suppose let us assume here a panchayat is prematurely dissolved after 3 years. Then a new panchayat has to be constituted. What will be the term of the new panchayat? It is only the remainder of the term. But is it in all the cases? That is a question. It is true in general, but is it in all the cases? If the term of the panchayat, the remaining term of the panchayat is less than 6 months, then there is no need to reconstitute the panchayat. So it is not in all the cases you'll have to reconstitute. When the term is more than 6 months, then you reconstitute the panchayat, and that panchayat will be for the remainder of the term. So here the key word is what? In all cases. It is not required in all the cases. It is required in the cases where the term is more than 6 months. If it is less than 6 months, not required. But once the panchayat is reconstituted, it will always be for what? It will always be for the remainder of the term. Okay? So this is true. Statement number 3. A panchayat reconstituted after the premature dissolution does not enjoy the full 5-year periods. So is it true? A panchayat reconstituted after the premature dissolution. So what happens in case if the panchayat is prematurely dissolved? The panchayat reconstituted after premature dissolution does not enjoy the full 5 years. It's only for the it is only for the remainder of the term. So this is true. So what is the answer here? Which of the statements given above are correct? If you exclude statement number 2, so the right answer would be option C, 1 and 3 only. Okay, very, very important. Such simple questions are usually asked. Come to the next question. Come to the next question. Okay, so have a look into the next question. So consider the following statements with respect to the writ jurisdiction of the high courts. What is the article that gives the writ powers to the high courts? Article 226. Article 32 is for the high courts. Sorry, Article 32 is for the Supreme Court, and for the High Court it is Article 226. Statement 1, unlike the Supreme Court, High Courts can issue writs for the enforcement of even ordinary legal legislations. Is that possible? Now, in fact, you should understand the differences in terms of the writ jurisdiction when it comes to the Supreme Court and High Court. In case of Supreme Court, the Supreme Court can issue writs only for what? Only for the fundamental rights. But what about the High Courts? It can issue writs for both the fundamental rights as well as the legal rights. So this is true. The writ jurisdiction is a part of the basic structure of the Constitution. Is it part of the basic structure? That means Article 32 and Article 226 in general, are they part of the basic structure? the Supreme Court has said that they are part of the basic structure. There is a case which is called as L. Chandrakumar case. In L. Chandrakumar case, the Supreme Court categorically said that this power cannot be taken away even by way of a what? Even by way of a constitutional amendment. Okay, so that is definitely true. So let's try to remember this in your mind. So this statement is also true. The writ jurisdiction is part of the basic structure of the constitution. This is also true. What is the answer? Both? Both 1 and 2. Very good. Okay. So come to the next question. '85. Consider the following statements. If you see, consider the following statements with reference to the judiciary in India. Statement 1. So this is statement regarding the judiciary. 1. The strength of the Supreme Court is decided by whom? The strength of the Supreme Court is decided by the Parliament. Now, do you know what is the strength of the Supreme Court at the commencement? It is mentioned in the Constitution. At the commencement of the Constitution in 26 January 1950, it is 7 plus 1 judges. 7 judges of the Supreme Court and 1 Hussain judge. Sorry, 1 Chief Justice and 7 Hussain judges. That is what is mentioned. But today, what is the strength? So at the commencement 7 plus 1, and then if you look into Article 124 of the Constitution, Article 124 of the Constitution says that the Parliament can make a law, and by that law they can increase the strength. The Supreme Court Number of Judges Act was passed. The Supreme Court Number of Judges Act was amended time to time. And today, what is the present strength of the judges in Supreme Court? It is how much? It is 33 plus 1. 33 judges plus 1 Chief Justice of India. So overall 34. So, but the question is right, the statement is right, the strength of the Supreme Court is decided by whom? It is decided by the Parliament. Statement 2. Only the Supreme Court can punish for the contempt of itself or for any of the subordinate courts. Is it true? This power is also given to the high courts. For the Supreme Court, this power is given under Article 129. And for the High Court, this power is guaranteed under Article 215. Okay, so this power is there for the Supreme Court and the High Court. So the word only makes it wrong. No person has yet been appointed as a judge of a Supreme Court under the category of a distinguished jurist. Do you know as to who can be appointed as a judge of a Supreme Court? So anyone who has been a judge of a High Court for 5 years, anyone who is a practicing advocate in High Court for 10 years, and then the third category is someone who is a distinguished jurist. Now, a distinguished jurist is basically an academician who has a lot of academic knowledge. Say, for example, a professor who is teaching law. But under this category, not even a single person has been appointed as a judge till this point of time. So this is factually true. This has recently come in the Indian Express paper also. It was published in Live Law website also, which the Supreme Court itself releases a lot of things. So this is definitely true. No person has been appointed under this category. So this is also true. What is the answer now? The correct answer is, so which of the following statements are correct? So they're asking about correct. The strength of the Supreme Court is raised by the Parliament. That is correct. Only the Supreme Court can punish for the contempt of itself or any of the other subordinate courts. So that is not only with the Supreme Court. So no person has yet to be appointed. So this is true. Okay, so this is true. So this is true. So what is the answer now? Option 1 and 3 only. Very good. So Mukesh, whenever you see like that, you just tell it from there. Okay, because close proximity, sometimes we are not able to read it properly. Come to the next statement. In the context of Indian polity, consider the following statements regarding the constitution of 1. It was introduced in the second judge's case. When was it was something has to be added. In the context of Indian polity, consider the following statements regarding the constitution of collegium. Have you heard of the word collegium? Collegium is a group of judges who recommend the names for the appointment of the judges of the Supreme Court and High Court. So when this collegium, is it mentioned in the Constitution? So who innovated this? The Supreme Court of India has innovated this. And when it was innovated by the Supreme Court, it was innovated in the second judge's case. So far there are 4 judges' cases. The first judge's case, and then you have the second judge's case in 1993, third judge's case in 1998, fourth judge's case in 2015, which is also the National Judicial Appointments Commission case. But when was this was first introduced, the term collegium? It was introduced in the second judge's case in 1993. Statement 2. The third judge's case expanded it to a 5-member body, including the Chief Justice of India. Is it true? So in fact, in the second judge's case, when the collegium was, I would say, innovated by the Supreme Court, the collegium comprised of Chief Justice of India plus 2 senior judges, which was further expanded to what? Which was further expanded in the third judge's case to Chief Justice of India plus 4 senior judges. Right? So here, what is the answer in this case? It was introduced, so this is true. The third judge's case expanded, that is also true. The system has an official secretariat which prescribes the selection process. One of the biggest drawback of the collegium system is that the selection process is not formal. It is according to what is decided by the collegium. They do not invite application forms, they do not scrutinize the forms. And in fact, there is a complete lack of transparency with regard to how the collegium is making the recommendation. If the secretariat is there, if the application forms are invited, then there's a lot of transparency, which is not the case, which is basically the criticism of what? Which is basically the criticism of the collegium system. So this is definitely not true. Which of the statements given above are correct? It is option 1 and 3 only. Very good. Okay, sorry, it is option C. Because statement 3 is wrong, so option 1 and 2 only. Come to the next thing. Fast track courts. First, we'll have to understand about this fast track courts. What is the purpose of this fast track courts? Whenever a matter has to be decided by the court, it takes a lot of time. Suppose if there are certain urgent matters, like criminalization of politics is there, politicians having criminal records. And for them, there is a need to immediately fast track the cases. Otherwise, it's very difficult. And even before the trial is over, they may complete their term. So there is a need to fast track certain cases. Having this in mind, in certain cases, the fast track courts are established in our country. Okay, so with regard to that, let us try to understand that. The fast track courts are established by the union government in consultation with the respective high courts. No. Administration of justice is an item in the concurrent list. So both the parliament and the state legislature can make laws. So this is done by the state government. Because the fast track courts are usually the trial courts. Trial courts means what? They are all subordinate courts. The trial cannot happen in the High Court or in the Supreme Court. It can happen where? It can happen only in the subordinate courts. And the subordinate courts are mostly controlled by the respective state. So that means the fast track courts are established not by the union government, but by whom? But by the state government. Very good. So this is wrong. The judges of the fast track courts are appointed on ad hoc basis. That is true. As long as there is a need, they are appointed. This is definitely true. So what is the answer here? It is option B. B is the right answer. Mukesh, you got it right? Saiwa? Jagdish? So here you got it wrong. Union government. So try to remember, what are trial courts? Trial court means subordinate courts. So subordinate courts are under the control of whom? Under the control of the state government. So have this understanding. Come to the next question. Question number 88. Consider the following statements regarding the zonal councils. What is the zonal councils? Zonal councils, first of all, you'll have to understand what is the status they have. They have a constitutional status, they have a statutory status, or do they have a body? There's a body which is established by executive resolution, because that is one way the question can be asked. Now try to remember, zonal councils today in our country has got statutory status. When I say the statutory status, that means they are established by what? They are established by an act of parliament. And what is that parliamentary act? State Reorganization Act. So which act has provided for this council, zonal councils? State Reorganization Act of 1956. And the State Reorganization Act of 1956 has provided for 5 zonal councils. How many zonal councils? 5 zonal councils, one for every zone. One for the central zone, northern zone, southern zone, eastern zone, and the western zone. So these are the 5 zones that has been provided. And for all the zonal councils, who will be the chairperson? The Union Home Minister. Very, very important. The Union Home Minister is the chairperson. And who will be the members? The respective chief ministers of that particular state will be members. And in rotation, one of the chief ministers will also be the vice chairperson. Now this is all about the zonal councils. The very idea of the zonal council is in line with the federal provisions, that there should be some cooperation between the center and the states and between the states. Okay, so that is the idea. So at the regional level, if there is any issue, they can easily resolve these issues. That's the idea. But what you'll have to understand here is, Apart from that, there is also one council for the northeastern states. The Northeastern Councils Act has been passed. So there is a separate council, similar council for the 7 northeastern states, okay? Including Sikkim, 8 states, there is a northeastern council. So just try to keep all these things in your mind. Now come to statement number 1. These are advisory bodies which are created under the provisions of Indian Constitution. Is it true? What is the status of these bodies? Is it a statutory body or a constitutional body? It's not a constitutional body, although it is partially right. It is an advisory body. It is not that the decisions are binding upon the government. It's an advisory body. It's a recommendatory body. But it is not a constitutional body. So it is wrong. Statement 2. The Union Home Minister acts as the chairman of all zonal councils. Is it true? Including the Northeastern Council. He is the chairperson. True. There are 4 zonal councils that in total that covers 28 states in India. Is that true? Today we have, including the Northeastern Council, we have 6 zonal councils. Okay. So under the State Reorganization Act, 5 zonal councils. So 1 and 3 is wrong. Which of the statements are correct? So the answer is what? Answer is option 2. Now similarly, there is also one more body which is called as Interstate Council. What is the position of this Interstate Council? Is it a constitutional body, statutory body, or is it a body established by executive resolution, executive body? Interstate Council is a constitutional body. It is established under Article 263 of the Constitution. Interstate Council. I am not talking about interstate river water disputes. That interstate river water disputes, the Parliament can make a law under Article 262, not under Article 263. Interstate Council under Article 263. So today go home and see what is this Interstate Council. So sometimes question can come in the Interstate Council or from the Zonal Council. So whenever you do a topic, you have to do everything from that topic. Okay, come to the next question. Come to question number 89. Consider the following statements. Pursuant to the report of Hutchins-Sanyal Committee. This Hutchins-Sanyal was once the Solicitor General of India. Or I would say, to be very specific, he is the additional Solicitor General of India. Not now, earlier. Some 2-3 decades earlier, he was additional Solicitor General. Pursuant to the report of Hutchins-Sanyal Committee, the Contempt of Court Act 1971 was passed. In fact, why this committee was appointed is to punish the people who are engaging in what is called as contempt of the court. What do you mean by contempt of the court? Showing disrespect to the authority of the court. So anybody showing disrespect to the authority of the court or to the judges, it can be seen as what is called as the contempt of the court. Now there is no law in our country. When Hutchins-Sanyal Committee was appointed, there was no law in our country as to how to be punished. Although the Constitution makes the Supreme Court and the High Court to be contempt courts. They can punish for the disrespect to the courts. But what is defined to be contempt? It was not there. It is not defined in the Constitution, or what shall be the punishment to be given in case of contempt. Nothing is there. So that is why the Hutchins-Sanyal Committee was appointed by the government and to give some recommendation. And he gave the recommendation that you make a law, and in that law you define what is called as the contempt, and you also prescribe the punishment for the contempt. So this statement is true or wrong? This is definitely true. Subsequent to that, the Contempt of Court Act 1971 was passed. Statement 2, the Constitution of India empowers the Supreme Court and High Court to punish for the contempt of themselves. Is it true? That means the High Court and the Supreme Court in our country today, they can punish the people who are showing disrespect towards themselves, that is to the Supreme Court and High Court, and also towards the subordinate courts also. But here, yes, this is definitely true, so this is true. The Constitution of India defines civil and criminal contempt. Is it true? Just now I said that the Constitution does not define contempt. Then how do we know what is contempt? It is defined in the Contempt of Court Act 1971. The Contempt of Court Act defines contempt into 2 types of contempt, civil contempt and criminal contempt. So you can say civil contempt is a mild form. Somebody is showing non-compliance. Say for example, the judges are passing an order to appear before the court. Somebody failed to appear before the court without the permission of the court. Then it's a civil contempt. What is criminal contempt? Somebody is acting prejudicially against the court. Somebody is preventing the court from administering justice. Somebody is openly saying that this judges do not know anything. The Supreme Court of India is of no use. That means then they are trying to reduce the confidence of the judiciary in the general public, which can be seen as what? Which can be seen as criminal contempt. For civil contempt, normally the punishment is fine. For civil contempt, the punishment could be fine, it could be imprisonment, or both. So all the 3 punishment can be given by the judiciary. But who prescribes the punishment? It is given in the Contempt of Court Act 1971. What is the quantum of the punishment? Okay, so this is definitely, the Constitution does not say this, but where it is? It is in the Contempt of Court Act 1971. It's an ordinary law, so this is wrong. In India, the Parliament is vested with the power to make laws on the contempt of court. Is it true? Because contempt of court is an item in the union list. You go to the union list, in the union list contempt of court is mentioned. If something is mentioned in the union list, who has the power to do that? The Parliament has the power to do that, so this is definitely true. So what is the answer in this case? Which of the statements given above are correct? It is 1, 2, and 4. So what is the answer? Option B is the right answer. Come to the next question. With reference to India, consider the following statements. 1. So this is a very good question. So you should have an idea as to what is judicial custody and what is police custody. What is judicial custody means? What does police custody means? So whenever an individual has done some mistake, and immediately the police is arresting them, and they are kept in the police station for 24 hours. The 24 hours of custody is what is called as police custody. As per the fundamental right of that individual, so this individual has to be produced before the nearest magistrate within how much time? 24 hours. So till 24 hours he is in which custody? Police custody. And after 24 hours he will be produced before the magistrate. And then if there is a need for further remand to inquire into that particular matter, then he can be placed under which custody? Judicial custody. So under police custody he is in police station, he is under the control of the police in charge. When he is in judicial custody, he is not in police station, he is in jail. And he is under the control of whom? He is under the control of the judge whoever has ordered. So what is the need for this judicial custody? The need for the judicial custody is two things. One is to prevent the unnecessary harassment. That is one objective. But the major objective is that allow the police to investigate in that matter. Because if this individual is released, he might go somewhere if the police have to further investigate. 24 hours time is not enough for a police officer to investigate that matter. So he needs some time, and for that he is put under what? He is kept under what is called as judicial custody. So during this time, can the police officer investigate that individual? The police officer, can he question that particular individual? He can do that, but with the permission of the judge, not without the permission of the judge. So it allows the investigation also, but prevents the harassment or the physical harassment of the person who is kept in jail also. Okay, that is what you should understand. Now with this objective, come to the question. Judicial custody means an accused is in the custody of the concerned magistrate. Is it true? Here we are talking about judicial custody. There are two things which is called as police custody and judicial custody. What happens first? First it is judicial custody or police custody? First police custody, then judicial custody. So judicial custody means accused is in the custody of whom? Accused in the custody of the magistrate. Is it true or false? This is true. Till this point of time it is true. And such accused is locked up in the police station, not in jail. Is it true? The second part is wrong, because in case of judicial custody, where he is? He is there in the jail, not in the police lockup. So this is wrong. 2. During judicial custody, that means when he is remanded by the judge, during judicial custody, the police officer in charge of the case is not allowed to interrogate the suspect without the approval of the court. Is it true? He is allowed to do that, but with approval of the court. So this is true. So what is the answer here? Which of the statements are correct? It is option B only. B is correct. Come to the next thing. Consider the next thing, 91. Which of the following statement is correct regarding the cantonment board? Now first we'll have to understand what do you mean by cantonment board. So cantonment board means that we know that there is some type of municipalities, urban local bodies in our country. So cantonment board is one form of urban local body. So for example, Delhi is a municipal corporation. There can be smaller towns municipality. Certain transitional areas there can be Nagar Panchayat. And if there is an industrial establishment, there can be township. If there is a port, there can be a port trust, seaport. So similarly, cantonment board is certain areas as a permanent military establishment. Wherever there is a permanent military establishment, there can be some civilian population also there. Nearby, some civilian population is a thing, and some military people are also staying, a permanent establishment. In those areas, one administrative setup is allowed under our country, under our legal system, is what is called as the cantonment board. So normally you tell me, if there is an administrative setup there, who will preside over that? So who can preside over that? the commanding officer of the canton, the commanding officer of that particular cantonment or that particular military officer who is the highest rank officer, he will preside. He is the ex officio president. And then the vice president can be elected from among the general people. Things has to be, basically it's an administrative setup. They take out decisions to carry out the administration in that particular area. Now come to that, it works under the administrative control of state government. Does defense military comes under the administrative control of state government? So it comes under the administrative control of Ministry of Defense. Okay, so it is not under the state government, so that is wrong. The executive officer of the cantonment board is appointed by the governor of the concerned state. The governor has no role with regard to the army. Okay, so that is also wrong. He is not appointed by the governor, but he is an ex officio chairperson, ex officio president. Ex officio means what? Automatically. Nobody has to appoint that. Automatically he will become that. By virtue of being the head of the commanding, by virtue of being the commanding officer of that army there. Rather it is a vice president who is elected from the general public and not the president. So now come to the last thing. The military officer commanding the station presides over the meeting of the cantonment board. He is the president and he presides over that. So the answer is what? The answer is option D. Come to next thing. Next question. Consider the following statements with respect to the Supreme Court of India. The Supreme Court of India was inaugurated with the commencement of the Constitution. Does it come on the same day at the commencement of the Constitution? When the Constitution came into force? 26 January 1950. The Supreme Court came only on 28th of January. Okay, so there is a small gap, factual thing, but just try to remember, it did not come at the same time. It was not inaugurated. After independence, the Supreme Court replaced the British Privy Council as the highest body of appeal. What is this Privy Council? Who consisted of this Privy Council? This was a system which was followed by the Britishers. When the Britishers were there in India, there was a concept of what is called as Privy Council. No. So at that point of time also, we had the Supreme Court. But the Supreme Court was not the highest court of appeal. Today, the Supreme Court is the highest court of appeal. Can we make any appeal apart from the Supreme Court? In what happened at that point of time in Britishers, they were all Privy Council, means they are advisors to the crown. Who are these people? The crown could be king or the queen, but they are the advisors to the crown, and this Privy Council had representation from number of areas. The ministers were there, some advisors were there, some judges were there. So it's basically an advisory body when it comes to the legal matters, when it comes to, I would say, matters which has been decided by the Supreme Court. So ultimately the Supreme Court was not the final authority. Then subsequently an appeal can be made to whom? To the Privy Council. The Privy Council members might look into this and they can change the decision which is given by the Supreme Court. But with the advent of the Constitution, with the commencement of the Constitution, the Privy Council was done away with. So now who is the final authority in our country? It is the Supreme Court. Okay, so this is definitely true. So what is the answer here? Which of the statements given above are correct? Option B is the right answer. Who is looking into a matter to give a judgment? It's a general term. Anybody could be a jury. In fact, we had this jury system even in the lower courts also. Jury system means that you call upon certain categories of people along with the judges, the civilians who may be concerned in that particular matter. A jury of people will decide that matter, not the judge. That is a jury system. So Privy Council means whoever were advisors to the crown. They are only called as the Privy Council. The jury system was also abolished in our country. So the law in our country allowed for jury system. I think till 1960s or something it existed. But subsequently it was abolished. In fact, there was a famous case, I think, which is called as Nanavati case. You can just look into that case, what that Nanavati case is. So subsequent to that case, the jury system was eliminated from our country because the jury system had given a very wrong judgment. There's a lot of criticism about this judgment. Then it was done away with. Now who can give judgment? Only the judges. Jury system is done away with. So jury system, I would say it's a general term. And people who are part of the British, this Privy Council, they're also juries. But they are at the highest level. So jury system means any civilian, not a judge, still they are authorized to pass a judgment, then that's basically what is called as a jury system. But this is at the highest level. Come to the next question, question number 93. Who among the following are eligible electors in election to the members of the Legislative Council of the state? So basically, who will have the right to vote in the legislative council? Legislative council, direct election or indirect election? Indirect election by means of proportional representation. Indirect election means not everybody will have the right to vote. Only certain categories of people will have the right to vote. So who among these categories of people will have the right to vote? Members of municipalities of the state, will they have the right to vote? They have the right to vote, true. Graduates of 3 years standing and residing within the state, will they have the right to vote? So here the most important thing is 3 years standing. Minimum they should have completed their graduation before 3 years at the time of voting. Teachers of 3 years standing in a state not lower than the secondary educations. Is it true? Is it primary or secondary? Secondary? 3 years or 5 years? So both the things are right. It should be 3 years in standing and minimum of secondary level. What do you mean by secondary level? Above? Above, it should be not like above. When you say secondary level, not less than 12th standard, in the sense that they should be teaching 9th, 10th, 11th and 12th. In these areas they should be teaching. That's the secondary level. Anything up to 8th standard is primary level. Okay. And the last thing is members of the legislative assembly of the state. So do they have the right to vote? The members of the legislative assembly, of course, they also have the right to vote. Only these categories. And apart from that, there is a nomination also. Who nominates the members? The governor. And how much members he nominates? 1/6 of the members is nominated by the governor. That 12% will be nominated by the president. Here it is how much for the governor? For the governor it is 1/6. President will nominate 12 members in the Rajya Sabha. Okay, so what is the answer here? It is option C, 1, 2, 3 and 4, all of the above. Come to the next question. Consider the following statements regarding the Metropolitan Planning Committee. So you just have a look into these two things also, which is especially part of the municipalities. There are two things which is called as the District Planning Committee and the Metropolitan Planning Committee. These are largely dysfunctional today in our country. The composition of this Metropolitan Planning Committee and the District Planning Committee is not mentioned in the Constitution. So who can determine the composition? The Parliament can make a law, and by that law they can, the state legislature can make a law, and by that law they can determine. But few guidelines are given in the Constitution. Okay, so come to the first statement. The state legislature makes provisions for the composition of the Metropolitan Planning Committee. Is it true? So Metropolitan Planning Committee means, say for example, Delhi is a metropolitan area. For the metropolitan area, there is a committee. That committee will give idea as to how to develop this metropolitan area. So this is definitely true. This is given in the Constitution. And further, 3/4 of the members should be elected by the members of the municipalities and chairpersons of the panchayat in the metropolitan area from amongst themselves. So everything is true. The only thing that is not in line with the Constitution is instead of 3/4, it is 2/3. So here how much? 2/3 of the members. And then the last thing is the chairperson of such committee shall forward the developmental plan to the state government. Is it true? This is true. This is what they have to do. Basically, it is just an advisory body. They will make all the developmental plans and finally the chairperson will forward for the perusal of the state government. Okay. So this is true. So what is the answer here? If you eliminate option 2, the answer is option 1 and 3 only. This one. So this has to be, this is a constitutional body. This is a mandate. The composition can be determined by an act, but the body is established by the Constitution itself. Okay. It's a constitutional mandate for the states. Come to question number, which question we are right now in? 95 or 94? Come to question number 95. Which of the following are the constitutional safeguards for the independence of the Supreme Court? So otherwise, what are the various things that is there in the Constitution to ensure the independence of the Supreme Court? So they have the power to punish for its contempt. Is it there? Which article? Article 129. They have the freedom to appoint their staffs. Article 146, but you don't have to remember that. In fact, who will recruit the staffs of the Supreme Court? Staffs doesn't mean the judges. Staffs means a clerk, clerical post, people in the registry of the Supreme Court. So who are all recruited by whom? By the Supreme Court itself. They have the power to do that. Okay, so they have the freedom to appoint their staffs. ban practice after retirement. In fact, as there's a ban on the Supreme Court judges being practicing, so this is also true under the Constitution. Its jurisdiction cannot be curtailed by the Parliament. Now, what are the different jurisdictions of the Supreme Court? Appellate, very good. Writ jurisdiction. Then you have advisory jurisdiction. Then you have the review powers for the Supreme Court. You have special leave jurisdiction. A number of jurisdictions are there. So, can this be curtailed by an act of Parliament? It cannot be curtailed. It can be increased, but it cannot be curtailed. Okay? So, it cannot be taken away. This is one way that the independence is given. So, what is the answer here? It is 1, 2, 3 and 4. So, D is the right answer. Very, very important. Every year, you can just go to the last 10 years of paper. Every year, there is a question from Supreme Court. And most likely from the jurisdiction of the Supreme Court. So, very, very important. Come to the next question. With reference to the municipal corporations, Delhi is a municipal corporation. Consider the following statements. The council of the municipal corporation is the legislative wing of the corporation, consisting of both the elected and the nominated members. Is it true? Now, say for example, for every municipal corporation, people are elected. From every ward, people will be elected. They are called as councillors. And the councillors will be there in the municipal corporation. So they do perform a deliberative functions. They are the one they will discuss as to what has to be done for the welfare of the municipal corporation. But what is the difference? Although their function is similar to that of the legislative wing, or they perform a deliberative functions, can a municipal corporation make laws? Can this legislative wing, can this council of the municipal corporation, are they empowered to make laws similar to that of parliament and state legislature? They are not empowered to make laws. They cannot make laws, but their function is similar to that of a legislative wing. They will discuss, they will deliberate, they will make the executives accountable. Okay, but they cannot make law, but their function is similar to that of what? Some function is similar to that of a legislative function. They have no taxing powers. The taxing powers is to be decided by the law passed by the concerned state legislature. The state legislature will pass a law, and by that law they can allow them to collect the tax. If the state legislatures by law allow them, then they can collect the tax. Okay? So this is what they can do. So, but this is true. Mayor's main function is to preside over the meetings of the council. Is it true? Mayor is what? Mayor is the executive. And say, let us assume mayor is like the prime minister, let us assume, or mayor is like the chief minister at the lowest level. So his main function is to preside over the council. That is true. The municipal commissioner is the chief executive authority of the corporation. Is it true? That is also true. The municipal commissioner is the chief executive. This municipal commissioner is appointed by whom? By the state government, who is usually an IAS officer. Okay? So this is true. So what is the answer here? So the answer is option D. D is the right answer. Come to the next question, question number 97. Consider the following statements with regard to Gram Nyayalaya. So Gram Nyayalaya means mobile courts. That is what you will have to understand. So many people in our country, they are not accessible to justice because the judicial system is not located everywhere. They have to go to the headquarters or they have to go to the courts. So many times people are not able to do that. So one idea that the government thought is that we will bring the justice at the doorsteps of the people. How? We'll provide for what is called as mobile courts. That the judges can move to the villages, to the intermediate panchayats, to the village panchayats, through some vehicle or something, and we'll go and we'll deliver the justice there itself. That's the idea of what is called as the Gram Nyayalaya. It follows a regular court mechanism. It follows all the laws of our country. But instead of people going to the courts, the court will come towards the people. And mobile courts. That's what is mobile courts. That is basically the Gram Nyayalayas. Now, there are few differences in the Gram Nyayalayas. I'll just explain them. The Gram Nyayalayas can try criminal cases where the alleged offences attracts a maximum punishment of 3 years. So they can attract only the petty cases where the punishment is not more than 2 years. Okay, it is not 3 years. So only petty cases can be taken up. So this is wrong. Gram Nyayalaya are strictly bound by the rules of the Evidence Act. So there is something which is called as Indian Evidence Act. Rules of evidence provided under the Indian Evidence Act. See, the very idea of mobile courts is to deliver the justice easily. If you are so rigid, then it is extremely difficult to pass a judgment. So there is an exception which is given under the Gram Nyayalaya Act. If the judges want, they can follow it. If they don't want, they can bypass this also. So when you say that the Gram Nyayalayas are strictly bound, then is it true or false? False. It is not strictly bound. Okay, because to make the system little easier. Okay, so this is not true. So what is the answer here? Which of the statements given above are correct? Answer is option D. So Gram Nyayala means you have to understand it is a mobile court. But there is something which is called as Lok Adalat. What is Lok Adalat? Okay, so what is the basic difference between Lok Adalat and Gram Nyayalaya? Very good. So Gram Nyayala is a normal court system, only that the court is coming to your place. But Lok Adalat is an out of court settlement. You are not following the court mechanism. It is an alternative dispute resolution mechanism. So here, there is no court system there. It is an alternative system. It's an out of court settlement. Lok Adalat. Okay. It is called as people's court. So don't confuse between Gram Nyayala and Lok Adalat. Both the topics are very, very important. So whatever topics I am suggesting, definitely you can expect question from those areas. So try to work on those areas. Gram Nyayalaya? It is at the intermediate panchayat level usually. So it is at the intermediate level and the local level. So it is at the lowest level. That's the court will come to the village itself and they'll deliver the justice. No, in Gram Nyayalaya there has to be a judge. I do not know what practically it is happening there. In addition to that, there can be other members, but it cannot be presided by someone who is not appointed by the state government as a judge. The judge will be appointed by the state government. I think he is given the same designation as that of a district judge. Okay, so come to question number 98. Which of the following functions are provided by the panchayats under the 11th schedule? This is a very factual question. So how many items are there in the 11th schedule? How many functional items? Think about it. How many functional items? 28 or 27? 18 functional items. So can someone tell me how many functional items are there in the 11th schedule and also how many functional items are there in the 12th schedule? 29? Very good. So 29 functional items. Here it is how many functional items? 18 functional items. So you don't have to memorize this, but just try to have a glance before you go to the examination once. These are all very miscellaneous questions. Just to put you in some kind of difficulty, this question has been added, but I don't see such a question may be asked. But here, what are all related to the rural areas? Agriculture, agriculture extension, implementation of land reforms, fisheries, small scale industries, technical training and vocational education. So the answer is 1, 2, 3, 4 and 5. So just have an idea what may be related to rural area and to the urban area. Come to the last question for today's discussion. Question number, we have 2 more questions. Okay, so this is 99. Okay, come to question number 99. Consider the following statements with regard to the Family Codes Act 1984. So the family codes are mainly to look into the matrimonial disputes. Today matrimonial disputes are lot of disputes and they get stuck up in the regular courts. So to look specifically into the matrimonial disputes, this family codes was established under the Family Codes Act. And in order to provide the administration of justice easily, in order to provide divorce maintenance easily, so this was brought in. It provides for establishment of family courts by the state government in consultation with the high courts. This is definitely true. Who will look into this? It is the state government which will look into that. So wherever if you talk about the subordinate courts, who has the right to do that? It is the state government, not the central government. Okay. No appeal lies against no appeal shall lie to any of the court against award given by the family court. It's like a normal court system. If the family court, which is likely to be district court, you can go to the high court, then you can go to the Supreme Court. When you say no appeal lies against it, that is wrong. So this can be true for ADR, alternative dispute resolution mechanism. In Lok Adalats, against the order of Lok Adalats, there can be no appeal that can lie against that in the court system because it's an outer court settlement. So there is no appeal against it. But this is a court settlement. So this is appeal is definitely possible. So what is the answer here? The answer is option. Statement is correct. That is A only. Okay, just come to the last question for the day. No, you cannot appeal. You cannot appeal, but if you want to start a fresh litigation, you can start from fresh. There are judges, but not someone who is a professionally qualified judge in case of Lok Adalat. Because there they don't have to follow the laws and all those things. There the judgment is mainly based on compromise between the parties. Both the parties are willing to compromise, an order can be passed. Huh? District magistrate is not someone who is qualified. In Lok Adalat, normally local activists, those people may perform the duties of a judge. If they want, they can be appointed, but it is not mandatory, as in the other court system. Okay. So come to the last statement, which is a very important question, I would say, very, very important area, which was asked in UPSC also earlier. Constitutional government means what? So constitutional government means a government which is carrying out its duties, responsibilities as it is enshrined in the constitution. So in the Constitution of India, let us assume, is the powers of the government restricted? How the powers of the government is restricted? By providing fundamental rights, by providing judiciary. So any constitutional government, one of the idea of having the constitution is that so that you can prevent the government from becoming arbitrary. And how do you prevent? You put restrictions to the government and the other organs in the constitution itself. So with that idea, just see what is a constitutional government? A government which is limited by the terms of the constitution. That's basically, and this is also called as constitutionalism. Do not get misunderstand. Do not confuse yourself. If the question is what is constitutionalism? A constitutionalism is something which leads to a constitutional government. Okay. So both constitutional government and constitutionalism both are one and the same. So the answer is what? Answer is option D. D is the right answer. Is it clear to all of you? So with that we have come to the discussion of our polity paper number 2. So I would say that you keep up your momentum. So next test is what? Geography. We have some time. So geography is a technical subject. Try to prepare it well. And all the very best. God bless. Thank you. We'll again meet during the next discussion. Okay. So thank you very much. Next test probably it will be taken by Rajendra sir. So if you have any doubts, you can ask him during the discussion. Okay. So thank you very much. All the very best.